Good morning, the staff of Parliament. And good morning to members of the media. And a very good morning to our guests. Good morning, Honorable Ntuli. Good morning, Honorable Sokanyile. Good morning, Honorable Skosana.
Good morning, Chair, and compliments of the new season.
Good morning, Honorable Shongwe.
Good morning, Chair, nabasebenzi basekhaya bonke.
Good morning, Bangazita.
Goeiemorgen, voorzitter.
Goeiemorgen, meneer. Good morning, Honorable Sols.
Good morning, Chair, and compliments of the new season.
Thank you so much. Good morning, Honorable Breitenbach. Good morning, Honorable Kola Barnard.
Good morning, Chair. Compliments of the season.
Good morning, Honorable Cameron.
Good morning, Chair.
Good morning, Honorable Klopa.
Good morning, Chair. Compliments for the new year.
Advocate Arense, good morning to you.
Good morning, Honorable Chair, Honorable members, members of the media, members of the public. Good morning.
Advocate Mkhwaiz, good morning to you. Do you have a microphone here? When I say good morning to you, I want you to greet South Africans. When I'm sitting here, I'm representing the Republic, so it's not me saying good morning to you, it's the Republic saying good morning to you.
Okay, my apologies, Chair. Good morning, Chair. Good morning, South Africa and honorable members.
Thank you so much. Advocate Mkhize.
Good morning, Chair. Good morning, honorable members and South African.
Thank you so much. Who is representing the staff of Parliament here, or who is leading the delegation from the staff of Parliament? Good morning, Nicolette van Zyl. Greetings to you.
Good morning, Chair. Good morning to all
And
members.
extend those greetings to all members of your staff.
Will do.
Mokhalaka, good morning and welcome. Good morning, Honorable Matthys.
Good morning, Chair. I know you missed me, so it's extra good morning to you.
Thank you so much. I'm greeting Honorable Tambo and Honorable Pambo. Good morning to you and welcome. Honorable Matthys, may you please introduce the honorable member sitting next to Honorable Pambo.
That's our national chairperson of the Economic Freedom Fighters and the EFF's chief whip in Parliament.
She is Honorable.
Honorable. How can I forget? Mam Nontando. I'm so used to calling her Mam Nontando that I'm even getting confused.
Honorable Nontando.
Chungu.
That is the surname. Honorable Nontando.
Good morning, Chair.
Good morning and welcome. It's a convention in the proceedings of this committee that when a member of the National Assembly or any House of Parliament joins us, we introduce them. So we accordingly introduce you that you, for this moment, have joined our proceedings. General Phahlane, good morning.
Good morning, Honorable Chair, and good morning to members.
Thank you so much. Is there anybody you want to introduce to us?
Chair, I'm with Advocate Setene, my counsel behind me. I also am with Advocate Johan Extian. Both are here to support me.
Thank you so much for the introductions. Honorable members, this is a new year, it's a 2026. And before I make any remarks, I'm going to give your parties, each one of them, 2 minutes to greet the people of South Africa. Can we start with the African National Congress?
Well, good morning, Chairperson. Good morning to all honorable members who are here, the Senior Counsel and the team, General Phahlane and his team, the staff of Parliament. Maybe, Chair, I should also take this opportunity to convey an apology on behalf of...
we will come to the apologies, Chief Whip.
Okay.
Just greet South Africa.
Okay. No, thanks. And good morning to all fellow South Africans and compliment for the new season. Thank you very much.
The MKP.
Ngikuthokoze mgcini sihlalo bahayithu bonke abantu abasithumela eParliament ekulu njengoba sila ku Ad Hoc Committee ngibalochisa bonke ephasini mazombe ngithi ingathi unyaka lo ungaba unyaka ozokwenza ukuthi unite kube mnandi eSouth Africa kulungiswe imthapho le esenze ukuthi sifike la sikhona ngithi namakhosi bafundise amakhosi ngithi bayede wonke umuntu okhona ngapha ngephasini siyabalochisa njengomkhonto wesizwe ngiyathokoza.
Thank you. The Democratic Alliance.
Morning, Chair. Good morning to the members. And good morning to everybody who holiday appears to be over and is now watching this committee. So Happy New Year to everyone.
Thank you so much, Honorable Breitenbach. The EFF.
Morning, Chair and colleagues, and General Phahlane and your colleagues. We send our revolutionary greetings to the people of South Africa and wish that all those who are unemployed get their jobs this year and it becomes a very successful new year, especially for the poor of the poorest. Thank you.
The IFP.
Well, thank you, Honorable Chairperson. Greetings to colleagues, the honorable members. Greetings to the Senior Counsel, Advocate RNC and his team. Greetings to the parliamentary staff, and also to General Phahlane and his team, and to fellow South Africans out there. And I do want to take this opportunity to also congratulate our matriculants for such an outstanding performance. I thank you.
The Patriotic Alliance.
Nqwenkia Ahuniki, South Africa. God has entered the ring. Thank you.
Thank you so much, honorable members. I afforded you that opportunity because I know that during the Christmas break, you met many South Africans who look up to you to represent them in this parliament, and some of them would have appreciated the work that you do. Others would have given you advices, and others would have raised their hopes with you, their expectations, and how they may want you to deal with matters that afflict their lives on a daily basis. I want to thank you so much for those messages of goodwill that you have given to the people of South Africa. We are going to move to apologies. We have received apologies from Honorable Sangoni and Honorable Ngola, as well as honorable vessels who are having family commitments. Today is the day of the reopening of schools in the Republic of South Africa, and parents who have children who will be registering or appearing for the first time at school today have to accompany them to their respective schools. And that is basically why those honorable members will be joining us later today or tomorrow. Honorable James has her flight delayed. She will join at the time she arrives. And Honorable Breitenbach has requested to be released at 18 hours this morning. And tomorrow as well, she has an appointment which may take her out of the proceedings. But she has promised that she can send someone to bring her photograph here. We will see as it comes. Honorable Breitenbach and Honorable Thopper as well has spoken about personal commitments tomorrow. Can I check further apologies, Honorable Skosana?
Thank you, Chair. Honorable Nomvalo will join us in the next few minutes.
Okay.
Thank you.
Do we still have further apologies? Okay. Honorable members, we have two witnesses this week. Today, we have a date with General Phahlane, and then tomorrow it will be Lieutenant General Khomotso until Friday around 2 o'clock or 15 hours. And then next week, Tuesday and Wednesday will be the appearance of Mr. McBride. And then Thursday and Friday will be Mr. Julius Mukwanas. The committee will meet on Monday to finalize all outstanding matters as we are working towards winding up towards the date of the 20th of February. General Phahlane has requested that because they had a hectic time preparing for the statement that has been made available to us of about 170 pages. The request is that we run until 20 or 21 hours tonight so that they can have time to rest. So this is a matter which committee members must think about as we proceed during the day. Committee members have any feedback that they want to give to the chair, you can always advise. In case by that time we are not finished, we can decide on Monday when do we reallocate him a day to come back to conclude the proceedings. But like I said, we are a committee, we are here, all of us, we can always advise each other as the day progresses. I think it's a fair request. Let's allow the proceedings to go ahead, and we will make that determination as the day progresses. Can I check Advocate Arensa? Do you want to formally introduce the witness?
Thank you, Honourable Chair, honourable members. Good morning, General Phahlane and your team, legal team. We have formally met each other also this morning, and we've been engaging with General Phahlane and his team over the past few weeks. and the affidavit that is now before the committee with the annexes is the result of that lengthy engagement. General Phahlane obviously wants to use this opportunity of clearing the air and raising a few issues on this platform, and it's his right to do so. So he is here today, and he's willing and prepared to give his evidence. So I formally request you to swear him in as a witness. Thank you.
Okay. Maybe before we swear him in, may you kindly introduce the advocate next to you formally to the people of South Africa.
Thank you, Chair, honourable members, members of the media, and members of the public watching. On my left is Advocate Bongiwe Mkhize. She is a member of the Johannesburg Bar. She was appointed in early December to assist us in place of Advocate Lerato Sikalala, who has been with us up until the end of November, and due to prior commitments that she has during the course of this year, starting early this year, she was unable to continue. It's a big loss to the team. But in the short time that we've had with Advocate Mkhize, she's a more than able replacement. So I've already introduced her online to the Honourable Committee, and she's here in person today, so we welcome her on board. Thank you.
Advocate Mkhize, we welcome you to this committee and these proceedings, and we want to wish you all the best in the responsibilities that have been allocated to you. And in the same breath, we want to thank you, all of you, Advocate Zikalala, Advocate Mokhaitz, and yourself for raising the flag in the name of the women of South Africa, that women are capable, women have abilities, and they can do everything to realize the aspirations of the people of South Africa. All the best to you. Thank you so much. I nearly said advocate, Honorable Malema.
No, thanks, Chair. And I'm sorry to come late on this point. When you dealt with apologies, you said people have taken their children to school, and an option we thought we didn't have. Because had you communicated something like that before, we would have done the same. We're sitting here painfully that we have not accompanied our children to school because we thought such an option was not available. But now I hear that it is
those
acceptable.
children who have today as their first day at school, and I know very well that you and I do not have children who have to start school today. They have been there, they are used to the environment.
No, you don't know that.
Yeah, no, it's not that it's an option, honorable members. They have made those requests that they accompany their children to school. General Phahlane, are you ready? Can we administer the oath?
I'm ready, Chair.
Thank you so much. Let me just read the following to you, which is a standard practice that we do with every witness that appear before this committee, that you have been invited to appear before this ad hoc committee to investigate the allegations by Lieutenant General Ntantla Mkhwanazi. You have been invited here to provide information in relation to the ad hoc committee's oversight work in investigating the aforesaid allegations. They include, amongst others, the alleged unlawful disbandment of the political killings task team, otherwise known as the PKTT or NPKTT. Number 2, the alleged moratorium on the filling of vacancies within the South African Police Services, the SAPS. Number 3, alleged corrupt relationship between senior leadership within the SAPS. And lastly, alleged political interference in the work of the SAPS. When this invitation was extended to you, you were accordingly informed that you may provide this information to the Ad Hoc Committee if you so wish, under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act. We want to take this opportunity to inform you that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. General Phahlane, however, you are protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or a Committee of Parliament with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. General Phahlane, you are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take the oath or the affirmation. Which one do you elect?
I take an oath, Chair.
If you take oath, then you will follow me as I dictate. You will say I and state your names in full.
I, Johannes Khomotso Phahlane,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much. I'm handing over to you, Advocate Arendse, to take us through the proceedings until 13 hours. During the proceedings, General Phahlane, if members of the committee want to clarify certain matters that you would have made in your statements, they are allowed, and I think it's something that you must be alive to. Thank you so much.
Thank you, Chair.
All the best.
Thank you. Good morning.
Good morning. General, a fairly lengthy affidavit has been made available by you to the committee. And there's a number of issues that has been raised by you. Perhaps we could just start. What is your current or present position?
I'm looking after my family. I'm at home. But before we go there, although the chair may have made reference to it, is it my understanding that the length of my affidavit and the issues to be raised is appreciated by the committee members, which will not necessarily make it possible for us to complete today. And I'm raising this because I surely don't want to be here and run through the issues for the sake of running through the issues. it was important for me to provide context in as far as the affidavit is concerned, and also considering the amount of time that we took in consultation and the sleepless nights, Chair, we spent in putting together this comprehensive affidavit. So I will appreciate it if we were not to run through the affidavit for the sake of running through the affidavit, but do justice to the issues that have been raised. I'm not here solely to respond to what Mr. Nkabinde had disclosed. Of course, what he said is the truth, but also there are a number of issues that General Mkhwanazi himself have spoken to that I will want to talk to, that are covered in my affidavit. And maybe, Chair, I'm raising this because just like General Mkhwanazi, we had thought we would be provided an opportunity by the former Chief Justice Zondo. We provided our affidavits because there were issues that were raised. I was given permission to come, but I was never given a date. So the Zondo Commission came and went without me having an opportunity to respond to the issues in the public domain, which issues remain relevant to the proceedings today. They also are relevant in the Madlanga Commission of Inquiry. And I also thought it would have been good if there was follow through to what the Chief Justice Zondo has said, because he did not make any findings on the security issues. There was a commitment or recommendation made that he's going to recommend to the President to have a commission or inquiry specifically focusing on the security cluster or the justice, crime prevention and security cluster, which let me speak for myself, I welcomed. I thought that opportunity is going to present itself. It never did. So I'm just simply, Chair, raising this to say there is no way that I will be comfortable in going through the affidavit, comprehensive as it is, with evidence in this day alone, because we are not going to do justice. That's my plea. I certainly don't have an issue with proceeding. And in answering your question, I'm at home. I was unlawfully dismissed. That matter is before the Labour Appeals Court. The Labour Appeals Court may pronounce this week or next week, and I don't want to go further into that. That's where it is. Let's allow the courts to pronounce.
Honourable Chair, I don't know if you wish to respond to some of the comments made by General Phahlane. I certainly, I'm not in a position to indicate to you now how soon we might get done. I think you're right that we would not want to rush through your considerable affidavit. It's apparent from the affidavit, and the honourable members of the committee would have read it for themselves, that you remain aggrieved at your dismissal and you wish to raise certain issues relating to that. However, as we've pointed out to you in our engagements and again this morning, that this is obviously not a forum that will be able to make those decisions. They have been, you've pointed out, been raised in other forums, and decisions have been made there. But to the extent that your evidence and what's in your affidavit are relevant to the terms of reference of this committee, we will have a full engagement. And if we are not concluding at the time indicated by the Honourable Chairperson, then we'll come back at another time.
Yeah. No, it's fine. I think it will be fair to give honourable members an opportunity to express themselves on the request for sufficient time by the witness. Can I take the parties, the ANC?
No, thanks, Chair. Chair, I earlier on when you said that we are going to deal with this matter late, we accepted your guidance, but we were a bit conflicted because usually when we start a proceeding like this, we have to prepare as parties, fully aware of the time at which our own engagement will begin with the witness. And so it's going to be difficult to proceed without that plan well known ahead of time. So in essence, I want to propose that we agree with the request from the witness that we should grant him a second day, and therefore by so doing it allows us to be predictable today that the engagement is largely going to be led by the senior counsel and his team. As and when the situation requires, we will make our own interventions. But we plan in a way that allows us to know that for today, except interventions, the greater part of the interactions are going to just between the witness and the legal team. I think it will be helpful to plan it in that way. Where I think we may have to decide later, as you said, is which other day can we secure for the witness to come back. But that we agree in principle that it should be today and another day yet to be determined. I want to propose that we consider that approach. Thank you.
The MKP.
Thank you, Chair. I don't think it's a problem, Chair. I think it's understandable. When you read this submission from General Phahlane, it's a very long one. And indeed, it will be totally impossible for us to finish the day today. And I guess the issue now is about the date. You know, when we agreed that when we have to finish, whether it's I think we've got a shocker block calendar for next witnesses. But indeed, with your wisdom, I guess that we will be able to have a date, you know, soon for this submission to be completed. Thank you, Chair.
Okay. The DA.
Thank you, Chair. Must be because it's the beginning of the year. I agree with Mr. Ntuli. Let us deal with the matter in that fashion. And we need an extra day in any event, so it makes little difference. I noticed, Chair, that we're not sitting on Mondays, and I know that Mondays are a constituency day. But given the severe time constraints of this committee, perhaps we should consider sitting on Mondays. Thank you.
The EFF.
No, thanks, Chairperson. I really don't know what we're doing and where the consents of the witness come from, because in this committee, we've never rushed through any affidavit. And there must never be such a suggestion that we rush through affidavits. And in this committee, there's never been a witness which left here unsatisfied that my issues were not sufficiently canvassed. And therefore, where that consent comes from, I don't know. When you told us that was going to finish at 9, the chief whip of the ANC and everybody else knew what you were saying. When you said 9, we knew you were talking 1 o'clock or 2 o'clock, because that's what you say. Or we are going to finish at 9. At 9, we start renegotiating again to finish at 11, and we finish at 1. That's how effective we are. We are very serious about these matters. So we can't, right at the beginning, say, it looks like we're going to have a problem. 168 pages, does not necessitate anything. It can be 168 pages with few issues that can be sufficiently canvassed, and by 9 o'clock we're done. But this committee at all times, when it is not satisfied itself, it will stretch itself and come to a conclusion that we need another day. But we can't start by saying we need another day, and the reason is is 168 pages. That cannot be a criteria. This issue which I'm picking up is that the concerns are, I can't just come to rush through the thing, and I'm saying we've never done that. We're going to give this matter the attention it deserves, and by the time General leaves here, you'll be satisfied like the rest of others who came before us here and they left satisfied. Thanks.
Bangazit.
Well, thank you, Honorable Chairperson. I'm inclined to actually support the proposal made by Honorable Nduli in respect of how the proceedings should actually be, taking into account the concerns and the volume of work it would appear that this committee would need to look at. But also there is merit in actually what Honorable Malema is actually saying, that we should not actually put hurdles on our way before we even embark on a journey. We haven't actually started interrogating the issues here. Maybe by 9 o'clock, we would be satisfied that we have done justice to the witness statement, and thereby not necessitating any further extension of time. Well, let's see what happens by 9 o'clock. Thank you.
Honorable Sols.
I support the proposal, Chair.
Okay. General, the committee is saying to you, or you must not be worried that there is any matter that is in your statement that will not be given due consideration. But then, secondly, let's run the proceedings. And at the appropriate time, a determination will be made. If we have exhaustively dealt with everything today, it's okay. And if the committee feels that there is a need for an extension, it will arrive at that decision. So, yeah, all the best.
Thank you, Chair.
Thank you, Honourable Chair, Honourable Members. General Phahlane, perhaps we can, however, get through some of the formalities a bit quicker. And here I'm referring to your academic credentials and your career in the South African Police Services. And if you could just confirm, you matriculated in December 1984. You entered the police as a constable on the 8th of November 1985. In 1982, you obtained a National Diploma, Police Administration. You also obtained a Bachelor of Arts Honours in Public Administration in 2014. And in 1999, you obtained a certificate in Management Services and an advanced certificate in Management Consultancy. Can you confirm that?
I can confirm, Chair.
Thank you. So that's quite an impressive background, and it's of little surprise, no surprise that you ended up in the most senior position in the police services, albeit in an acting capacity. because it also appears from your career in SAPS, which, as indicated, commenced on the 8th of November 1985, that you served over many years in various capacities and in various components that make up the South African police services. You spend time in crime intelligence. You spend time in the detective service, in crime prevention, in visible policing, in human resources, in organized development, in strategic management. You were appointed, you also spent time in communications, and then you also spent time in the senior management services, holding the rank of Lieutenant General, again, which points to you being eminently qualified to hold a senior position in the police. You were appointed on the 1st of September 2007 to the rank of Divisional Commissioner responsible for personnel services. From there, you also held a position as the head of forensic in the forensic division, and until your appointment as the acting National Commissioner of Police.
It's correct. It will be evident from that I'm not a fly-by-night cop. Many years serving the South African public as an officer in various capacities. I became a senior manager, as the records will show, in 2001. And I'm occupying the rank of Lieutenant General since 2007. That's when I was appointed to that level. So I did not ascend to that level only when I became appointed as an acting National Commissioner. It was a, by the way, I was a temporary worker then as an acting National Commissioner.
Yeah.
Okay.
And it was on the 14th of October 2015.
Let's see.
Sorry, Chair.
No, Chair, I was trying to raise my hand earlier and you couldn't recognize me. I just wanted to ask a quick question, if you don't mind, that the General mentions the high school he went to, mentions the college where he went to, and then he mentions further studies. But in the further studies, you don't mention the institutions where you obtained those further studies.
All right. I may respond. My bachelor's degrees are from the University of Pretoria, both my BA in Public Administration as well as my honors degree. I acquired them through the University of Pretoria. My national diploma in policing, it used to be offered by the institution it was called Technicon SA, which when the institutions were amalgamated, became part of UNISA. But that was the institution that offered the qualification. And in terms of the management services and management consultancy courses, which is more system management and organizational development and so on, that's offered by Tshwane University of Technology. When I was there, it was still called TUT. Yeah, I suspect I covered them all. Thank you, Chair.
Okay. You can proceed, Advocate Arendse.
Thank you, Honourable Chair. Yes, just in relation to that question by Honourable Malema, we did ask General for your curriculum vitae, and you said you need to just update it and you'll make it available to us. We've got a copy here, but we make a copy available to the committee members in due course.
Yeah, you must tell the committee, Honorable Chair, that I grudgingly gave you that CV of mine because I'm not a job seeker. I'm not an applicant.
You're not looking for a job here?
No.
Okay, thank you. On the 14th of October 2015, you were appointed as the acting National Commissioner in place of the suspended then National Commissioner General Ria Piecha. And then at that point, did you engage with the minister or the president in relation to your appointment?
In actual fact, it's interesting. I was in this committee when I was appointed, in this room. We were making presentation to the Portfolio Committee of Police. General Pierre was sitting somewhere here.
Yeah.
When the announcement was made, Francois Bietman, the former chairperson of the Portfolio Committee, was up there. And an announcement was made that General Pierre is being suspended. For few minutes, General Sithole, who was the Deputy National Commissioner, was appointed by the chairperson to be acting. Not long after that, an announcement was made when I was sitting here that the president, then President Jacob Zuma, appointed me as an acting National Commissioner of the South African Police Service. That was the 14th of October 2015. Appointments at that level are not made by the minister. They are made by the president. He appoints and he disappoints, if English says so.
So you were appointed then by then President Zuma. And on the 1st of June 2017, almost 2 years or so later, you were asked to step down or step aside by the then Minister of Police, Mr. Mbalula.
Correct.
Can you just tell us about the circumstances that led to that situation?
Correct. You will know that I was a guinea pig of the step-aside policy because it was first applied on me for whatever reasons. On that day, I was in Pretoria. I get a call from the office of the minister. I can't remember who specific in the minister's office. And I was asked to travel to Cape Town for a meeting with the minister. I had no reason not to respond to such, made travel arrangements, got here to Cape Town, waited for more than 3 hours for the minister to come. He came. We had our less than 5 minutes meeting. He was there with his deputy. I think the deputy then was Mr. Bongani Mkongi, if I'm not wrong. Yeah, Bongani. So at that time, the media was dominating with Phahlane and IPID and Robert McBride and O'Sullivan. And then the minister simply asked, General, in view of all this negativity in the media, is it not better that you maybe step aside? I agreed because I'm not glued to any position. And I accepted the role of an acting national commissioner from the president, knowing that as a member of the South African Police Service, you can be deployed anywhere at any given time, as long as it's to serve the people of the Republic. I only asked 2 questions to the minister. Who do I hand over to? And he said, no worries, don't worry about that. And I say, since you say step aside, what does it mean? Say, no, you go home. Shook the minister's hand, thank you very much. I left. On my way out, I met Mr. Bo Mbindwani, who was, I think, a political advisor to the minister. I was coming from the 9th floor in the building, on ground level. As I was stepping out of the lift, Mr. Bo Mbindwani was entering, leading Lieutenant General Mutiwa, a colleague of mine. I left for the airport, waiting for my flight, and it is there, when I was sitting there, that I was following the minister, making an announcement to the effect that I am removed. I was asked to provide reasons within 48 hours why I should not be suspended, and that he is now, or Lieutenant General Mutiwa, who is incorruptible, is now the new acting national commissioner. I was at the airport. Now, I'm giving you all that to say I was not removed by the President of the Republic of South Africa as the Constitution and the Police Act dictates. I was made to step aside by the Minister of Police then. No law provides for such. That's why I continue to say that my removal from office cannot be found anywhere in the prescripts. Later, I think it was on the 7th of June, I then got a call from a colleague of mine, Lieutenant General Skete, who was saying, hey, General, I'm being asked to deliver documents to you. And I said, what is it? I mean, I've worked with General Skete for years. And he said, I've got these documents. It's a notice of suspension. And I said, General, you don't have to go through the trouble of traveling to my office. You can just ask one of the officers in my office. In actual fact, I sent my driver who went to him to fetch the documents and bring them. When I received the documents, the first thing I did, I called General Mutiwa. And I asked him, General, are you trying to sort out the mess that the minister has created? And he was very apologetic. He said, General, I'm very sorry. It is true. It's a mess because you never suspend someone verbally without documents. And if I were to be suspended or removed from office, it was to be by the president who in the first place appointed me. To date, I don't have a letter signed by the president which is saying you are being removed as an acting national commissioner. Following the first, I think it was the second or the third, there was a media, there was, I can't remember the president's spokesperson, it's Dr. I just forgot the surname. He issued a statement and said, the president thanked me for my services. That's in short what I can say about that removal. Unlawful, irrational, but it doesn't belong here, it belongs in the courts. That's why I'm ventilating that matter in the courts and the public protector of South Africa.
But at the time, you didn't firstly protest your innocence in relation to the allegations then in the media and in the public domain. You didn't take issue with that when it was raised with you by then Minister Mbalula. You also never took issue with the minister that, according to you, he was not competent to relieve you of your duties as the then acting National Commissioner, and also you never took issue with the suspension. Is that right?
You are incorrect.
At the time, it's not apparent from your affidavit that you took issue. I'm not sure whether you raised it subsequently. I think you said in a complaint with the public protector.
Because I'm not looking for political intervention or political interference, I don't have to raise issues that are raised in the courts. And I'm not supposed, I don't have to repeat what is being raised with the public protector of South Africa as in ventilating those issues. And I don't see any of such in the documents that the bundle that you have given me here, because it is comprehensive. There was no reason for me to argue with the minister. There is no reason for me to protest. When we serve, I always hear ministers and deputy ministers say, we serve at the behest of the president. The National Commissioner is serving at the behest of the president, not of the minister. So why do I have to contest what need not be contested with the minister? It's not in my nature to protest. I'm not I was never in that mode. I don't protest. I walked away because I don't want any conflict. And I just said, I am not glued to any chair. That is why when I was removed by the National Commissioner, being the Divisional Commissioner, personnel, responsible for personnel, and he moved me to forensic services, I accepted because he was not moving me into prison. He was moving me to go and perform a policing function that I performed very well. It falls within those objects of policing.
Now, subsequently, you were charged and you were required to appear before a disciplinary committee, and initially you did appear on 2 occasions before Advocate Matau, SC.
It's correct. I appeared on more than 2 occasions. Yeah. And when I appeared before Advocate Terry, there were 11 concocted charges. If you want to have a look at those charges, I'll give them to you and the honorable members at some point. But those charges were disappearing day by day because the charges, the people who were supposed to be charged were actually those who were charging me. at that level, when I was in forensic services, I was not responsible for appointing people as senior managers. So now, if you charge me and say, you have appointed so-and-so, go and charge the appointing authority who happened to be the national commissioner then. So those charges were slowly falling away until there were only three charges left. And we were calling for reconvening. My counsel here was representing me. We were calling for the reconvening of that session. It never happened. As we were calling, come the 6th of July 2020, a certain Lieutenant General Reed gets sent by Sithole to me to serve me on new charges completely different from what was there. And concocted by him, Sithole, and everyone. I actually saw in this file, but let me not go there. I'm not the evidence leader. After they concocted those charges, they initiated what was referred to as an expeditious process. Those three charges, which were left from the 11, I never had an opportunity to respond to. Frivolous, just like the charge with regard to the expeditious process.
So, just to recap, the disciplinary procedure that was invoked the first time, that was in terms of Regulation 9.
No.
Regulation 8.
Regulation 8.
Regulation 8, that was the one where you appeared before Advocate Matau, SC. You say there were initially 11 charges, which were then reduced to 3. But in any event, you were never asked to plead to those charges. So those, even though you appeared there on a few occasions, that hearing, in fact, never got off the ground. It never commenced.
No.
Subsequently, the disciplinary action was then changed to Regulation 9, what is called an expeditious hearing in relation to senior management officers of the police.
No. May I allow, Chair, sorry, I'm allowed to correct you.
You must please comment if
Yes.
I don't have it right
No,
or have it wrong, then you must
No.
please
Yeah.
correct me. You then, that resulted in your appearance before Brigadier Riet.
Lieutenant General Reed.
Lieutenant General Riet.
Yeah.
Yes. That is called an expeditious, what's it, expeditious hearing?
Expeditious process, Regulation 9, yeah.
And that's before him as a single officer, disciplinary officer. Those proceedings are also set out. Can I refer you to the exhibit bundle, item 1, and item 2 is a record of that process. That is the formal notice of this expeditious process. That right?
Which one?
The exhibit bundle.
Yes.
Not the big one.
Yeah, I'm on it.
That one, yeah.
Your own exhibit,
Yes,
not mine, okay?
Yes, our one.
Yes.
Yeah.
It's
Right at the beginning, item 1 is a notice of outcome of the expeditious process on the 24th of, yes, the first item. That's a notice of the hearing, and the outcome is at Annexure G, if you page a few pages down, and yeah.
Sorry, Chair, I'm losing you. What is few pages down?
The first item is called the
No,
notice
I
of,
can see 1 and 2, the record of proceedings,
yes,
and then,
yeah. So it's really just to reference the process that I was referring to, and you were
okay.
busy trying to correct me.
yeah,
So it's just a matter of process.
okay.
Yeah. So that process took place not in front of Matau, but in front of Lieutenant General Reed. And that was a process that was different to the initial disciplinary process for which you were asked to appear.
Okay. Am I?
Yeah.
So, if I'm allowed, in responding but also correcting you, the expeditious process is not meant for senior managers. The expeditious process is a provision within the South African Police Service Discipline Regulations 2016. And I happen to be the accounting officer together with my former minister, Minister Natin Hleko, that signed those regulations into operation. And that expeditious process is currently being abused while people are spectators. The expeditious process is supposed to be used where, for example, there is direct evidence, something that you cannot contest. For example, we were sitting with an issue of members, somebody who is being arrested in the middle of a cash heist. This member was maybe either the driver of a getaway or he was part of the group. In that particular instance, all what is required is a factual report. When the expeditious process was put in place, it was in inverted commas to make provision for a summary dismissal, because there can never be any justification of a member of the South African Police Service involved in crime, whether it is rape or what. But in cases where there is evidence, there is witnesses where people must be called to either corroborate or deal with the issues, the expeditious process is a wrong process to follow. It is for that reason that I'm saying expeditious process was not meant for senior people. It is meant for all. Now, coming back to me, even the Terry Motau process, let me tell it that way, the one where he was appointed to chair, it was unlawful in my case because the discipline regulations do not apply to the national commissioner or the acting national commissioner. The acting national commissioner or the national commissioner is to be subjected to a process provided for in the Police Act and the Constitution in terms of holding a fitness board. So both processes were not to apply to me. I just said in the beginning, I was removed from office by the minister who was by law not allowed to do so. Now, the question is, when I left the 1st of June, where did I go? I never went to any police office. I've never seen a police office till today. I went to my house. So, if they wanted, they could have allowed me to go to my position as the Divisional Commissioner of Forensic Services and then take action in line with the discipline regulations, because they would have fully and squarely applied on me. Now, I'm to some extent disappointed because I've got a half-baked document here which you say it's evidence. If you look at this document, you'll see the first document. The first document is read as document. Then you have here what comes from Mohlala, which allegedly, according to the discipline regulations, is supposed to be an investigation report. No.
General Phahlane, we also do our own research and we make efforts to find relevant documents. These documents have been presented to you and are placed before the committee, not to argue with you, it's to place certain issues on the record. You've made your position clear. It's not apparent, though, from the proceedings before Lieutenant General Riet that you raised that as an objection, but be that as it may, can I move to the next item?
No, but Chair, you can't attribute something to me and move on. That has been ventilated.
Okay. So if you raised it before Van Riet, the proceedings are there before you. Can you point out where you specifically take issue with him and say you are not competent or you don't have jurisdiction to conduct this investigation or this hearing?
Chair.
Because I was going to try and speed up matters because subsequently you did approach the Labour Court and that judgment is also in the bundle. Unfortunately, Honourable Chair, Honourable Members, we didn't have time to index or there is an index, but we didn't have time to paginate the bundle. So if I may just ask for some indulgence as we page through this, but there's a judgment of Judge Van Niekerk, one of the senior judges in the Labour Court. General Phahlane, did you manage to get there? It's item 3. Item 3 is the judgment of Judge Van Niekerk.
Chair, if I am to go through this and respond to it in detail, I would have provided you with more information to this. So now we are confusing issues. Judge Van Niekerk's process came after the initiation of the charges. It is me who took the matter to court, and we were arguing a different issue there. We were not arguing the charges.
Yes, you had by now been dismissed.
No, there is no such.
Can we? I don't have time to argue with you. Can I just read from what the judge?
Let me just
Can we just read what the judge says?
Which page is it?
It's the third item. It's the Labour Court judgment of Judge Van Niekerk. It's in the exhibit bundle. Have you got it now, General?
I have it.
Yeah. So you'll see from page 2 of the judgment, this is what the judge says. This is an application in which the applicant, that you, seeks in terms of his amended notice of motion to interdict the second respondent, that's the National Commissioner then, from confirming or ratifying a decision taken by the third respondent, that's Lieutenant General Riet, to dismiss him and to declare unlawful and set aside disciplinary proceedings initiated against the applicant in terms of Regulation 9 of the SAP's disciplinary regulations. In the alternative, the applicant seeks an interim order pending the institution and finalization of an application to review. So this is where the judge summarizes your complaint, and which is what you indicated earlier. The applicant's complaint is that the first respondent, the SAPS, is using Regulation 9 to circumvent a disciplinary process already underway in terms of Regulation 8 before an independent chairperson, Advocate T. Matau SC. Then the judge goes on to say the regulations are in the Gazette, they're based on a collective agreement between SAPS and the trade unions, and then he records that Regulation 9 provides for an expeditious process, and as the title implies, it provides for certain cases of alleged misconduct to be determined by way of an expedited hearing. And then in paragraph 3, it deals with some background of how you appeared before Advocate Matau, and your allegation that the SAPS was now acting mala fide, because you can't defend yourself in an unbiased forum, as you put it. So after the argument, the judge dismisses your application and doesn't make a cost order. And at paragraph 10 on page 6 of the judgment, the judge says, in short, the pleadings do not disclose a cause of action over which this court has jurisdiction. So the point is, you were asked to stand down. I'm just summarizing. You were asked to step aside or stand down by then Minister Mbalula. You were issued with a notice of suspension. You were then issued with a notice of a disciplinary inquiry, initially before an independent third party, subsequently in terms of this expeditious process. There was an outcome. You sought to interdict the outcome of that process, and then that application was dismissed, and subsequently your dismissal was confirmed. And you contested all of that, but is that a fair summary of the facts?
Chair, while this is not the process where I want to ventilate this, I suspect your reading of the process is wrong, and it will be misleading. We have never challenged the merits of the matter before Van Niekerk. When we went before Van Niekerk, the intention, it was between the sanction and the confirmation. What we were challenging there was because if you look at the record somewhere, if you had obtained the comprehensive records, you would have seen that after Reid arrived at his sanction, which came as a shock, in a finding, not a sanction, we initiated this process because the regulations provide for mitigation and aggravating circumstances. You will not find any mitigating circumstances coming from me because we were challenging that particular process. While we were still waiting for a court day, as usual, they moved on and came up with a sanction. Following that, we accepted that I'm not going to contest this because the correct platform is to go to the bargaining council, which we did. So the Haramse judgment has got nothing to do with the merits. Van Niekerk judgment has got nothing to do with the merits of the matter.
But General Phahlane, be fair to me. So I just read to you a few minutes ago on page 6, paragraph 10. This is what the application was about. He says, the pleadings do not disclose a cause of action over which this court has jurisdiction. It was a technical issue. I accept what you're saying, that it didn't deal with the merits of your matter. I accept that.
You said it's page?
It's on page 6, paragraph 10.
Oh, sorry, I'm looking at the wrong document.
And he expands on it in paragraph 12, where he says in the second sentence on page 7, the applicant appears to indicate that he intends to invoke this court's review jurisdiction in terms of section 158(1)H, that's of the Labour Relations Act, which entitles an applicant to review any decision taken or act performed by the state in its capacity as employer on any grounds permissible in law. So that's his discussion. And then he goes on to say that he doubts whether you have established a prima facie right for the purposes of any interim relief. So it's a very technical judgment. You were the applicant, presumably on legal advice. And from the appearances, you were represented by senior counsel and a junior. And it was to interdict the outcome of the writ process, isn't it? And that interdict was refused. So the writ process, and that's what I want to move on to. I'm not debating with you the merits of your case or the merits of the charges on which he found you guilty. Because we can't resolve it in this forum.
And I don't want it to be resolved here because I'm not looking for political interference. And I'm not going to get stuck in dealing with the judgment, which I'm trying to explain to you. You only go and read what you want to carry across. And I'm trying to explain to you the context. And we have moved on from this judgment. We have accepted that this judgment did not favor us in as far as interdicting the process is concerned. And this judgment had nothing to do with the merits. In reviewing, we went to the correct platform, which is the bargaining council. And it is there where the merits were ventilated, and we talked to it in here, where still the outcome was not in my favor. I then went on to the labor court. Again, it was not in my favor. I am on the doorstep of the labor appeals court. We are awaiting judgment on that one. So I don't want to spend time talking about the Van Niekerk judgment, which was I never challenged it anyway, because I accepted that there is a need to move to the right platform, which is the bargaining council, where the merits and the process were to be dealt with. There are no merits in this particular case.
General Phahlane, at the outset, everybody, all the honourable members, all of us accepted that we will not speed through your affidavit because you're entitled to fully vent whatever views you have. In your affidavit, a considerable affidavit, you spend 9 pages on challenging what you regard as the unlawfulness of your dismissal. So, and we had these engagements over the December holidays with you and your council. We discussed the issue of relevance to the terms of reference of this committee. So now you tell me, no, you can't go there and read from what Judge Van Niekerk had to say in this application. That is what I'm doing. If you want to speed through it, then I'm quite happy to agree with you. One, that the Van Niekerk judgment didn't deal with the merits. The first time the merits of the charges against you are dealt with is in this arbitration award, which is the next item, which I want to come to. In that arbitration, the arbitrator upheld your dismissal. You weren't happy with that. You took that on review. It went to the Labour Court. The Labour Court dismissed your application for a review. You asked for leave to appeal. Your leave to appeal was refused. You then petitioned the Labour Appeal Court. that petition was upheld and your matter was heard by the Labour Appeal Court. I think it was on the 16th of December last year. And that outcome is still pending.
It's not correct. 16th of September, 2025.
So is that a fair summary of where we are?
No, 16th of September.
16th of, what did I say?
December. I was busy with an affidavit on the 16th of December.
September, sorry. 16th of September.
Chair, all I'm saying, and I must be understood, there is nothing wrong to make reference to that, and it is in here. But I've got the problem if you are making reference to that out of context, creating the impression that Van Niekerk dismissed my application, and somewhere you mentioned the correct, on technicality, not on merits. And I did not have time to contest Van Niekerk's judgment because it was just not going to take me anywhere. The correct platform was the bargaining council where I went to. And I ventilated the issues there. Whether I agree with the outcome or not, it's a different matter. The matter was ventilated at the bargaining council. Outcome came not in my favor, and I'm saying so in my affidavit, that once that came, follow the process. Go to the labor court. Outcome came not in my favor. The same acting judge refused us leave to appeal. It is for that reason that we went to the labor, we petitioned the Labor Appeals Court. And the Labor Appeals Court hearing took place on the 16th of September. When I started, I said, the outcome is imminent. So I really don't have time, energy to waste on the issues that are correctly at the Labor Court. I was here correctly giving an update of where they are, because somewhere you hear somebody, he was fired for the blue lights. I want to know, where is that blue lights? He was suspended for the blue lights. Show it to me.
So, shall we move on from there, or do you have anything else to say about your dismissal? Can we accept that the issue of your dismissal, both procedurally and substantively, in other words, on the merits, has been before an independent, a bargaining council arbitrator? It's gone to the Labour Court, and it's gone to the Labour Appeal Court, and until such time as the Labour Appeal Court might rule differently, you have been dismissed by the SAPS in what the arbitrator and the courts thus far have agreed is a procedurally and substantively fair manner.
If that is pleasing you, let it be. And that's exactly why I'm putting it here. It's nothing to hide about. I don't find a reason why I should be arguing. If you were to go into the very same issue, I don't know why we jump so quick to it.
Because we are going to come to an important issue. Sorry, I see your counsel wants to.
Sorry, Chair. I was listening to some learned people here behind me. Yeah, I'm all yours.
Don't, yeah. All right. So the relevance though of so we put that behind us now, the issue of your dismissal. The Honourable Committee is aware of the fact that you're unhappy about your dismissal, you've challenged it, but as things stand, as we sit here today, your dismissal, both procedurally and substantively, has been upheld by the courts, and yes, you've challenged it, but to the extent that you now argue or contend in your affidavit that you've been what you call unlawfully dismissed, that has been dismissed by the courts. Can you at least accept that?
What must I accept?
That your complaints and your case against your dismissal has been dismissed in arbitration and by the courts up to now.
The question, and I know I'm here to answer questions, the question is, why do you put that to me while it is part of my affidavit? And that's exactly what I'm saying. I've outlined a process which allows you and the honorable members to have background to that. And I emphasize, I am not here for that. This is a matter ventilated elsewhere. This is a matter that belongs elsewhere. This was by way of background. Where am I? What is happening? Somewhere you started by asking me, where are you working? And I'm saying, I'm working in my garden. I'm at home. Now I'm giving you background. Why am I in my garden? Because I was unlawfully dealt with, and the matter is at the Labour Appeals Court. Let's make peace with that. That's where it is, and go into the issues that need to be dealt with. Part of what I'm saying there, I'm also showing you, giving you even why why I'm even going to an extent of talking the unlawfulness and people in authority who disobeys the laws. I'm giving even annexures. I gave you documents to that effect. But for the sake of progress, I've never came here to say I'm still employed. No, I'm in the Labour Appeals Court. We're waiting for a judgment. So we can move on.
Thank you. Now, one of the big issues that came up in the expeditious hearing and subsequently in the arbitration was the tender relating to the 360 by 180 degree cameras.
Where in my affidavit are you, Council?
Don't you deal with the Itemba tender? You deal with it in your affidavit.
Yeah,
it's
but
very much at the heart
really
of your complaint.
Chair, for me not to be lost, because now one moment we are moving away from the dismissal and so on. Now you go back, because that's part of the reason why this matter is before the Labour Appeals Court. I thought that we have agreed. If we have to deal with the tender,
General Phahlane, let's do like this. The statement that the witness has deposited with us is numbered in paragraphs, isn't it?
Page 18.
Yeah. I think that is the approach that we must take. If we are on page 18, let's go to that page in the specific paragraph.
Yeah, it's item capital letter E on page 18. General Phahlane deals with the procurement contract bid 19/1/9/1/187, that the supply and delivery of the 360 by 180 panoramic image capturing system.
Did you get that page, General?
I'm there, Honorable Chair.
Thank you. Let's proceed.
And General Phahlane, you and I had agreed that the court process, arbitration processes, that's now where they are, and it's subject to the Labour Appeal Court now also sitting and considering your application to appeal. But in relation to the merits of the case, that's where I'm moving towards now. The merits of the case, the matter is dealt with fully, not perhaps to your satisfaction, but dealt with fully in the arbitration award, which deals with, amongst other, this particular tender. Do you want me to take you to the relevant passages, or do you accept that this Itemba FDA issue was dealt with in the arbitration award?
No, Honorable Chair, I'm not going to accept that approach. I'm not going to accept to be taken through an arbitration document while I'm contextualizing that issue. Here in my affidavit, it's E, paragraph E, and we are from 44 going forward. So we can deal with what I am saying in relation to that. If you want to go and refer to some aspects of the arbitration, because we are saying it here, I'm not going to repeat the arbitration, which we have extensive legal documents before the courts on it, and I'm saying I'm waiting for the outcome thereof. So, to be fair, Chair, I must be spoken to on my affidavit. The issue that the council is trying to talk to is traversed from page 44 of my affidavit, and it goes on. Sorry, paragraph E, paragraph 44. I talk to it not selectively.
Can we understand this? Advocate Arons and General Phahlane. General Phahlane,
Chair,
you say that the matters on which you are being questioned are still before the court.
Yeah.
So you are essentially saying to us that the what do you call it, the award of the arbitration award has been appealed.
Yes.
And that the judgment of the Labour Court as well,
yes,
has been appealed. And now we are awaiting the judgment of the Labour Appeals Court.
Yes.
And you argue that it may be unfair to ask you questions on matters that are still lis pendens. That we must wait for the judgment of the Appeals Court.
No, am I allowed, Chair? No, that's not what I'm saying. Because I have spoken to the issue myself in the affidavit. It is here, paragraph E, from page 44 until page 81. What I've got an issue with is that now I must go through the arbitration award, which I did not even bring here. It is council and them who went to go and fetch it from wherever they fetched it. So because it's something that I've dealt with extensively, challenging that arbitration award, challenging the Labour Court review award or judgment, and the same matter is now where it's pending before the Labour Appeals Court. So all what I'm saying is that don't go and take the pieces of the applications that we are lying there. I have spoken in detail. Now the council was talking about the procurement contract of the what is it? The 360. Here it is. So why must I go and look at a document which, the reason why I'm challenging it is because I don't agree with what the arbitrator wrote there. Now, I must now go and argue with counsel on something as if I'm before the very same arbitrator. I'm saying, let's talk to it. But here is my affidavit. It's talking to the issue.
You say that those matters are on appeal.
Yes.
Yes, that is the point that we wanted to get. That
Yeah.
those matters are on appeal. So we may ask you questions from a wrong premise or from wrong assumptions, because we don't know what the decision of the appeals court may be. If the appeals court comes and upholds your application, we might have made wrong conclusions.
Yeah.
Okay.
So, General Phahlane, I was referencing the arbitration award, and I would also reference the Labour Court judgment, only for the purposes that the issue that you raise on page 18 under item E relating to the panoramic system, that issue was dealt with in the arbitration. Witnesses were called. You were entitled to cross-examine those witnesses. You yourself led evidence. You then took that award on review to the Labour Court. The Labour Court also applied its mind to those issues. That is all that I'm trying to establish in response to your narrative, which appears from page 18 on the procurement, on that very same procurement contract, and which runs for a number of pages in your affidavit through to page 32, paragraph 81. That's all that I tried to do. I didn't try to argue with you. I didn't try, and I'm certainly not trying to persuade this honorable committee that you are wrong and that the arbitrator and the Labour Court was right. All I'm trying to say, General Phahlane, or trying to demonstrate rather, is that these issues have been ventilated in what all of us regard or hope to regard as independent forums, legal forums, where you have already given your side of the story, your version. So, having said that, this is your affidavit. We've agreed you're not going to be rushed. What is it now under this item E that you want to elaborate upon or to convey to the honorable committee?
You see, Chair, I refuse to accept what counsel is saying. And I refuse because that's exactly the kind of narrative that has been peddled in the public domain. And I can't, in a paragraph, try and sum up the injustice that I have suffered and the narrative that has been there. Even witnesses in this, before this committee, I was listening to them. They were talking to this 24 million irregularity. I recall, I think it's honorable, but I think it was coming from some members, where they were questioning the submission to the AG to say, can you clarify us on this? That has got a lot to do with this. Facts were misrepresented before the AG, and I cannot just go over this thing. And I took note of what Honorable Malema said earlier. Why the thinking that we are going to be rushing through. And Honorable Malema, unfortunately, this is what I'm being subjected to. Look at what I'm doing in terms of that procurement, because somebody went to pay 24 million plus interest to a service provider who did not even deliver a single camera to the police. That happens in 2018, 2019, while I'm sitting at home since 2017, the 1st of June. And that is being attributed to me. That is what I'm dismissed for. To say you have allowed a service provider to take 24 million plus interest, which became 31 million, that decision gets taken in 2018, 2019. I'm giving you here even proof of who signed for that thing. And now I must, in a paragraph, sit here and say, Honorable Chair, I agree with the narrative. I'm not going to agree with it. And if we are to do justice, let's traverse this issue on paragraph E on the panoramic camera. It's not as small. The very same arbitrator that you are referring to misunderstood what is at play here. There was a contract signed. This contract was signed in 2014, 28th of July.
Yes, when you were the head of the forensics division.
Yes. So
That
let's
is
take
why it's
members
relevant.
into confidence in as far as what this happened and not just narrowly go to this narrative that has been hating to listen from people who are so uninformed.
I was trying to be of assistance because that's exactly what the arbitrator does.
No,
The
that
nar-
arbitrator
the narra-
misunderstood.
Sorry,
Wait. Can you take a breath, both of you? I want us to do the following. The General Phahlane has accepted here before the committee that there are unsuccessful bids that he made to overturn the arbitration award. And then the last is the judgment that is awaited from the appeals court. If the matters that you are leading now, Advocate Arendse, are matters that are before the court, sitting here ourselves may not make an assessment or a review of the proceedings in a court of law. And I will want us to move to matters that pertain to our terms of reference. Unless if in those matters there is something that the witness wants to bring before this committee. To say, in terms of the 4 pillars that you have read before me, Chairperson of the committee, that you are investigating, there are the following matters that I want to bring to your attention, and I think they will help the committee to move forward. But I'm reluctant that we should confine ourselves to matters that are now before the court or take much of our time dealing with matters that are judgments or the arbitration award contained in the arbitration award or judgment of the labor court. Because both of you agree that those matters now are on appeal. So I will give you an opportunity. If there is any matter that you think you want to bring to the attention of the committee, which is not a matter before the court as we speak now, let's deal with those matters and allow the committee to move forward. Honorable Nomval.
Yeah, no, thank you very much, Chair. Chair, it's a clarity because I want to be on the same page with you. In fact, I was tempted to ask a question when the General raised a concern regarding some questions that are posed to him. Now, Chair, the question is, because my understanding is that to a greater extent, the senior counsel has asked questions in relation to matters deposed on the affidavit. For instance, the 360 tender or contract is deposed on the affidavit by the general. So it's not something which is outside and which is now an ambush. And my understanding is that 80% of issues raised on the affidavit are issues which are before court, the contract, because most of those issues influenced dismissal of the general. Now, the ruling that you are giving, Chair, is confusing, really. I'm confused. So how do we identify matters that he should ask and matters that he should not ask? Whereas those matters, all of them, are on the affidavit and were voluntarily put on the affidavit by the general himself. So I'm confused. I just need clarity. I'm not arguing with your ruling. I just want to be on the same page, because we will ask questions after the senior counsel. And when we ask questions, we must comply with the ruling that we have made. You have made as the chairperson. So that's where my confusion is.
Okay. No, just to clarify that matter, because it is said by the witness here that the questions that the advocate is asking him are questions that emanate from matters that are now on appeal. That is what you are saying, General.
No, Chair. My discomfort was with counsel going to arbitration awards, wanting me to answer on an arbitration award, which is an issue that we are dealing with. So that's why I'm lost. The document that he's giving me, he's reading from, that arbitration award, even the labor court award, they gave it to me here in the morning.
It's fine. The arbitration award is under appeal.
It's under appeal, but I don't have an issue in dealing with for example, what led to that. But I've got a problem if I must now write an exam on an arbitration award, which I don't even agree with.
You listen to what Honorable Nombalo says. The statements that are contained in your affidavit, you are ready to respond to them.
Yes.
Okay. Honorable Skosan.
Thank you, Chair. Lochani likupi, General Phahlane?
Ngiyaxolisa. I'm here and ngiyabonga.
Lochani likupi?
Asikhona njani?
Siyathokoza.
Thokozini.
Now, Chair, I think what the General is raising is the issue. In fact, I'm going to ask about what I heard now. He said he was given a statement this morning. It's the other one, which it was for the first time you see that statement. That bundle.
Yeah.
You only saw it this morning.
Okay. Must I answer, Chair?
I just wanted to find out, because if I heard it well, he said that he only saw this morning. Am I right?
You can respond, General.
Chair, the documents in here are not foreign to me, but these documents are not part of my submission in terms of annexures, because I have accepted that here I am not in the labor court, or I'm not in the labor appeals court. It has been dealt with there. So what counsel is doing, he brought these copies, like this is somewhere here, there is records of proceedings. And somewhere I said earlier that unfortunately some of these are half-baked, in that some documents that are supposed to be here, if we want to bring the whole records, bring the whole records and not selective. So I'm now being questioned to say, the arbitrator said this. I say, we have moved on from what the arbitrator said. We have accepted the laws following the arbitration process. We have accepted the laws following the labor appeal, the labor court. But we are now waiting for a labor appeals court judgment. So why must I go into this? The issues, Chair, they are raised. It's me who raised it. Maybe, let me say, I may have instigated them. That's why they are part of my affidavit. That's why they are comprehensively addressed. So I don't understand why must I go and read an arbitrator's document that I don't necessarily agree with. If we want to have an understanding of what happened, here it is on paragraph, E. It's well captured between E. If you disagree with it, disagree with it. But it captures. Now I must go in, but the arbitrator said this, or an acting judge said this. I hold a view on those people. And that's why I don't agree, Chair. I'm not saying we must not. We must deal with the issue. Because, for example, the 360 camera issue, the 24 million, it's very critical. It's being brushed over. Every time an issue is being asked, even from management, they say, no, but he was dismissed. Dismissed for what? If I'm to be dismissed for 24 million, it's not me. That decision gets taken in 2018, 2019 by a sitting national commissioner who decided to settle with a service provider who laid their hands on 24 million, that became 31 million. That man left the country with that money, unfortunately died. But now they say, Phahlane approved this. How do I approve something in 2019 while I'm sitting at home? The last day I was in a police office was when I left, before I left Parliament. But this is the issue. So I don't understand why we should escape it. Why must we go to a bargaining council thing, which is not talking to the real issue? The same issue is sitting before the Portfolio Committee on Police. I was listening to them, listening to material irregularity. When that issue is being raised by management, no, but the person who was responsible has been dismissed. I listened even when you were at Khoshimampuru, the CFO said so, to say, no, that matter has been dealt with. Whereas the merits are being misrepresented, the facts are being misrepresented. I hope I'm clear, Chair.
It's now 13 hours. We are going to come back here at 14 hours. I want to allow yourselves time. I see you have your legal team here. The evidence leader is with his team. When we come back from lunch, you must be able to help us to move forward in a quicker pace. You had time to consult. When we started here, Matebele, you said to us that it was a marathon of consultations. And I may even need some time to rest. And that's why you requested that at least by 20 hours or 21 hours tonight, if we can allow you that time to rest. So when we come back from lunch, we want to see proof that indeed there has been consultations between you. Can we do it that way? Yeah. And I must say that it rarely happens that in our proceedings, we have this kind of altercation. We always have a smooth running of evidence presentation between the evidence leader and witnesses. So I think the committee has been very patient with yourselves. So when we come back at 14 hours, let's make sure that where you have been missing each other, you would have corrected that and help us to move forward. Thank you.
Are we going to adjourn now, Honourable Chair?
Yeah, we're breaking now. We are coming at 14 hours.
Thank you.
Thank you. 14 hours has just struck. General Phahlane, welcome.
Thank you, Chair.
Well, are you ready? We can proceed.
I am ready.
Did you find each other with the advocate?
I suspect we did, Chair.
Okay. I want to hear you saying, I'm convinced we did.
Well, let me say the following. I'm convinced that following what is in my affidavit in dealing with the issues, it's going to make us make good progress.
That's very important. Thank you so much. SC, can we run until 17 hours? When I say until 17 hours, I mean, okay, let me say the next break will be at 17 hours. Thank you.
Thank you, Honourable Chair, Honourable Members. Welcome back, General Phahlane. So, the issue of your dismissal, which you contend is unfair and unlawful, that we've dealt with, that's out of the way. You say there's still a Labour Appeal Court decision that's pending.
Yeah, I thought, Chair, we must move away from that one by allowing me to close it with these paragraphs which are in that particular portion, and then we can go to the 360 that you were making reference to, without going into the details, whether it is the arbitration or the Labour Appeals Court. And somewhere I think me and Council are talking past each other, because unless I have it wrong, you talked about the arbitration. Now there are two arbitrations. There is an arbitration award that relates to the 360, that led to the payment of the 360. And there's a triple SBC, award. Now, that award, the Labour Court judgment, is a subject of the current pending matter before the Labour Appeals Court. Therefore, I don't think I will want to go too much into that. We have said a lot. What I will talk to is the arbitration award, the Judge Haramse arbitration awards, that relates to the 360 and the awarding, the subsequent payment of the 24 million. But I thought maybe just to close off the issue on the dismissal, just to sum it up, if I'm allowed to refer to those paragraphs in my affidavit.
Now, yeah, you may do that if you want to, but I just thought that I agree with you. And just for purposes of clarity and to honourable members of the committee, we are talking about the same tender. That's the 360-degree camera. But in relation to the one arbitration award, which involves your dismissal, that is your conduct in relation to that tender and that contract. Then there's the other award of Harms, LTC Harms, the appeal judge, retired, where he confirmed the payment of 24 million. The tender itself, the 360-degree camera tender itself, is worth over 90 million. The arbitration award of Harms was when there was in inverted commas, settlement agreement, which did not involve you at all. And that is also the nub of your complaint. You were not consulted, you were not asked. It was actually a settlement agreed to by National Commissioner Sitole.
All right. I think this is where now I'm very calm and I'm going to relay the facts so that the disinformation is not continuing. Council just referred to 92 million. Haramsa's judgment has got nothing to do with 92 million.
Yes,
92 million is the bid, the same panoramic contract bid camera, the 360 cameras of forensic services. When the contract was awarded on the 28th of July 2014, the value of that contract was 92 million. Now, it gets awarded. Once it is awarded, obviously, my environment, forensic services, is the end user because these are cameras that are used by crime scene experts. So ordinarily, we are to place an order and buy from that particular contract. That contract is awarded to Etemba. So before even we can place an order, a competing supplier, who in this case happened to be FDA, writes to supply chain management as a division, the place where contracts are being managed. They are the ones who awards and so on the contract. So they raise an issue with supply chain management, wanting to inquire on which basis was the bid awarded to Etemba, because at least them being in the industry, they knew what the camera offered by Etemba specifications are versus what camera they were bidding for. They responded to the bid for. So once they raised the issue with supply chain management, I think the letter of FDA, which is part of the records, was the 22nd of August 2014. They now, supply chain management, instead of them dealing with the complaint, they opt to send it to me in forensic services. When I received that complaint, which is an issue raised by FDA, I then put together a team of experts, the same managers, the same team that compiled the specifications. I put them together to say, here is an issue where supply chain management is requesting our input. So they revert back to me and say, indeed, they have looked at the specifications against the product that is offered by Etemba, and they concluded that is not compliant with the specifications. In other words, supply chain management awarded to a bidder who did not comply with the specifications. I then write back to supply chain management to provide them with that information, to say, you have awarded a contract to a supplier and we are not going to be able to use these cameras because they don't meet specifications. And Council, you're correct. That contract is worth 92 million. So there was to and fro in terms of communication. We said to supply chain management, in my letter, which is here on the records, 22 October 2014, go into a process cancel. When we say cancel, we don't mean you must just immediately receiving our letter cancel. They must go together with legal services into a process of engaging the supplier and say, we have established the following. The issue there was that even the bid evaluation committee, when they made their submission to the BAC who awarded, they did indicate the non-compliance by the Etemba bid. Heavens knows why that contract was awarded, because the BEC is saying to you, this product does not comply with this thing. For example, one of the requirements was it must be a 360 camera. It must not allow manipulation. You must not stitch images together. But the Etemba product, you stitch, you do 90 degrees, 90 degrees, 90, which is, you now piece together the 90s to make it 360. Now, that is unacceptable. You can't go to court and present such evidence because the chances of the courts and learned friends arguing, but you have manipulated, and they are great. So that thing has got no value. Now, long and short, consistently as forensic services, we have given feedback to supply chain management and say, we can't. Supply chain management went even to National Treasury to say, how do we deal with this contract? National Treasury comes back to them and say, subject this contract to an independent assessment. That time, I'm acting National Commissioner. Supply chain management and legal services write a note to me. It is here. I think it's JKP4. In the submission, they say, can we take it for an independent assessment? 23 November 2016, I agree and say take it for an independent assessment. I think also there is an email here where the same supply chain management people communicate within themselves and say, the acting national commissioner said we must defend the litigation, take it for independent assessment. But I can tell you that today it is not dealt with. So when we talk about 92 million, you are not talking about 92 million in respect of Haramse. You are talking 92 million in respect of the July 2014 contract. Now, I'll repeat it here. I refused to order from that contract because the experts were never going to use that camera. How do I order something that is going to be a white elephant? They were never going to be able to utilize the cameras. So, fast forward, having refused, and even people after me in forensic services refused and say, we can't order this thing, we are not going to need it. I saved the department 92 million. That could have used to buy cameras that were never going to be used. Beyond me, remember I say I signed and approved that the independent assessment must be done based on the advice of National Treasury also. Even us as forensic services, there is a letter there, 29 April 2016, which is saying, take it for independent assessment and we will pay. In other words, forensic services was even prepared to pay for the independent assessment. To date, it did not happen. Come the 1st of June 2017, I'm out of office. Having directed that you must still do independent assessment, defend the litigation, because at the time there was an email from Atemba saying, we now want this, they were now demanding 14 million to say, because you did not order for our damages to bid and so on, pay us 14 million. I don't know what happened because since the 1st of June 2017, I'm involved nowhere. They go on, then there is a settlement, which is signed by General Setole to say, let's settle for the, no more than 14 million. When I was in office, I saw them asking for 14 million, but they settle to pay 24 million. Now, I don't know how long it took to settle the 24 million because there is 7 million extra that they paid for interest. Now, Honorable Chair, my question is, I'm not going into the merits of the dismissal or whatever. My question is, what do I have to do with payment that was settled by General Setole in 2018, 2019, when I'm long out of office, despite the fact that everyone consistently in forensic services was opposing and say, we can't pay. No one of forensic services was involved in a litigation, deliberately excluded. And when they pay, after they paid, that's when they come running to me and say, you cost the state 24 million rands loss.
General Phahlane, I don't disagree with your narrative. That's why I asked you if we can agree that whether it's the 92 million or whether it's the 24 million award of Judge Harms, it's about the same contract. Yeah, can we agree that?
Well, if you want me to say it for the sake of saying it, I agree, we can move.
Okay. A reluctant yes, I'll...
It's not reluctant. I've
No,
already expressed myself, Chair. I agree, and I have explained the context, because the context was wrong.
And the reasons... The reason why the arbitrator found your dismissal procedurally and substantively fair are reasons which are not part of the award of Judge Harms of the 24 million. They are completely separate. That is, the 24 million is after there had been demands made by the successful bidder. It was made clear to them that SAPS made it clear to them we're not going to honor this contract, so they what they call repudiated the contract. And at the end of the day, Atembu sued and said, look, these are the damages that we suffered. We also know from the award that at the arbitration, SAPS were not even represented there at the arbitration. They didn't have any witnesses there, and their counsel complained that they didn't have an instruction. And LTC Harms then said, in that case, I'm making the award. Now that is separate from the 92 million. But we're talking about the same contract. Okay? And I accept that that settlement agreement was signed by National Commissioner Satori at the time and had nothing to do with you. Okay? So, as far as your dismissal and the reasons for your dismissal are concerned, you've taken that as far as you can so far, and there's a judgment outstanding. The 92 million contract, or at the time the full contract that was before the arbitrator, that related to your, let's call it, alleged conduct or misconduct in the process of that tender. It didn't, and to put it again also on the record, at that time it didn't involve any dishonesty on your part. The arbitrator found that your conduct was reckless. That is what the arbitrator found. Okay. So can we move on from there? But the contract itself, it does feature later on in this whole narrative for other reasons. We can deal with them.
Am I allowed to
Of
talk?
course.
Paragraph 41. Even the acting judge at the Labour Court found no element of dishonesty that Lieutenant General Reid attributed to me, and the learned judge ought to have found that the Commissioner completely ignored or failed to deal with material information placed before her. That's on page 17, paragraph 41. The learned judge also found that my dismissal was procedurally and substantively fair on charge 1, only one charge. With the leave of the Labour Appeal Court, my application for leave to appeal was granted and the appeal was heard on 16 September 2025. To date, we wait for the judgment of the LAC. I'm also awaiting the outcome of an investigation conducted by the Public Protector of South Africa on the complaint I lodged in relation hereto, registered with since 2022. 4 years later, I'm still waiting. So I really have run out of the appetite of dealing with that matter because it's very well covered in my affidavit. And there is no distinction between the Harams award and the contract that was awarded in July 2014 by Supply Chain Management. The payment emanates, which follows Haramse's judgment is on the same 92 million contract, which for record purposes, once again, I had spent no cent on that particular contract.
I accept that in relation to that 92 million rand contract, your view was that the successful bidder should not have been awarded the contract because the product was defective. That's what you said.
Chair, I want to disagree with your view because that is the narrative that has been peddled outside. Your view, it is said, I did not agree with that contract because it was not awarded to FDA. So if you say my view, I disagree. The view of forensic services led by me is that that contract was not compliant and the record speaks for themselves.
Again, General Phahlane, let me not be quoted because I'm referring only to judgments that had been handed down. And in your application for leave to appeal, that judgment is also in the bundle. It's in our bundle. It's not in the bundle. In the exhibit bundle. When you applied for leave to appeal, and what page is it?
Number 6.
It's item number 6. Where did you flag it? No. But can I refer you to paragraph 26? It's on page 11 of the judgment. You see that? The applicant's conduct did not need to amount to serious insubordination, for it constituted serious misconduct. Regulation 9 sets out serious acts of misconduct to include serious insubordination or similar misconduct. Having considered the evidence, I'm satisfied that the applicant's conduct amounted to similar misconduct and that it constituted serious misconduct. And then later on at paragraph 33, and this is in relation to the 24 million, the LTC Arms award. Although the applicant was not involved in the settlement process, he set in motion the sequence of events that led to the first respondent, breaching the contract with EFG, that's the successful body, bidder, and ultimately resulted in EFG having a claim for breach of contract against the first respondent. This ultimately resulted in the first respondent paying EFG an amount of 24,494,000. Again, that's what I'm reading to you. That's what a judge found.
Judge who?
Sorry?
Judge?
Judge Davey. Acting Judge
right.
Davey.
Chair, ordinarily, I will not want to dignify what that judge wrote there out of respect for the judiciary. Because if this was to be correct, it is me who on the 22nd of October 2014 saying to supply chain management in response that you have awarded a contract to a bidder whose product doesn't meet the specifications. It is me on the 4th of November that I write again to supply chain management after I called the two. Maybe you will tell me when you are to listen to me. Chair, I'm responding to questions. I suspect that I'm to be listened to by the person who asked questions. It's me who in November 2014 that I respond to supply chain management after I called the service providers, that is Atemba and FDA, to come and demonstrate the capability of their cameras. I'm not alone. I'm with management of forensic services. That presentation satisfied me that the response I got from the experts, which said the camera doesn't meet the specifications, then gets demonstrated to me on the 28th of October 2014 by the same service provider, Atemba. And I saw it with my naked eye, the stitching and the non-compliance which is happening. On the 10th of March 2015, I write to supply chain management a comprehensive letter, which is say, please subject this product to an independent assessment. On the 29th of April 2016, the divisional commissioner acting writes to supply chain management and say, this product doesn't meet the specifications, therefore we can't buy. We even make an offer in that letter to say, subject this thing to an independent assessment and we'll pay. 29th of September 2016, National Treasury responds and say to supply chain management, subject this thing to an independent assessment with CSIR and what is it, South African Bureau of Standards. 23 November 2016, in my capacity as an acting national commissioner, I approve and say, subject this thing to an independent assessment. It's not me who wrote, it's supply chain management after they receive the National Treasury letter. And then I later leave. Was it only going to be satisfactory if we have ordered? So this judge who's writing here, must I respond? Was it going to be acceptable for us to have spent 92 million on a non-compliant contract? I will be dancing a different tune today. It will not only have been this concocted disciplinary, I'll be parading before the courts to say, corruption, corruption. If I said to my people, buy, they are telling me, they are experts. I'm not an expert. They are saying, we are not going to be able to use this thing. Now, consistently, you are being told, buy, buy, buy. Just now, there is a discussion on the 360. I don't know why is it also 360. 360 million of, what is it, Medicare 24, the Mr. Kat Matlala's contract. Why is that contract cancelled so shortly after the allegations that it doesn't meet the specifications? Why is this 92 million rands not cancelled, despite us, the experts, saying that camera we are not going to be able to use? Is it not supposed to follow the same process? There is clause number 2.7 of the general conditions of contract management, which tells you what process must be followed once there is an issue. So, Chair, I see, I can't help you. I'm not going to dignify this judge's comments with a response. That's why they are before the Labour Appeals Court. Let's wait for the Labor Appeals Court to pronounce. I'm not going to spend my energy on that person.
Can we please take Honorable James? There is a microphone there. The microphone behind you is on. If you can please help to switch it off. Thank you so much.
Thank you. Apologies. Thank you so much, Chair. I wanted to ask this question almost 5 minutes ago already. General Phahlane, you make mention that you wrote to supply chain management, you wrote to National Treasury. Now, like we've said previously to the witnesses that appeared before this committee, here when we say we wrote to, we want names. So we really need you to mention the names of the people that you wrote to that ignored those letters. Thank you.
Honorable Nomvalo.
Yeah, no, thanks, Chair. It's a follow-up question. I just want to establish if I have the correct understanding of what the General has said. Do I understand you, General, to be saying, when you said they must subject the product to an independent assessor, do I understand you to be saying you wanted them to make an assessment of whether the product does meet the specification or not? Do I understand you correctly?
That is correct, Honorable Chair. I did not want, because remember, one, this complaint is informed by a complaint that is lodged by a competing service provider being FDA. Now they complain about a product of a timber. I take that complaint, which did not come to me, it went to supply chain management, the right place where it's supposed to be. They now send it to me. What I did is to put together my experts. Remember, those specifications that they used to publish the bid were developed by the end user, the experts, because they know what is it that they want. So I now bring them together and say, there is a complaint, can you please assess and come back to me? They then respond to me with an information to say, indeed, we have found that this contract or this bid, this camera, which is now on offer, it will not meet this it doesn't meet these specifications. Based on that, I write to the Divisional Commissioner, Supply Chain Management. It's my letter dated, I think, the 22nd of October, which is here on file. Now, once that happened, there were meetings, including me and the Divisional Commissioner, Supply Chain Management, to raise this issue. But surprisingly, I was getting letters from the same supply chain management saying, place orders, place orders, place orders. And my question is, why do I get this? So ultimately, 29 April.
I'm sorry, Chair. So ultimately, the independent assessment was made.
No, to date it's not made because
not made.
National Treasury, like I mentioned, was the last authority to respond to supply chain management and say, subject those cameras to an independent assessment. Now, the same supply chain management and legal services write to me. Now, then I'm the acting national commissioner to say, can we subject it to an independent assessment? Of course, I said, yes, let's proceed. To date, that independent assessment is not done. So it was to determine, someone independent must tell whether what we are saying as forensic services, whether what the suppliers are saying is correct. But to date, it's not done.
I'm satisfied, Chair. Thank you.
Honorable James, are you satisfied?
No, we still don't have the names. Thank you.
Chair, I'm using a document which is full of pages. Can I just look? But I know that my letters were all directed to the Divisional Commissioner Supply Chain Management. At the time, the Divisional Commissioner Supply Chain Management was General Kruse. I think
what we should do when we break at 5, you can look for those names and make them available.
Yeah, but it's easy, Chair.
Unless if it's very easy for you to find them now.
Yeah, if you look at annexure JKP4, now JKP4, it's the information note that I have approved. Sorry, what is 201? Page 201. Oh, okay. Yeah, and then I'm just going to give the numbers, then we can find the pages. There is an extra JKP 5. We will see its correspondence by a Brigadier Kruger. And you'll see at the bottom of that, he's writing, say, I refer to the telephonic discussion this morning. Kindly find attached the approved information note from the National Commissioner's Office for your attention. The instruction is that you proceed with facilitating the appointment of independent expert assessors. This process will take place while we defend the summons. That is JKP and then JKP 5. And then, now I was referring earlier to a site visit, the BEC. After they've done their own evaluation on site, that is on JKP 6, and you'll see page 2 thereof. It talks about what the non-compliances were of this particular camera, especially in respect of a timber. And the next one is on, and then JKP 9. On JKP 9 is my first letter, the one that Honorable James I'm referring to, that I wrote to Supply Chain Management. It's on JKP 9. And then you also look at that in relation to JKP 10. That JKP 10 is a response from within Supply Chain Management. The chairperson of the BAEC, who's now saying they have made, unfortunately, they say they did not have technical experts on the bid adjudication committee. That's why, that will explain why at the end of the day it was approved. And then my last letter as the Divisional Commissioner, Forensic Services, there it is, JKP 11. I wrote on the 10th of March, 2015, and you'll see my last sentence there. Based on the above explanation, the Division Forensic Services does not support the decision made by the Bid Adjudication Committee to award the contract to Etemba. It's 249, this same, yeah. On page 249, I'm told. 249, yes. I hope I've answered a few of those questions in terms of the correspondence that was there. I think in JKP 15, and this is now in relation to the Aranse Award, not Aranse, Haramse Award. There is on JKP 15, 259, okay? The acting divisional commissioner of forensic services, I'm long gone, because this was 2018-0702, General Magadlela. Right here, it remains a challenge for me to clarify if equipment that does not meet specifications proceed to enjoy approval from the bid. So he's simply agreeing. I mean, this is in 2018. I'm long gone, but he agrees. And then the National Commissioner on the 2018-0704 approves the same thing. While he's been told, you can't approve this because the thing is not compliant. But there it is, it's approved, but then it becomes my problem. I don't know how. I hope I answered the question, Chair, in respect of some of the correspondence. Those that I did not find, I'll find them during a little bit later and share.
I'm covered. Thank you so much, Chair.
Advocate Aransa, we can proceed.
Well, Phahlane, I'm afraid you're misleading this committee. Let me demonstrate this to you because you're making an issue of it. I thought we'd move on. Can you look at, firstly, when you indicated that you wanted or you were in support of the appointment of independent expert assessors, that was only in November 2016. And in November 2016, you were now the acting National Commissioner. Is that right?
Chair, I'm allowed to take offense.
Can I
go
what
with
I'm trying
you?
to demonstrate
That is
to you?
my first correspondence as the acting National Commissioner. My only correspondence. I've just shown you, Council, 10th of March 2015. That is the last letter that I've written as the Divisional Commissioner for Forensic Services. And I've shown you the letter dated 22nd of October 2014.
If, with reference to annexure, your annexure JKP4, which is at 201. Let's start there.
Chair, I'm also human. I suspect I'm allowed to take offense. I can't be told that I'm misleading when I am tendering here factual information. And I'm going back.
Allow me to complete
Okay.
what I want to put to you. I don't make a statement like that lightly. As counsel, as an advocate, subject to the rules of ethics, I can't make a statement like that, you're correct, that you must lead without reference to the facts. And that's not what I intend to do. Because you've given your narrative and I'm saying it's misleading and it distorts the facts.
Yeah, I'm listening.
Are you listening?
I'm listening, sir.
Now, the losing bidder, FDA, lodged the complaint on the 22nd of August 2014
Correct.
about Itemba's conduct.
Correct.
You, and at that time, of course, you were still the head of forensics.
Not the head, the Divisional Commissioner for Forensic
Divisional,
Services.
well, divisional commission, the divisional head of forensics. And you, when they lodged a complaint, you signed it on the 22nd of October 2014.
Sorry, just I signed.
This complaint. Yeah. Your own complaint was signed on the 22nd of October 2014. SCM wrote a letter on the 4th of November 2014 to the Bid Evaluation Committee to reconvene to obtain clarity from the nominated expert on the BEC panel on the product of Itemba. The BEC then reconvened and provided a report confirming that both bidders, Itemba and FDA, complied and they submitted their report. So this is all in 2014. On the 10th of March 2015, Forensics wrote a further letter in relation to the issues of the timber product. And on the 31st of March 2015, the concerns were addressed to Itemba in a letter, and on the 7th of May 2015, Itemba responded to the concerns raised by forensics. On the 13th of May 2015, Itemba's letter was forwarded to forensics for comment and information. On the 4th of June 2015, you now as head of forensics noted that the matter is urgent, but however undertook to provide a detailed response, and to quote you at paragraph 2.29 of your response of 4th of June 2015, and that is in the information note JKP 14, you provide a detailed response, quote, at an opportune moment. So that's on the 4th of June 2015. On the 27th of July 2015, a reminder was sent to you awaiting your response. No response. On the 2nd of October 2015, a further reminder was sent to you to respond to Itemba. No response. That's the whole of 2015. On the 10th of February 2016, Itemba sent a letter, a follow-up letter, detailing the products offered, the benefits of the product offered by them, and requested that an official order be placed. Because the tender award had been made. They were entitled to receive orders in accordance with the award and the contract that was signed. On the 29th of March, Itemba, not having received any orders, issued a letter of demand. On the 25th of April 2016, Itemba requested a meeting with the Forensics Division. Only on the 29th of April 2016 did you, through Forensics, reiterate the viewpoint about the Itemba product that it was defective. Itemba then says, look, you are repudiating, your conduct is repudiatory, and we are now cancelling the contract. On the 14th of July 2016, Itemba accepted the repudiation and cancelled the agreement. Yeah. And that narrative is the same narrative that is recorded by the arbitrator in her award. And the reason why the arbitrator found against you is that in the context of this matter, and given the delays and the non-responsiveness on your part, she found your conduct to be reckless. Now, this morning already, I said to you, the arbitrator didn't find that you were dishonest, but you were reckless in your conduct. Can we agree on that? That was, not agree that it was, you don't have to agree with me that it was reckless, but to agree with me, that is what the arbitrator found. So, if you also look at page 213 of this JKP4, sorry, it relates to clause 7 of the general conditions of contract, which places an obligation on the parties to make an attempt to resolve issues amicably by mutual consultation.
What page did you say?
Page 213.
213.
These provisions, I put it to you, had been blatantly disregarded. There were attempts. The bid evaluation committee and the nominated experts and supply chain management and ITEMBA had made attempts to engage and to put their concerns to forensics, but these attempts were either disregarded or ignored. And that's the basis of the arbitration award, which still remains undisturbed.
It remains?
And when you say...
No. There is a word you used. It remains?
Undisturbed.
Undisturbed?
Yes, it hasn't been set aside yet. That's what I mean.
All right, fine.
Yeah. So, I put it to you that this reference to I think it's JPK 5, the one on page 219 of 28 November 2016, is a complete afterthought. It was belatedly sent after the contract had already been cancelled.
Which one? Which letter are you referring to? JKP?
JKP 5.
Okay. A complete afterthought.
Yes, this is the one where it's from Kruger, Lawrence Kruger, Brigadier, dated 28 November 2016. It's to Mokoena, Lieutenant General, the subject matter, appointment of expert assessors, ITEMBA Group. Dear Lieutenant General Mokoena, please see the trailing email by Major General Mnisi, Legal and Policy, as well as the attached information note signed by the Acting National Commissioner, that's yourself, to approach an independent third party for an expert assessment as to whether the product offered by ITEMBA Forensic Group complies with the specification. General's respectful approval is requested to proceed with the referral of this matter to the Office of Major General Pillay to activate the procurement process for the appointment of an independent expert as mandated by the Acting National Commissioner. So that is the narrative in its proper context. And it's in that context that the arbitrator found against you.
Am I allowed to respond?
Of course.
Okay.
If I may just round this off. You also know that you were present initially when ITEMBA's expert, I think a Professor Weiss, W-E-I-S-S, he came here from Germany because he's the what do you call it, the founder of this camera, of the camera device. Yeah. He came, and you were in that meeting with all the senior management, and he made a presentation where he in fact said that this camera is not defective and that it does comply with the specifications, and he then undertook to ensure that maintenance on this camera is done on a regular basis as required by the contract.
Am I allowed to respond?
Now the reference to Weiss's evidence is made also in the arbitration award. And this is in JKP 10 at the bottom of page 247. The bid evaluation committee Brigadier Magagula, Chairperson of the Bid Evaluation Committee, on the 20th of November 2014, they recommended that the issues raised by forensic data analysts in their complaint were not found to be part of the bid specification, can therefore not be considered for the cancellation of the contract. However, an agreement was reached that the matter should be referred to legal services for advice and proper guidance. It's at page 247. Annexure JKPTN is 246, and it's an information note, that's addressed to the Divisional Commissioner at the time of Supply Chain Management, Lieutenant General Cruiser.
Am I allowed to respond now?
Yes, of course.
Okay, I'm asking.
You don't need my permission. I have put to you what I wanted to put to you, and you can now respond.
I will never say to an older person you are misleading because of how I'm brought up. Worse, I can't say it to counsel. But I seriously take offense when such is attributed to me. And I'm presenting here factual information. Page 213 that councillors referred to, 27.1. If any dispute or difference of any kind whatsoever arises between the purchaser and the supplier in connection with or arising out of the contract, the parties shall make every effort to resolve amicably such dispute or difference by mutual consultation. For everyone's information, I am not a party to the contract. I did not sign any contract with anyone. The contract is between Supply Chain Management on behalf of the South African Police Service and Atemba. 27.2, if after 30 days the parties have failed to resolve their dispute or difference by such mutual consultation, then either the purchaser or the supplier may give notice to the other party of his intention to commence with mediation. No mediation in respect of this matter may be commenced unless such notice is given to the other party. Anyone who have seen a notice in compliance with provision 27.2 of the general contract must tender it with me. Should it not be possible to settle a dispute by means of mediation, it may be settled in the South African Court of Law. Mediation proceedings shall be conducted in accordance with the rules of procedure specified in the SCC. That is on page 213. I just want to check what the annexure is this. Is JKP? No, is it not JKP 3? On top there, that information note starts on page 191, and that's JKP 3. It's JKP 3. And then, this is the same information note that I approve on the 23rd of November 2016. What was I approving? Paragraph 3, because this is submitted to me by Supply Chain Management. So it's a paragraph 5.3. 5.3 reads, in view of Atemba, it's on 215, in view of Atemba's statement that they will proceed to serve summons and claim damages suffered as a result of the service breach of the contract, and the risks involved in the service approaching court, with an application to set aside the defective decision. It is recommended that the service awaits the serving of summons by a timber in this matter and defend it. I'm taking cue. This information note is put together by a learned colleague, Lieutenant General Khan, who is the Divisional Commissioner of Legal and Policy Services. Now, I said 5.3, that's what I was asked to approve. And that's what is sitting before me. 5.4, which is the second thing that I'm being asked to approve. It is further recommended that National Treasury, Office of the Chief Procurement Officer's proposal for an independent expert assessment as to whether the product offered by a timber complies with the specification should be pursued, as this will remain relevant in this matter. So it is following this information note that the email, there was an email referred to of Brigadier Kruger, page 219. Okay, maybe I must go here. Page 219. And you will note in that email, it is not directed at me. After they received my approval, which they requested, they then communicate to 219. Now, Kruger sent it to the Divisional Commissioner. That's the Divisional Commissioner of Supply Chain Management, the custodian of contracts at the time. He said to me, please see the trailing email by Major General Munisi. Major General Munisi used to be in legal services, legal support, as well as the attached information note signed by the acting National Commissioner to approach an independent third party for an expert assessment as to whether the product offered by a timber forensic group complies with the specification. General's respectful approval. He's not asking my approval. I've already granted approval on what they were asking. Approval to proceed with the referral on this matter to the Office of Major General Pillay, blah, blah. And then I read earlier the bottom part of that. You can see nowhere in that thing am I addressed. It's General Khan, who was the Divisional Commissioner Legal or Head of Legal, General Mokwena, who is the Head of Procurement or the Divisional Commissioner Procurement, Major General Mangale, who is the Component Head, Crime Scene Management. In other words, it is in his environment where those cameras were going to be used. Groenewald used to be in legal and so on. But it says, the instruction is that you proceed with facilitating the appointment of an independent assessment. This process will take place whilst we defend the summons. Whether it's the judge or the arbitrator, someone must show me in the contract that was signed to say, once the contract was signed on the 28th of July 2014, you must order within a month or within 2 months or 6 months. This contract made provision for the first order of 60 cameras in the first year of the contract, because it's 2 years, it's over 2 years. Which means if you take from July 2014, by July 2015, that's the first year within which there was an obligation to order 60 cameras. But before we could even place an order, it is already found that the contract did not comply with the specifications, that the cameras that were offered by the bidder were never going to be used. Now, I received a letter from Supply Chain Management, the one that we're referring to from FDA, which came to me through Supply Chain Management, is JKP 8. That letter of the Divisional Commissioner Supply Chain Management it's dated 2014-0904. Yeah, 2014-0904, coming to me. Now, somebody who is a judge or an arbitrator somewhere is saying, why did you not order before the complaint? What was the rush? Was I supposed to order just because there is a contract? We always get asked the question of due diligence. So, thankfully, the complaint came, and I was able to send it to the experts in the environment. That's my letter of the 22nd of October. Let me go to that. There is my letter of the 22nd of October. That's why, Chair, it can never be an afterthought. In this letter, I communicate paragraph 2, which is JKP 9, on page 244. It is alleged in the inquiry that the product of the successful bidder doesn't comply with several criteria as stipulated in the bid specifications. Paragraph 3, it says, the bid evaluation committee shortlisted 2 bidders from the companies, namely Atemba and for FDA. Both bidders indicated that their products comply with the bid specification. The shortlisted companies were subjected to further evaluation, which included supplier site visit and product demonstration. It was not apparent to the bid evaluation committee that the bid offer from Atemba Forensic Group may not be compliant to any of the specifications. On paragraph 4, we are telling supply chain management, our findings are that subsequent to the awarding of the bid, receiving the inquiry, it is found that the bid offer of forensic Atemba Forensic is not compliant to the following critical specification. Underline critical specification. Clause 3.5.1, the specification required the spherical camera that rotate, capture, and capable of scanning and also create a full panoramic image during one single rotation by turning on motorized rotation device. Now, there we are saying, the product of Atemba does not provide one single rotation scan, but rather rotates and then scans a limited view, repeating this process several times and requires stitching by the user to provide a panoramic image. I can go on. Those are the reasons advanced in a letter that is communicated to supply chain management. Now, Council mentioned JKP4 of JKP10, sorry. That is the letter from within supply chain management. This person who's writing this letter is the chairperson of the bid adjudication committee in supply chain management. And this submission of hers, it's prompted by my submission. There it is. To give feedback to the divisional commissioner on the outcome of a meeting held, the letter with reference blurb dated 2014 was received from the divisional commissioner supply chain management to reconvene and discuss the complaint received from divisional commissioner forensic services on behalf of forensic data analysis company. Exactly. Here it is. I'm complaining on behalf of FDA. FDA lodged a complaint with supply chain management. It is supply chain management that submits a complaint to me and say, can you input, can you look at it? I respond. But no, it's a complaint because even in the records that the council is reading of the arbitration, somewhere you will see they received a complaint from me. I never complained. We responded to a complaint. But important, if we were to take the honorable members into confidence, page 247, findings of of this particular bid adjudication committee. That is bid evaluation committee. Thanks, Councillor. In the light of the above facts, the following findings were made. Now, after reading them, whoever is confused, maybe I'm confused with. If they are not confused, I'm also not confused. It says, the technical experts were part and parcel of the committee who agreed that both bidders met all requirements during the evaluation and site visits. Now, this is what I was referring to. Nobody took the responsibility of leaking confidential information to forensic data analysis as contained in their complaint. Thirdly, it says, the technical experts indicated that their representatives who visited both bidders' sites were not competent enough to make informed decisions after the visits. It's them, it's not me. They are saying they were not competent. The reason why they were not competent is because a nominee of forensic services who was an expert, a crime scene expert, was excluded from participating in the evaluation. So this bid was evaluated by non-experts, and the Treasury regulations demands that when there is an evaluation, there must be an expert. The final recommendations of the panel did not highlight the concerns raised in the complaint received from their division. Now it's again their division. They were only highlighted as pros and cons. Now, those pros and cons is exactly the non-compliance issues that are being raised. Now, my letter of 2015-03-10, I was still in the office as the divisional commissioner. I've already mentioned paragraph 14 of that letter, 252. Based on the above explanation, the Division Forensic Services does not support the decision made by the Bid Adjudication Committee to award the contract to a Temba Forensic Group. If you go and look at paragraph 11 on top, it says, forensic services cannot be placed at risk and under no circumstances will the expert status of crime experts be compromised. So, Chair, if this is an afterthought, it is an afterthought. 2016, the letter you are referring to of 2016, I am long no more the Divisional Commissioner of Forensic Services. There is an acting Divisional Commissioner because I left the environment on the 14th of October 2015. And in this letter, the general who wrote the letter, paragraph 7, it's on page 256. On the 6th of August 2015, a further meeting between Lieutenant General Phahlane, Lieutenant General Kruse, and other members from Division Forensic Services and your office were held. During this meeting, the concerns as raised above in terms of compliance of this item to the bid specification was again discussed. When that discussion was taking place, I am still the Divisional Commissioner, Forensic Services. And I convened this meeting with General Kruse to go and discuss this thing because we were saying, can we just be helped? We are not going to buy from this thing until such time that the issues are resolved. It is following that letter of 2016-04-29 that Supply Chain Management wrote a letter to National Treasury. And there is National Treasury, JKP 14, 29 September 2016. So, Chair, I'm not sure in which way am I misleading. What I can tell, and I will tell it until I die, I will never spend public funds on something that is not going to be used, especially 92 million go down the drain just because there is a glorified service provider somewhere who has been given a contract, and I must append my signature and say, place an order. I will never do that.
So, again, I'm not going to debate this with you any further. I'm not here to provide the answers, but this is the way, all that what you said now, this is how the arbitrator has dealt with it and subsequently confirmed on review in the Labour Court. And I'm looking at the award. It is item 4, dated the 16th of July 2021, from paragraph 81. The applicant's conduct, in my view, was reckless at this stage. There was a threatened legal action. The applicant, that's yourself, held the view that supply chain was insistent on this procurement despite the alleged non-compliance. He, however, failed to see that it was him or his division that were making it difficult for supply chain to act appropriately in this matter. It is not sufficient for him to merely indicate that the equipment was not compliant and not comment on the report that indicates that, in fact, the equipment is compliant. What compounds the matter is the fact that the inventor, that's Dr. Weiss, of both these cameras, was the person who was providing the opinion on the effectiveness and compliance of both. The evidence of Dr. Weiss, which of course was not contested in the arbitration, you were entitled to contest his evidence, that he was the inventor of both and understood how both these cameras worked, was not disputed or challenged. On the 2nd of October 2015, another letter from Supply Chain Division was sent to the applicant, referring to the previous correspondence where a request was made for comment. And it was indicated that this was required in order to assist supply chain to finalize the matter. Because you are the end user, you must use it. The applicant in his testimony indicated that he did not respond to this email and said that, quote, he could not grace this with a response. Again, I find the applicant's attitude to be grossly reckless and a clear dereliction of his duties. Despite the applicant's views on the compliance or non-compliance of the equipment of Itemba, there was a contract that was concluded between this entity and the respondent. The applicant indicated that the contract was worth 92 million and that he was not going to procure and spend that kind of money if that was going to not benefit the respondent. But unfortunately, by failing to assist supply chain in this regard, he was actually putting the respondent at risk of being litigated against and not even having any way of defending itself. During his testimony, General Phahlane emphasized the fact that he was not in supply chain and needed to understand why he was dragged into the contract engagement. So the arbitrator took into account exactly what you have told the committee, that it's not you, but it's supply chain. Whilst it is so that contract management falls squarely within the domain of supply chain, the facts must be considered in the context of the prevailing circumstances at the time. The prevailing circumstances were that the respondent, through supply chain, concluded a contract with Itemba, and the end user, led by the applicant, was saying that the procured product was not compliant. Itemba provided a report that addressed the concerns raised by the end user. Supply chain was simply saying to the applicant and or the division to provide your comments on the report to assist in determining the way forward. The applicant indicated that the reason why he could not, quote unquote, grace the correspondence from supply chain with the response was because already in August 2015, there was a meeting that he held with the Divisional Commissioner, Supply Chain, and that in this meeting, he had indicated that supply chain must get an independent expert to provide advice on the suitability of the product of Itemba. The challenge with this version is that it is not corroborated. On the documentation presented in the hearing, it appears that there was a meeting, but there was no minute of this meeting. Further to this issue was discussed at the meeting, testified by the applicant. I cannot understand why he could not just respond to the division, to supply chain, and tell them that he had already discussed the issue with Cruiser, and it was agreed that an independent expert be appointed. The applicant did not provide any response, and I find by failing to provide a response to the report of Dr. Visa, He put supply chain in a difficult position as they could not just take a decision to cancel a contract without further information from the Forensic Services Division. So that is how what I had read back to you based on the information note and your narrative. This is now the concluding remarks of an arbitrator who conducted a hearing, witnesses testified, you testified, and this is what he concludes at paragraph 98 of the award. On the totality of the evidence, I find that the respondent has proved on a balance of probabilities that the applicant intentionally caused the non-compliance in respect of contract 19/1/9/1/187 for the purchase of 360-degree panoramic cameras. With respect, General Phahlane, I think you've given your view and you've indicated why you don't agree. I rely on the documents I have in front of me, the arbitration award that has now been taken unsuccessfully on review to the Labour Court. I don't see why or how any further discussion or debate on this issue is going to assist the Honourable Committee. I think your views have been made known pretty strongly, and they will obviously take that into account.
Chair, may I say the last thing? Let me just stick to the fact. Reference is made here to Dr. Weiss. And these honorable members and our beloved country is being told that I'm supposed to believe Dr. Weiss, a German, who is a service provider, a timber, is buying the cameras that he was selling to us from Weiss. So, a timber is a local supplier. Weiss is an overseas manufacturer of this so-called 360, the Civita that you are talking of. Weiss happens to have worked for the company that manufactured Spheron, the 360 camera that we as the South African Police Service have deployed successfully so. That 360 camera, the Spheron, actually assisted us immensely in the Oscar Pistorius case. That's the first big case where that camera was being used. Weiss happened to have left Spheron having stolen the intellectual property of Spheron, and he went to establish his own Civita camera. And he now sells it to us through a timber. Now, when you say I had a meeting with him, it was me, I refer to it in my testimony, that on the 28th of October 2014, after my letter of the 22nd of October 2014, I called both a timber and FDA to come and demonstrate their cameras so that we can have a closer look what is the capability of these cameras? Because this local supplier, Atemba, was just a middleman. They were not able to demonstrate that particular camera. They brought the German Dr. Weiss to my meeting. I never invited Weiss. I invited the suppliers who were bidding. I have invited Atemba because they were awarded the contract. Now, whether it's the judge, whether it is the arbitrator, now I hear today, I'm supposed to have believed what Dr. Weiss is saying. How do I believe one supplier while the rules of the game say an independent assessment? It's Treasury regulations that say, subject this to an independent assessment. And I'm saying it here today. To date, it's not done. Once again, if I have to suffer because of not having listened to a German person called Dr. Weiss, let it be. I will never spend a single cent on buying something that is not going to be useful to forensic services. And consistently so, my colleagues have said so. Now, Chair, I thought we moved long away from the so-called dismissal. I have traversed that issue. I thought I'm talking about the Spheron. There was, for long I've been saying paragraph E, but at least I have spoken to those issues that are covered on paragraph E, which is until paragraph 81 on the same. And if we were true to each other, Chair, I'm going to use just 2 paragraphs. Paragraph 79, it's on page 31 of the affidavit.
Before we go there, can we take Honorable Skosan?
Thank you, Chair. I just wanted to, I was a bit confused as well that I thought the matter of the submission which was given to General Phahlane this morning, the issue of the arbitration, those matters, the matter of labor court, because I thought that General Phahlane said to us that the matter is in the appeals door, if I remember well. Now, I'm not sure, are we back to that again, what the evidence leader was reading now? We are back to that, or it's a different story altogether? And my follow-up question to General Phahlane is, are you saying that, if I want to understand, I'm not putting aspersions on that. Is Dr. Weiss, in your view, conflicted in this matter? Thank you, Chair.
Chair, he is definitely conflicted because, one, he worked for Spheron, which is the camera that FDA was selling. There, he was fired at Spheron. Then he left and went to establish a company of his own to manufacture Sevita camera, which allegedly is an improvement from Spheron, but I can't vouch for that. So now he is the one, in actual fact, he's the one who's selling. But then even the council reads here what comes from the arbitration award. I'm told, I'm supposed, because he gave an opinion, I was supposed to say, I'm satisfied. Let's proceed with the order. A conflicted person, he's the one person, he actually is the one who is selling through a timber to us. Now, I must disregard the prescripts. I must disregard what the experts are saying and say, because Dr. Weiss has spoken, let's carry on and spend the 24 million. Now, council reads, and I don't know why I'm back there, but anyway, I'm just a witness to be asked questions. My duty is to answer. I must not ask questions. He reads out the arbitration award, and we were able to prove that that award relied not on the correct recordings of the proceedings. Because somewhere, for example, in the award they say, Phahlane did absolutely nothing. If I did nothing, what are all these correspondences? And my job was not to answer documents of saying order, order. My job is to make sure that there is a product, and I'm being mistaken for being an end user. I was hearing counsel saying so. End user are crime scene experts. I just happen to be a manager of experts in the South African Police Service. So I take cue from what they are saying. I don't impose things. Whoever wanted the 92 million, unfortunately they did not get it, but Setola gave them 31 million. I think they are smiling. They did not even deliver a single camera. And then it is me. But this matter is before the Labor Appeals Court. I don't know why I must be going through it. I had it in my affidavit to give background to what has been happening in this regard. Thank you, Chair.
Yeah, Honorable Skosan.
Thank you, Chair. I think the clarity from General is very clear. 24 million plus interest, 31 million was paid without any camera delivered to South African Police Service. Whether the judge said so or the arbitrator said that he found you, whatever, those issues which I don't want to go to. Whether he agreed that you were wrong. But the issue which you are putting to us here is that you saved South Africans. You were saving South African money not to pay for something which we are not going to use for this country. Those cameras were not even delivered. I think what is important for me from where I'm sitting is that it was a fruitless expenditure, Chair. But thank you.
If I respond, Chair, it's 100% correct. That
before you respond, because these matters go on record, isn't it? So you say that there were cameras that were procured by the SAPS, and those cameras were never delivered. It's not what you are saying.
No, Chair. I'm saying, based on the settlement approved by General Sithole and the payment that was made to Etemba, the payment was for what is called repudiation or breach of contract. It was not for buying the cameras. It is to say, we had the contract, you did not order from us. And the bill started being 14 million, it became 24 million, and then they subsequently paid 31. But I'm saying, for that amount, while it was not an order to buy a camera, there is not even one you can show, but the 31 million is gone.
And who was the person who authorized that payment?
General Sithole and the CFO who was there in Khosimampuru, they approved the 24 million. They paid the what do you call the plus the 7 million, which became 31 million. And I know they continue to say, no, this matter is dealt with. It is dealt with the AGSA. The person is dismissed. That's the issue that relates to me, not these blue lights that I'm hearing of. I was never.
Yeah, no, let's not go there. We
Yeah.
will come
Okay.
late. We're still on this one. I want to take the following hands. Honorable Breitenbach, Honorable Shongwe, and Honorable Ntuli. Honorable Malema. Is your hand up, Honorable Matthews? The five of you. Honorable Breitenbach.
Thank you, Chair. Chair, with respect, Mr. Phahlane is now just, not sure how to put it, talking constantly about prosecuting his own labor-related issues. It's got nothing to do with the terms of reference of this committee. It's completely irrelevant to the work we have to do. And I honestly can't see the point of sitting here and listening to it for the rest of the day. I just can't. So either we go back to our terms of reference and deal with issues that are relevant to this committee, or I'm not prepared to sit here and listen to Mr. Phahlane prosecute his labor issues in front of this committee. It's irrelevant and we can do nothing about it. Thank you.
Honorable Shongwe.
Thank you, Chair. I think Honorable WDA must understand that Mr. Phahlane is led by the SC here on that matter, so either it forms part of TOR or not, but he's led. What I want clarity on, Babu Phahlane, is le mali ekhokhiwe ikhokhwe ngoba umthengisi uyakhala ukuthi awuthenganga kithi. And how did they arrive to this amount? What was the formula? What was the determination ukuthi kube so much millions for ukuthi angithenganga kuwe? Two, I think we missed an opportunity CFO Udimpane, but I also second Honorable Nomvalo Magat. Some of these people must come back. Chair, to you, I really want to appeal on behalf of South Africans. Yes, we want to arrest people very urgently. I have a few of them that must be arrested soon. But we can't miss this opportunity of closing this committee singakaqedi ngokubola okubonakala phakathi, because some of these matters, we are on, I think we're still on stage one, if I may call it like that now, of this statement of General Phahlane. We haven't even started to go further probing it, as the booklet is so big. But I'm hearing that there is a need for iskhathi esiningi, Chair. Because I need to understand exactly how do we get to so much millions because asithenganga kuwe. Thank you, Chair.
Chief Whip.
No, thanks, Chair. My first question is linked to what Honorable Shongwe has raised. And the last one will be a very brief comment in relation to what Honorable Breitenbach is saying. On the matter of the sequence that has been presented to us, just to briefly recap it, a contract is awarded on condition that a number of cameras are going to be ordered within a period of a year. And before you get into the end of that first year of the 2-year contract, certain developments unfold, which include challenging the legitimacy or the appropriateness, relevance, whatever the correct description of the contract. But around the same time or simultaneously, the person who has been awarded a contract is already complaining that you have given me a contract, but we are not placing orders. And I heard your responses to be saying, we are not duty bound to give you orders immediately, because in terms of our contract, we have at least 12 months within which we must order the first consignment of 60 cameras. Now, the question then generally arises in this context. The payment that was then subsequently made, 31 million in total, divided into 2, was a payment in compliance was a payment in compliance with the grievance that the company launched with the department or with SABS, in which they were saying, we have a contract with you, but we have not ordered, and yet the year had not ended. That's number one. Number two is whether the payments were essentially as a result of a decision arising after 12 months of the appointment without the service provider being given orders to provide the first consignment as the contract was worked out and developed. So I hope you got that question. That's a question I have for you. But then I want to comment on the point that Honorable Bredenbach is raising. I mean, I've been talking to my colleague here next to me, Honorable Sangoni, saying to her, I'm not sure, Chairperson, I'm not very certain where are we traveling to, given the extent to which the senior counsel is engaging the witness on the matter at hand. But my own attitude is always to wait a bit before I can intervene, because sometimes you intervene earlier or when you are about to arrive at a destination where you are being led to. But the concern that Honorable Bredenbach is raising is a valid concern. I also have heard that concern, Senior Counsel. I thought we were overdoing this part of the questioning to the witness. But like I'm saying, I thought maybe one should give you a benefit of a doubt. We may be getting closer to where we're going, but I was worried we're taking longer. And I was beginning to talk to Kusela that I am not sure where exactly are we going to be ending on this aspect. Especially because that's my last point, Chair, and my approach for being long. Especially because where there are contentious matters or there are disputes of facts between what a judge and somebody else, I can't remember the name, has done, and the witness, and we spend a lot of time on that conversation, how does that help us to resolve our own issues as the Portfolio Committee? So that's an area that I would like our senior counsel to reflect on, consistent with what Honorable Bredenbach was raising. Thanks, Chair. Thanks a lot.
Thank you so much, Honorable Malema.
No, thanks, Chair. I think the Chief Whip dealt with it and the Honorable Bredenbach. If we were to calculate how much we made from 9 until now, working for Parliament, it will not be worth it. You are actually going to eat people's money for nothing. I don't know what we're doing from the morning until now. I don't know what this exercise we are engaged in helps this committee with in relations to the terms of reference. Can we please get somewhere? We need to move, because really we've been keeping quiet, all of us. And some of us, it's unlike us, to allow a situation where we spend a lot of time on a matter that we've been told is actually even before the courts. And you intervened and said you heard that this matter, our awaiting judgment, is on appeal or something like that. Trying to caution the senior counsel on try by means to avoid going deeper into that thing, because a judge will come and say, actually, this is the position. Still, even after that intervention, we're still not making progress. When we break, go and talk to each other and agree on the direction we're going to take. We come back, we proceed as if there was never a break to engage on this matter. So, Chair, please, we need to leave this point. We must leave it and go to issues that are relevant to this committee. Thanks.
Honorable Matthews.
I've been covered now, thank you, Chair.
Okay. Can I take your response before I speak on the matter that the honorable members have raised? There are questions that you have been asked, General. Are you able to respond to those questions?
Those that I remember, because they were long, but I'll try. First, Maybe I start with Honorable Breitenbach. It's not me who brought the.
Yeah, don't
the
respond to
judgment.
that one.
In actual fact, it's paining me to be taken through the very same thing, which has got inaccuracies, things that I don't agree with, but maybe there is a reason. In respect of what the Honorable Member Ntuli raised, even how they arrived at, I think it's Honorable Shongwe, how they arrived at the figures of 24 million, and so it will be found in JKP 16. I was not party to it. I see here there is a memorandum which was drafted to the State Attorney's Office by DP Dupree SC and Botma. On the pages, I think paragraph 4 or so until 6, the figures are there, how they arrived at. But I cannot tell the reasoning behind these particular figures. What I saw before November 2016, the first letter of demand was 14 million. How it escalated from 14 to 24 and now to 31 million, I really don't know. And what Honorable Ntuli asked, remember this payment gets made 2018, 2019. This was a 2-year contract, which means the first year of it would have been 2015 because it was awarded in 2014, July. So 2015 would have been the first year, and then it would have ended in 2016, somewhere there around. And so this was not, the money that was made was not related to any procurement. In other words, there was never an expectation that there is going to be a camera or an item which is going to be delivered. It is the civil claim. I see somewhere here, they even say the South African Police Service was not able to justify or bring anything on the table in respect of the quantum. So they basically agreed to what the service provider was offering. And before I forget, there was something that I did not mention when I was responding to counsel on Vase. Vase himself, during the arbitration, if the records are read properly, he considered that he saw in the correspondence that the South African Police Service has expressed the need to have the product subjected to an independent assessment. And in his own testimony, he said, I agree that was the right thing to do. He even said this could have been done by approaching universities or institutions. In our case, we know which institutions were dictated by National Treasury, being SABS and CSIR. But to date, it was not done. So simply put, that was what was supposed to be the case. Yeah, I don't think, is there a question I missed?
By Honorable Shongwe.
It's responded to that question. Okay, thank you, Chair.
Okay. The honorable members are right on the point that they emphasize, and we have not said it once in the proceedings. We said it many times. that General Phahlane, we are not a dispute resolution forum. And we are not in a review process. The facts were stated very early in the proceedings that these matters are before the Labour Appeals Court. And it was even before we took the lunch break that I said, if there are any matters that are related to our terms of reference, which we can take out of the court proceedings, let us be alerted to those matters. And look, the matter only comes now that there has been a transaction that is suspected of financial improprieties, where an amount of about 31 million has been paid. If, for instance, when this matter was presented for the first time to say, we will not focus on the processes that are before court, but the committee must take note that there is this transaction which has happened, and we think that this was improper because the state lost money. Whether it was a corrupt transaction, unlawful, or unreasonable, in whatever way that transaction may be described, it is brought to the attention of the committee to probe it. And the rest of the matters that are before court, we leave them for the court. It's not for us here to justify whatever award the court would have arrived at or whatever judgment the Labour Court would have arrived at. We can arrive at the appeals court and it overturns those decisions that have been previously taken. In fact, we have instances where we had even the Constitutional Court itself condemning not only the judgments, but the conduct of judges who made those judgments. So if we can have focus, and I must apologize, Honorable Breitenbach, because immediately when we started after lunch, you sent a note here to say, but Chairperson, is like, we are going off the rail even when you have warned that we need to focus ourselves to the terms of reference. So can we take up matters that fall within the terms of reference of, we no longer want to hear anything about the arbitration award. Look, General Phahlane, when you live here, if there is an arbitration award or a Labour Court judgment, this committee will not change it. If there is an appeal pending, this committee does not have any influence over that process. We can't influence it in any way. We are going to wait, like you, for the day that a judgment will be made. And SC, we are appealing for the last time that it is not the purpose of this committee to demonstrate to General Phahlane that the judgments or the awards that have been made are right or are wrong. It's not our purpose. Let's look for matters that fall within our terms of reference and deal with them. If there is any, we have said it in many occasions, witnesses that come before us are not accused persons. They are South Africans who come here to have a conversation with us as a committee and help us to probe the allegations that have been made. If there is corruption in the SAPS and there is a witness who has information that helps us to probe those corrupt activities, let's allow that witness to give us a chance. For instance, now, if you have any information about the 31 million that has been paid, and the South African you allege that the South African state would have lost money. Give us that information. We will deal with it and make the necessary recommendations on how that matter has to be processed. I think that is adequate, and we should be able to move forward. Honorable members, understand that they have given you their time, they have been tolerant, and we must not take advantage that it is still January, we still have other 11 months to come. No, let's focus. Thank you so much.
May I say one thing, Chair?
No, I think I have spoken to you. I have drilled what the honorable members have said. So I'm now handing over back to yourselves to continue with the presentation of evidence. But it must be within the confines of what members have said.
May I proceed, Honourable Chair? General Phahlane, the next item you deal with in your affidavit quite extensively, which is from item F, political interference in the South African Police Service, and you deal with it from paragraphs 82 onwards, 82 to 109. I want to ask you specifically about the allegation that in relation to crime intelligence, the appointment of Richard Ndluli, which is at paragraph 92 of your statement. You allege that the process followed by the late Minister, Nadine Tetwa, fell outside of established practice. You allege that the late Minister had failed to present a submission to Cabinet for the appointment of the head of intelligence, which you allege was the practice at the time.
Maybe, Chair, I have difficulty with the word of the use, and you'll have to pardon me. I'm not Lesotho by birth, so English may be escaping me at times. We are on political interference. I'm saying in my affidavit, and before we move to that 84, it's sitting on paragraph 92, it's sitting on paragraph 84, and I'm going there to answer the specific question. We must not shy away. Political interference has been prevalent in the South African Police Service, and it became more prevalent following the 2007 Polokwane conference, where many of these things that leads to where you are taking me happened. Because from there on, we started seeing practices that were not the norm. I'm the last person to be appointed following a submission to Cabinet. Everyone else that was appointed after my time, that process did not follow the Cabinet process. And where it started, the post of Divisional Commissioner Crime Intelligence became vacant. That is after the departure of Commissioner Lala, Ray Lala, he went to detectives and that post became vacant. General Mpero, Assistant Commissioner Mpero, was acting Divisional Commissioner, Crime Intelligence. And Commissioner Tim Williams was the acting National Commissioner. That's following the departure of the late Commissioner Selebi. I was the Divisional Commissioner, Personnel Services, which means my portfolio related to managing the human resource portfolio of the South African Police Service. That post was advertised, the crime intelligence post, and there was a process followed. First, because there were two phases. There was a recommendation made. That recommendation could not fly, did not go ahead, because the new administration came into being. It is there that General Mpero experienced issues, and he subsequently prematurely left SABS because of issues relating thereto. But the point I'm making there is that it is even in the, if you go and look, I think I made reference to it, to the 2020 protocol of the Department of Public Service and Administration, that when posts at the Deputy Director General level are being filled, the recommendations will be submitted through the minister, the executive authority of a department. It will be submitted to DPSA. DPSA will do the screening and everything that needed to be done. From there, they prepare a memorandum which will serve before Cabinet. And Cabinet will consider those recommendations. And once we have Cabinet approval, it will revert back to the department and an appointment will be made. So in this case, the acting National Commissioner, being Commissioner Williams, was excluded. He called me in, and I had to sit together with the minister and other ministers who constituted the panel. The only official was is the current ambassador, I think is it the UN or Netherlands, Advocate Vusi, I just can't remember the...
Netherlands.
Sorry, is it Netherlands? Matonzela. It was Advocate Matonzela. He was the only official that was who formed part of the panel. That panel was chaired by our late minister, and I think there was the Minister of Home Affairs, State Security, and our Deputy Minister initially said only on the shortlisting, but not on the panel itself, the interviewing panel, because I think he had transport issues from Joburg to here. So that recommendation was made. And again, it's not an allegation, it's a fact because it's done by me. A memorandum was put together, submitted to the minister. From the minister, it went to DPSA. In actual fact, it went to DPSA a day before Cabinet was sitting. The morning when Cabinet was going to be sitting, I got a call from the Office of the Minister of Public Service and Administration to say that submission is to be returned so that the appointment can be made. There is no need for it to go to Cabinet. The reason why that position was taken was to say only the president appoints the national commissioner, and the minister later was the one who appointed the head of the Hawks according to the revised Act. So That appointment was made without cabinet approval, and it became the norm since. Now, I was speaking to that issue because, again, when I was listening to the proceedings, somewhere there was reference to you wake up one morning and somebody is a lieutenant general. Or maybe the process that is followed in other departments must be followed. My position is there's absolutely no need to reinvent the wheel. The process is already there. The National Commissioner appoints a panel, chairs the panel. If it is a divisional commissioner, in other words, a lieutenant general at head office, a nominee will be ordinarily the deputy minister of police became a member of the chair. If it is a provincial commissioner's post, the Constitution and the Police Act say a member of the executive council of the province will have a sitting. So ordinarily, the premier will nominate whether it's the MEC or a designate of the provincial executive who sits on that particular panel. And then the recommendations are made, and then you follow the same cabinet process. I don't think it's a process that must be, invented. It's already there. It's a question of making sure that there is alignment. And in actual fact, if you look at what we call a national instruction, that national instruction was never changed to factor in, the other provisions that are not consistent with the law. So that's in short on that part of it.
So why and on what basis do you, other than having problem in inverted commas with the process that was followed or the procedure that was followed, why do you put it under the heading of political interference in the South African police? What was Richard Mluli not qualified for the position, or is he qualified, or was he qualified for the position?
Okay, let me respond. I don't have a problem. I'm presenting facts here as to what obtains in the South African Police Service. What was the situation before? What is the situation now? And when did that situation change? Even in my affidavit, you will have read, I say, there's absolutely nothing wrong with General Mluli. In actual fact, General Mluli was one of the most competent investigating officers. The Buremach case that was in court, amongst others, was the work of General Mluli with the team when they were in the Northwest. So I can't blame General Mluli for having participated, like any applicant, he participated in the process. That process was changed, and the decisions were taken. Now, it's a very strange question. Why do I put it under political interference? I'm told the minister's letter is political interference to say operations. It's the minister then was a politician who happens to take over and chair a panel without a national commissioner. That process squarely belongs to a national commissioner of the South African Police Service, not the minister. Only two people are by law to be appointed by politicians, and that politician is the president and the minister in respect of the head of the Hawks. So if it is wrongly placed there, I don't know where it belongs.
No, I'm not telling you. You placed it here, like we've done before.
Advocate, may we please take Honorable Sangone.
Thank you very much, Chair. Good afternoon to yourself, honorable members. Thank you for accepting my apology. Good afternoon, General. No, mine was just a clarity-seeking issue on the memorandum you sent to DPSA. Can you just explain that? Who returned the memorandum? Basically, who said the process has changed, you don't have to go to cabinet? Thank you, Chair.
I'm speaking under correction because it's long ago. But I think the person who called me was the spokesperson of the Minister of Public Service and Administration. At the time, the minister was Minister Baloyi. And what came to me was there was a conversation between the Minister of Public Service and Administration and our former late minister. And I also spoke to the minister because when it came, when that call came, somewhere I was expecting cabinet approval. But then the minister said, no, there were discussions. And following those discussions, this is the position. We can go ahead and announce the appointment.
Sorry, Chair, not to blame. No written instruction. It was just a conversation. Thank you, Chair.
We can proceed, yes.
General Phahlane, you put this issue of the appointment of General Mludli under the heading political interference. That's why I'm asking you. I'm not making things up. So, is this, because it sounds to me like it was the case, is or was this an irregular appointment? In other words, some procedure or process, either statutory or by protocol, was that not followed in this case? Or was it a case of an executive authority overreaching and using or abusing that authority to make an appointment for political reasons? Can you clarify that for us?
Chair, that part of an appointment made for political reasons, I'm not going to respond to it because I don't know. All I know, which is what I have already said, was that there is a set process. And that process was the National Commissioner advertises, the National Commissioner appoints a selection panel, the National Commissioner makes a recommendation, those recommendations are forwarded to DPSA through the Minister of Police. They are being signed off, go to cabinet, come back, an appointment is being made. So I'm not going to dwell into whether it was irregular or unlawful. I'm saying the law, I just said the Constitution say only 2 police people are appointed by the President. First, the National Commissioner. 2, the head of the Hawks. I'm now talking about the South African Police Service. There is no provision for a minister to put together or chair a panel, whereas in this case, you did not have even the National Commissioner. I was not there as a panel member. I was there facilitating the process. So I'm not going to take it further than what it is. All I'm saying is that this is what the law is saying. This is what the rules of the game is saying. And that's why I say I make reference to even the 2020 protocol, DPSA protocol. I think I'm making reference to it somewhere in this affidavit. I'll find it and talk to it later.
Sorry, are you?
I'm not looking for it now.
Okay.
I'm
So-
allowing you. If I
so
find it, I'll come back.
It sounds to me that this, what you are saying under this heading, that this appointment was unprocedural. You said in your evidence that you don't have a particular issue with Richard Nduli, and in fact is qualified as a police person, police officer.
Well, I don't have issue with General Mdluli. He may not have been in crime intelligence before his appointment, but he was appointed there. He did not appoint himself within crime intelligence. So whoever makes noise about him being the Divisional Commissioner of Crime Intelligence, they've got reasons for them making so. But as a fellow colleague, as someone that has done work for years, I can't take away anything from him in as far as a manager and an investigating officer or a commander of investigations are concerned. I'm not going to dwell into other things that are being said about him. They are outside my scope. But he's a fellow officer. I actually trained with him when we were on officers' course here in PAL way back in 1993.
There's two reasons why I...
Honorable Sokanyile.
Thank you very much, Chairperson. General, I wanted to check on the issue that you are raising, where the panel was chaired by the minister. That's an anomaly. Then after that, because there are working relations between the head of the administration and the political leader within that department, then the working relations, if you want to have a sound department, there must be those working relations that are sound. Did you raise it with the minister, this anomaly, so that it is not referred to as a precedent? Because it's an anomaly as you are raising it. Did you raise it with the minister, or you simply kept quiet, or the relations were no longer good? They were sour between the minister and yourself.
Honorable Chair, maybe, Honorable Member, let's not make a mistake. I was not the National Commissioner or the Acting National Commissioner at the time. The Acting National Commissioner was Commissioner Tim Williams. I was the head of HR, and I report to the National Commissioner. That is why when he could not sit on the panel and he was not happy with that process, he said to me, just facilitate this process. But as to what deliberations were there between them, I'm sorry, I can't assist.
Management meeting where the heads sit, who never spoke about it.
Management meetings where the heads sit, well, that's why I'm talking about it. It's something that I never kept quiet about it. It's something that we have raised. I was the head of HR, and while I say, and the reason why I was putting this is, if we say there is political interference today, let's not narrow it and say this is political interference. We can't be selective. It's about how we manage, because what we must understand always is that there is a close relationship between politics and policing, because politicians are governing. When politicians are governing, we as police or administrators, we implement government policy, government decisions. So it's a decision that was taken where it was taken, and we follow suit in terms of implementing. There was really no need to cause hullabaloo in this regard.
Are you fine, Honorable Sokanyi? May we proceed, SC?
Thank you. The reason why I asked you, General Phahlane, is the three. Firstly, you raised the issue of the appointment of Richard Ndluli under the heading of political interference in the context of you, in your words, saluting Lieutenant General Mkhwanazi by taking the country into his confidence and saying that the issues raised by him was because of political interference in the administration and operations of the South African police has been prevalent for years, especially post the African National Congress Polokwane Conference. The second reason is that you use at paragraph at paragraph 92, the second last sentence, you talk about, I encountered, and your words, glaring political interference in this process of filling the vacant post of Divisional Commissioner of Police. And then thirdly, your reference at paragraph 90, where you say that during the tenure of Commissioner Tim Williams, the post of Divisional Commissioner Crime Intelligence became vacant. Assistant Commissioner Mhlangi Mpego, who was for years served in various capacities in crime intelligence, was appointed for over a year as the acting Divisional Commissioner Crime Intelligence. The vacant post of the Divisional Commissioner Crime Intelligence was advertised. Mpego, together with others, expressed their interest and applied for the post. The candidature and recommendation of Assistant Commissioner Mpego was questioned with some underlying political undertones. The discomfort with the recommendations and candidature of Assistant Commissioner Mpego resulted in the post being withdrawn and re-advertised. So that is the context in which I ask you that question. But today, with respect, we get some sanitized answer that actually, yes, I'm using the word sanitized. And I'm inviting you to expand on your answer, because it seems as if this is a procedural irregularity that the late minister, may his soul rest in peace, had used some other procedure for the appointment of Richard Ndluli.
Chair, I don't know what is sanitized, and this is where I've got some difficulties. I've already, while Council started by moving away from the beginning of this F, I took you back there to say, let me take you back and do. So there is no sanitization here. The issues which are in here stands unless we go verbatim on what I've written, which is, I'm glad to talk about. In paragraph, let me first talk about the General Mkhwanazi statement and why I say I salute him. General Mkhwanazi went public on issues which are of national importance. And when he went public, that was not the first time that he's raising those issues. I know he said he was in Parliament, I think once or twice, on the related issues and so on. Nothing happened to those issues until he went on the 6th of July 2025. Here we are. We have got an Ad Hoc Committee. We have got Madlanga. Could it not have happened after the March parliamentary sessions? Even worse, if the National Commissioner did not agree with the decision of the minister, why did we wait until Parliament? Because this is within the ambit or area of responsibility and the mandate and scope of the National Commissioner, where we could have assisted the process by saying, hang on, Minister, I think we are now a step too far in respect of this, if that was the case. So it did not have to wait until March, it did not even have to wait until February. But I'm putting it here, General Mkhwanazi said it before the committee, that he had deposed an affidavit he wanted to go and speak at the Zondo Commission of Inquiry. I'm saying the same here, that I had an affidavit. On these issues of McBride, O'Sullivan, and so on, I was called to the Portfolio Committee on Police on the 16th of May 2016. Nkabinde raised these issues thereafter. If you go 16th of May 2016, fast forward, I get to the point where I'm told I must go and sit home. Who addressed the issues that were there? If they were addressed, we will be talking a different story. Counter investigations and so on flew. So it is on that basis that I'm saying General Mkhwanazi did the right thing by speaking on the issues that are of serious concern. And here we are, we have got the platform at least to address it. If the commission or the inquiry that was recommended by Judge Zondo was in place, maybe these things would have been ventilated there. He is not the only one who would have wanted to go there. These issues would have been raised lately in that platform. Chair, am I talking to myself?
We are here, General.
No, I know you are listening, but
No. You are appearing before the committee. You are not appearing before.
So I must not worry about
you. Not appearing before Advocate Arens.
No, it's fine. I just wanted to hear. I must not worry about their conversations.
No, nobody says you must not worry.
Okay.
What we are saying is that you are not appearing before Advocate Arens. You are appearing before this committee.
All right. Thank you, Chair.
Yeah. Yeah. Mokhalaka.
And Chair, to be fair to the SC, sometimes when SC ask him questions, he will be busy looking at the documents while the SC is speaking. It happens in this kind of proceedings. So we must be patient with each other here. And like you said, it is not the SC's committee, it's our committee. We're listening. Yeah. And we're taking everything into consideration. So SC has to be consulting, because if he asks us to adjourn and then he speaks to his colleagues, when are we going to finish? These colleagues of the SC, they're not here for the sake of being here. They need to help him. And when he's paying attention, it looks like he's now being treated unfairly. It's unacceptable what is happening to the SC. It's not done.
General Phahlane. When Advocate Arens speaks to his colleagues, who are young African female advocates, who in the history of this country never had an opportunity to be at this level. We want male South Africans like yourself to appreciate and marvel at that moment.
For the sake of progress, Chair, I'm here, I'm just a witness. All I'm saying is that...
Not for the sake of progress.
No, for my sake.
That national consciousness is what we want.
No, that I agree with, Chair, but I'm saying, earlier I was answering a question, and then I could see I was not followed. The same question was being repeated this thing that I was
No,
talking about.
it's
But
fine.
it's okay.
It's
Chair.
fine.
It's
Listen,
okay.
General, the members of the committee are here.
Okay.
If you listen to what Honorable Malema says, we are here, all of us. And that is why you see from time to time they come in and ask questions for clarity. And there were moments where they also allowed you to move your chair back to get counsel there. And you also said it by your own mouth that I'm speaking to learned people here. So let's have that tolerance. It's our meeting, all of us who are having a conversation with you. And for sure, up until now, you can see that there are no adversarial interactions in this meeting. So let's proceed in that spirit. We are going to break at 17 hours. The next break is at 17 hours. We can proceed. Honorable Breitenbach. 10 on the econ. Okay. Bonani, you heard that. Yeah.
But Chair, you know there is a tendency of sleeping. Please turn on the air concept before they sleep.
Yeah.
You know the air has a tendency of sleeping at work. So they will sleep if you don't turn on the network.
Listen. No, Breitenbach, wait, let me respond to that. You know, I said this and it's not 10 minutes ago. I said the year is still very long. We are still in January. Yeah.
Do let me respond. Even when we're asleep, we're better than him.
You still have many weekends coming and many days. We're just on the 14th day of the year. So,
Yeah, Chair, Honorable Breitenbach is carrying a very fun object there. Can we check if that is not a grabber?
Honorable Breitenbach, that object is not funny. It's not a funny. He says you are carrying a funny object. Yeah, that is the difference between the young and the old. Advocate Arense. Can I check, are we ready to proceed, or you want me to extend the time of the members?
Thank you. May I proceed, Honourable Chair?
Okay, thank you so much.
Thank you. Also under this heading of political interference, I think we're moving off the issue of Ndudli, and that I think you've given your response to that. You also allege under the heading of political interference the role of IPID, also especially under Mr. McBride, Matthew Sissoko, and Colonel Rulofse, and I'm reading from your paragraph 83, whom you allege implicated you based on falsehoods and fabrications by peddling and processing endless and malicious allegations directed towards you and your family. And you say you want to use this opportunity to deal with some of these issues.
Sorry, SC, you said it's paragraph?
Paragraph 83.
80?
Paragraph 83. It's under item F, political interference.
Yes,
Page 32.
I'm on it.
Yeah.
Just like him, I had submitted an extensive affidavit to the State Capture Commission detailing the capture of IPID and the egregious onslaught by McBride, O'Sullivan, and their accomplices to capture the South African Police Service. Following receipt of my affidavits and consideration of my submission, I was granted leave by the chairperson of the Commission of State Capture for my legal team to cross-examine Mr. McBride, Mr. Matthew Sissoko, and Colonel Rulofse, who implicated me based on falsehoods and fabrications by peddling and processing endless and malicious allegations directed towards me and my family. I'll take the opportunity to deal with some of the issues in an effort to give the Ad Hoc Committee and the public my side of the story. This issue is extensively traversed from page 48 onwards, and it is an issue that even Cedric Ngavinde spoke to this committee on it. So my suggestion, Chair, I'm not here, I was just introducing the issue. The issue is part of paragraph G from 48 onwards. For the sake of not dealing with it haphazardly, I'll suggest that I respond to it when I get there.
Okay. So can I draw your attention to paragraph 128, which is on page 38. 58, sorry.
Maybe when we talk numbers, can I just be told which numbers, the bottom or the top? Because
58 is the one at the bottom, is the page number of your affidavit, and
Okay.
128 is the paragraph.
128, yeah.
Yeah. That was on 14 to 21 May 2017. You were invited with Mr. McBride to a portfolio committee meeting that would deliberate on the alleged interference by the SAPS on IPID investigations into SAPS officials, including you, including me. Well, you. Thank goodness, not me, you. For ease of reference, you annexed JKP 20, which is at 409? 420 of the annexure bundle.
JKP?
JKP 19 is at 409 and 20 is at 420. Is this 19? Have you got it, General?
I have it.
Complaint by, this is at page 247. Is it 247?
No, Chair. For the sake of me not losing it, reference is made to JKP 20. Let's deal with JKP 20. JKP 20 are the invitations that I had received. It's emails. The date is, you'll see the middle. It begins with, good day, Colonel, attached, blah, blah, blah. It's from my secretary. And the person who's down there was Colonel Kevin Stein, who was our parliamentary officer. But the bottom line on this is on page 257, that same annexure, I think it's JKP 4, 257. At the bottom of it, it's written there, the Committee on Police would like to invite you and the Executive Director to a meeting. Why this was important was that when we were at the Portfolio Committee, I was accused to be the one who dragged McBride to the Portfolio Committee. I never asked for McBride to come to the Portfolio Committee. If IPID was doing their work, they're allowed to do their work. If they're investigating me, they're allowed to do the investigation.
Let's just get to the committee.
Sorry?
Let's just get to, you are now in the committee, not about who dragged who to the, you would obviously not have been before the Portfolio Committee if you hadn't been formally invited by the committee to appear. You are now asked to appear jointly with Mr. McBride. So can we just get to that?
But that's where I am. I'm saying, and it's not me who went to JKP 20. I'm saying, there where you were reading, there is JKP 20, and I'm explaining what JKP 20 is. I was invited to go to the Portfolio Committee. That's why in 128, the first paragraph, you read about where I was supposed to have been. I was supposed to have undertaken an official trip. It's not me who's reading, it's the council who's reading. And here, I'm now just explaining further to say, there is in JKP 6, the letter from Parliament, which simply say to me, because of your invitation to appear on the 16th of May, you can't be undertaking that official visit. You have to come. And I acceded. But I'm saying to you, we were already in the committee. I'm being accused in that committee to say, I am the one who dragged McBride there.
Now, in that meeting, the complaints by pop crew members and Paul O'Sullivan are referenced. The allegations are the following: irregularity relating to procurement at the forensic division and the oversupply of equipment, centralization of delivery equipment, defective equipment supplied, questions about delivery of equipment by the same service provider to provinces, corrupt relationship with the service provider, inappropriate social relationship with the service provider, and members raising concerns relating to the above were removed from their general post by General Phahlane. And over the page, IPID received the complaint on the 25th of February 2016, and General Phahlane was informed about the complaint in writing on the 18th of March 2016 by the then acting head of IPID, and was acknowledged by General Phahlane on the 9th of May 2016. There was seemingly no investigation or movement relating to the investigation during the period whilst Mr. Khomotso was acting as the Executive Director. The complainants approached the Executive Director and raised concerns about the lack of progress made on the investigation. The Executive Director then appointed a team led by Mr. Mandla Mashlangu to investigate the allegation on 1 November 2016. Upon the establishment of the team, witnesses were identified and interviewed and statements obtained. Just to interpose, and hopefully we can agree on this, General Phahlane, maybe for the first time today, just to provide context. At the time when the complaint was lodged, Robert McBride had been placed on suspension, and Mr. Khomotso was appointed as acting Executive Director. When Mr. McBride returned, this complaint that was lodged was then revised or revisited, sorry. So just to continue, soon after the investigating team started the investigation, The investigating officer, the complainant, as well as the executive director, started receiving death threats by means of text messages. The investigation established that on the first threat, the phone used to send text messages was linked to a police officer based at OR Tambo. The investigation also established that the second threat was made from a phone that received reception from 3G SAP's Intel tower. When General Phahlane became aware of IPID's approach to witnesses, he contacted witnesses and instructed the witnesses not to cooperate with the IPID investigators. IPID then opened a defeating the ends of justice case in November 2016 as the Camel Drift case. General Phahlane then made public statements on several media platforms that he's going to establish a team to ostensibly investigate security breaches. Instead of approaching SAP's protection services for the alleged security breaches, General Phahlane appoints a team from Northwest under General Mabula to investigate the so-called security breach. The team he appointed is a team that is under investigation by IPID for various offences, including murder, torture, assault, defeating the ends of justice. The DPP has already decided to prosecute them on the torture cases dating back to 2010, and warrants of arrest were issued. IPID is awaiting the DPP decision on the centralization of the above matters. Mr. Paul O'Sullivan and his assistant, Ms. Jane Trent, were charged for, amongst other charges, impersonating an IPID investigator in terms of the IPID Act. The Mabula team then started interfering with IPID investigations by interviewing IPID witnesses which had already deposed statements to IPID relating to the General Phahlane investigation. The Mabula team also unlawfully arrested one of the complainants, Mr. Paul O'Sullivan. Advocate Mashuga issued the warrant of arrest. The Mabula team obtained a search warrant against the complainant, Mr. Paul O'Sullivan. The investigating officer, Brigadier Nkube, in the application for the search warrant indicated that the threats from Mr. Paul O'Sullivan started on 12 February 2016. However, the case of intimidation and other charges was only opened in January 2017. It would appear that there was never a concern about the threats or the IPID investigation on General Phahlane until the Executive Director appointed the IPID investigating team and the investigation against General Phahlane started in earnest. General Phahlane instituted civil action against IPID and the magistrate who issued a search warrant, not seizure, to General Phahlane's property. The civil action is at state expense. General Phahlane unlawfully obtained Section 205 applications by IPID from the Magistrates Court file, which was not related to the search and to which he was not entitled. It is a shocking abuse of power that General Phahlane now has access to the IPID investigative information and would compromise the investigation, as the details of those subpoenaed in terms of Section 205 of the Criminal Procedure Act is now known to him. It is possible, just as IPID members have received death threats, that these witnesses may be intimidated or have their lives threatened to ensure that they do not cooperate with the IPID investigation. The Mabula team charged IPID investigators, Mr. Mandla Mashlangu and Tamani Binang, on charges related to the investigation of General Phahlane. We have since learned that they have now opened a case of intimidation against the Executive Director as per Pretoria Central, and the case numbers there. This Mabula team come to Gauteng with the sole purpose of countering the investigation against General Phahlane. We have received information from reliable sources that the Mabula team is now actively involved in countering investigations against them related to the murder and torture cases. And we have since opened another defeating the ends of justice case at Pretoria Central. IPID views this interference with his investigation by General Phahlane and General Mabula's team as detrimental to IPID's independence and offends the legislature's objective about IPID Act, provided for in Section 2 of that Act. Any investigation by any member of the SAPS against IPID investigators, because they are being investigated by IPID, defeats the whole purpose of the independent oversight of SAPS as provided for in Section 206 of the Constitution, confirmed in the Constitutional Court judgment, and is a clear conflict of interest. Officers who are subject of IPID investigation should be allowed to investigate IPID as they are conflicted. The actions of General Phahlane and General Mabula's team are in conflict with the stated intention of Parliament and the legislature in creating IPID. This conduct is criminal and undermines Parliament. The will of the people of South Africa as represented by Parliament is also undermined. IPID has instructed its legal team to issue letters of demand to General Phahlane and General Mabula to desist from interfering with the IPID investigation. Failure to comply will result in IPID approaching the High Court to interdict them. And in due course, I'll get to that case that was brought in the High Court, and a judgment was handed down. We have written to the NDPP raising concern about the summons against our investigators on charges related to the investigation of General Phahlane and perceived collusion by some prosecutors in assisting the Mabula team to interfere with the IPID investigation. IPID is convinced that it will be in the interest of justice for General Phahlane to be suspended or put on special leave to allow IPID to continue with the investigation without any interference. Amendment to the IPID Act must also address this issue to discourage any future interference. This is the annexure which you fairly, General Phahlane, has attached to your affidavit and your response.
I must now respond to what you were reading. Chair, must I respond? My response, if I'm allowed to, is well captured in the documents, in the minutes of Parliament, JKP 23, dated 16 May 2017. Because that is the day that we were in Parliament and that presentation was made. And that response is well traversed here. But I will go and politely read some of the issues that I'm referring to in respect of JKP 23. And I'm going back, page 58, paragraph 129. I'm trying to make it easy so that I just capture the facts. 129, the following day, 11 May 2017, Mr. Francois Biekman, chairperson of the Portfolio Committee, addressed a response to my letter of apology to attend a meeting of 16 May 2017. The letter is annexed here to SJKP 21. Upon receipt of the said letter, I rearranged my trip and duly attended. On 16 May 2017, I went to the meeting prepared and armed with a comprehensive presentation that will give a detailed account of the very same allegations presented by McBride. I annexed here to marked JKP 22, a copy of the presentation that was made to the Portfolio Committee in the presence of McBride. My appearance before the Committee on Police was to respond to the same allegations made by Robert McBride during his previous appearance on 4 May 2017, where I was not present. Robert McBride alleged that it was unprecedented for him to have been called to the committee to account on investigations against me in my presence while he was the initiator, the author, and the narrator of the script. I say so in my affidavit. It was during the said meeting that I characterized IPID as a captured state institution by Mr. Paul O'Sullivan. I opined that it was O'Sullivan Police Investigative Directorate, OPID. I annexed here to marked JKP 23 a copy of the transcribed deliberations recorded by PMG, a service provider rendering recording services in Parliament. I annexed here to mark JKP 24 a copy of the minutes taken by a committee officer of the Portfolio Committee. It is here where I pause and take the nation into confidence on Robert McBride's war waged against me, his well-orchestrated campaign through the media, with Paul O'Sullivan on various platforms under the pretext of fighting corruption, systematic corruption, and maladministration. It is apt that I deal with the overview of the allegations made against me, and when necessary, I will annex relevant document to substantiate my submissions. 134. Robert McBride must indeed be credited with having learned exceptionally well from his masters and handlers in unleashing a propaganda machinery on a target and in being relentless in his efforts to cause harm and reputational damage to those in his sides. The stratcom that was waged against the struggle seems to be what he admired, and he did not let an opportunity to pass without him applying such to his benefit. I salute Robert McBride in this regard, this despite the pain and hate directed at my person and the character assassination I endured. I had never met Mr. McBride in person until Saturday around midday during April-May 2016. Like you said, SC, April-May 2016, when you say he was on suspension, it is true, but he was under suspension from his post as executive director of IPID. When I was surprised by his presence outside my house in Sable Hills, the very famous McBride O'Sullivan playing field. I was with a fellow resident, Mr. Yuan Smith, may his soul rest in peace, who visited me to discuss matters related to the Homeowners Association. When I walked him out, he mentioned a person he was expecting who happened to be Robert McBride. It was here where Robert McBride came out of the driving seat of a white E200 Mercedes-Benz vehicle in which he was driving with a female passenger. We exchanged greetings. Mr. Smith allowed us space to briefly engage without any interference. At the time of this unexpected meeting, the media was running articles and stories by Pop Crew and O'Sullivan's allegations of corruption leveled against me. You will have noted as part of the records that twice on the 30th of June 2017, the late Judge Monama ruled in my favor on a civil litigation against the very same Pop Crew members. Recently, on the 5th of November 2025, the full bench ruled in my favor on that particular litigation. And it was found that the allegations made against me were baseless, and thus they are to pay me costs, and they are to retract the allegations that were being made and tender an apology. So these are the same people that I'm being told they are witnesses in McBride's pursuit against me. O'Sullivan, for that matter, there is not a single case docket. Of all these concocted dockets, there is not a single docket which contains an affidavit by Paul O'Sullivan. not a single one. Now, we talk here about the period with Khamanyani, when he lodged that complaint. I know it's a thick thing. Those who understand law will realize that this person was just going to town about everything else. If you accuse me, come directly. Let there be the elements of crime in that particular affidavit. I don't know what elements of crime we were able to find. But Khamanyani appointed a team of investigators to investigate that particular allegation. Even if there was nothing direct on me. They went to O'Sullivan. Brigadier Khomo, who came back to the police, was one of the investigating officers. I think there was a Mr. Mahema or Marema, but there were 3 people who were investigating. They went to O'Sullivan and say, in view of this newspaper, which you say it's an affidavit that you have, can you depose a sworn affidavit so that we can investigate properly? To date, that was not done. On the day that McBride came back to office after his suspension, I think it was the 19th of November 2016, somewhere there around. That first day when he arrived in office, he called those investigating officers, they were in KZN. He called them back to office. When they arrived, the morning, by the way, I've got records there of from the Section 70. He had received a call and a WhatsApp from Sarah Jane Trent, who is an assistant or whatever of Paul O'Sullivan, who's asking him, McBride, where are you? And he say, I'm on my way to the office. This lady say to McBride, I'm on my way to bring a Phahlane dossier. This is McBride, who was on suspension, that came to my office. First day he rocks up in office, he gets from O'Sullivan the so-called dossier. The same afternoon, when those guys came back from Durban, he removed them from the investigation. He took the dockets. That was the birth of the Phahlane task team. So, in paragraph 137, during this brief engagement, Robert McBride told me he was aware I was under attack from people who did not want me to be in the position as I was in and the work I was doing. He mentioned that those people did not want us. Now we now happen to be in the same bracket. They do not want us good people, and they will do everything in their power to fight us. He further mentioned that they were using the media to attack and that we should be careful. McBride said, I should be careful of the Minister of Police, referring to Minister Nathi Nhleko, and the former head of the Hawks, Major General Ntlemeza, who were allegedly behind the attack on us. Robert McBride offered assistance and said we should work together in dealing with these people. Who are these people? I must work with him to deal with the minister and deal with Ntlemeza, who were trying to get us destroyed and replaced by people of their own. He also offered to work with his contacts in the media because media people wielded power. I listened attentively, we exchanged cell phone numbers and agreed to keep in contact as and when the need arose. My response to McBride was that there was nothing to worry about with the allegations made in the media, considering I had done nothing wrong. I indicated to McBride that it was important for the allegations made against me to be thoroughly investigated, for the truth to be revealed. Robert McBride and I parted, and he followed Mr. Johan Smith to honor their engagement. I was left in disbelief and shock. I have never shared this conversation with anyone other than my wife. That's what happened on that particular day. So, on the 5th of June, my wife and I were attacked by 3 gun-wielding men while at a spa in Duncanville, Johannesburg. I remain grateful to the Almighty that we survived the attack, even though we sustained some injuries during the unfortunate incident. Following the attack on 5th June at about 1934, the first person who called me was Robert McBride. Robert McBride sent me a text message via WhatsApp which read, "Just heard, sorry about that, let me know if you need help. Offer still stands." Which offer still stands? I responded at 19:30 to his message as follows: "Noted with appreciation, kind regards." That's where I left it. I was taken aback months later in 2017 when I found out that it was Robert McBride who obtained a copy of the CCTV camera footage and recordings of the attack, forwarded it to Paul O'Sullivan's assistant Sarah Jane Trent, and Peter Louis Mayberg, who circulated such via YouTube with distorted reporting to the media. Robert McBride returned to office as the executive director in Independent Investigative Directorate from suspension on the 18th of October 2016. So I'm going through this so that I properly respond to what you are reading, SC, because these issues are traversed. I'm not under trial on what McBride is saying. He must come and say his say. I am putting my version, which is important that it be communicated and not be brushed aside. The attacks directed at me by Robert McBride and O'Sullivan and their sustained campaign through the media, both print and electronic, bears testimony to their control of individual journalists whom they weaponized against me. A propaganda machinery unleashed by McBride and O'Sullivan was spearheaded by a select group of journalists whom I know, by the way, and I'll name them here if need be. Marian Tem is one of those people. Who was this? The late Karima Brown? She's one of those people. Abraham Mashiro is one of those people. Barry Bateman is one of those people. There is a whole list of people that, in one of the WhatsApps, actually, you have here the WhatsApp exchanges between Sarah Jane Trent and the late Mandla Mahlangu, who was the investigating officer. Even Karen Vaughan is here. So you have got a whole range of people that were working on the Phahlane project.
Were you done on the part that you were reading?
I'm not done, Chair, but I think I must respect the committee's time because he decided to go and read Robert McBride's allegations, and these are properly responded to. If I was here to be taken through my affidavit, these issues would have been traversed. So I'm going to pause. I can deal with some of these things when we come back.
Okay. It's now almost 10 minutes past 5. We are going to break and come back at 5:30. Advocate Arense and General
Chair.
Phahlane. I'm allocating you up to between 8:30 and 21 hours to conclude today's business.
Thank you. He says I'm better be short. I need a chief whip. I need to whip him into line. I think you were busy.
Thanks, Chair. Thanks, SC. I'm going to make it short. It depends on you, because I'm just going to focus on providing facts. If we discuss, it's another story. I was on page 62 of my affidavit. I spoke about, Chair, I mentioned some journalists. These are not the only ones. I'll have an opportunity to talk about some of them. I'll check if whether some of those faces are in this room. Those journalists involved are known from the recordings of conversations secured following approval by a designated judge in compliance with South Africa's regulation of interception of communication and provision of communication-related Act of 2002. In other words, following the investigation that was conducted by General Mabula, because of the threats directed at me and everything, an application was made to the designated judge to monitor specific conversations or specific numbers that were of interest. And this is where, unfortunately, some of these journalists were flying in and out. Graham Hoskins is one of them, I know. During the afternoon of Monday, 14 May 2016, I received a telephone call from Mr. 62, I'm on page 62, Mr. Frank Tereblanche, the building contractor, who informed me that he was approached by people who told him that they were conducting an investigation on the building of my house in Sable Hills. He indicated that 4 people, a white male, a white female, and 2 African males had approached him at the crèche in Sinoville where his wife was rendering services. The leader of the 4 identified himself as Mr. Paul O'Sullivan, who led the interview and questions in relation to the construction of my house. He told me that he became uncomfortable after realizing that it was a private person called Paul O'Sullivan who claimed to be conducting an investigation. I'm getting feedback. Is something wrong with my... Yeah.
Mr. Feedback, can we check if all the microphones are off?
It's always been here. Okay, maybe let me place it.
We don't suspect that there could be anybody interfering with your presentation. We don't have those suspicions.
Thank you, Chair. May I proceed? The leader of the 4, as a result, he called me to inform me and inquire whether it would be correct for him to disclose any information to private persons purporting to be conducting investigations. I cautioned him against providing any information relating to the building of my house to anyone who is not duly authorized by law to conduct investigations and receive my information without the required authority. I also received a telephone call from my driver, Captain Alvin Dupree, informing me that he had received a call from Freck with the same concerns directed at me. Mr. Tereblanche called me again on Wednesday, 16 November 2016, during the morning, informing me that the same people were back at his place in Sinoville and that he had chased them away. Later that afternoon, at 17:23, he forwarded a text message which he received from O'Sullivan's assistant, Sarah Jane Trent, via SMS, and that read as follows: Dear Sir, IPID investigation. By the way, Sarah Jane Trent works for O'Sullivan, is his assistant, but he's sending this message. I confirm that the case number CCN 20160-30085, a meeting is arranged for 11 o'clock on Friday at IPID offices, City Forum Building 114, Madiba Street, Pretoria, nearest corner Schubert Street. We have confirmed that your status is not a suspect. You are, of course, welcome to bring an attorney with you, if you like. We look forward to seeing you then. Regards, Sarah Jane. This is clear violation of the IPID Act, as a private individual cannot be involved in the investigation. This also ravishes the statement by Paul O'Sullivan denying any involvement by him or Sarah Jane Trent in IPID investigations. It was after the telephone call from Frick Tereblanche on the morning of Wednesday, 16 November 2016, that I called Mr. Chris Joste, the estate manager at Sable Hills, to establish whether any person could be allowed access to my house without my permission or making contact with me. This inquiry to Mr. Joste was informed by my conversation with Mr. Tereblanche, who indicated that Paul O'Sullivan and his entourage were at the estate and had obtained his contact details from the security manager, Freki. Mr. Joste responded later at 13:24 on 16 November to my inquiry via text message, which read as follows: General, 4 people arrived at the service gate from IPID. He wrote in his IDP, that's why in brackets there I've got IPID, as per business card, and said they were doing an investigation and that it was confidential. They inquired about the builder of your house. It was mentioned that it was Freck, and Frecky gave them Freck's number. That's how they got to the builder of my house. We were told that they wanted to see the drawings of your house, which were shown to them. After this, they phoned Freck and then left to meet with him. This text message was forwarded with a copy of a business card of Mandla Gaiza Mahlangu. May his soul rest in peace. He's late. He was one of those IPID Phahlane task team investigators. From IPID, as well as a picture of a white sedan, a Ford Kuga, with registration numbers, there they are, owned by Paul O'Sullivan, which include which vehicle the 4 people were driving in. I was in Limpopo attending a strategic session with members of the National Management Forum since Tuesday, 15 November at the time, 26 at the time. I had shared these developments and information with the then Divisional Commissioner of Detectives, Lieutenant General Kotsi Nkomo, and the former Acting Divisional Commissioner of Crime Intelligence, Major General Machele, for further processing within the scope of their work. On 16 November 2016, at 17:35, I forwarded a copy of Mahlangu's business card and a picture of the Ford sedan motor vehicle as received from Joste to McBride's cell phone with a message that reads: Good afternoon, sir. Trusting that you are well, it is noted with concern that the IPID investigators are accompanied by the person who lodged the complaint to gather and interview witnesses. Once again, a Mr. Paul was trying to get to the builder of my house, and then in the message I asked, ethical investigation is encouraged in this regard. He never responded to that message. That was McBride. While at the strategic session, a colleague of mine, Lieutenant General Ngwenya, conveyed a message that the former Major General Sibiya, who used to be working for the DPCI, the now Deputy National Commissioner, requested to meet with me and Mr. Robert McBride privately upon my return to Pretoria. I was persuaded, and the meeting took place in Centurion at Liriba Lodge on Friday, 18 November 2016, upon my return from the strategic session. It was during this meeting that I once again urged McBride to ensure that a thorough investigation must be conducted on allegations against me. I further cautioned him about the involvement of Paul O'Sullivan in the investigation. I made it clear during this meeting that I did not need any favors relating to the allegations made by Paul O'Sullivan. On Tuesday, 22 November 2016, in the afternoon, I received a call from Mr. Cedric Nkabinde, an investigator from IPID, who informed me that he was investigating a defeating the ends of justice case against me. The case number is there, Camille Drift, subs case 123 of 11/2016. The purpose of his call was to secure an appointment with me for a warning statement. I referred him to my office and informed my secretary that I had agreed to meet with him on Thursday, 23 November 2016 at about 1400 at IPID offices. This appointment was rescheduled to a later date because of more important matters which required my attendance. Thus, the meeting did not take place. On Thursday, 23 November 2016, in the morning, I actually was leaving the gym that morning. Peter Louis Mayberg sent me a text message which read, "Hi, General. This is Peter Louis Mayberg from News 24. I was hoping to get your comment on the IPID matter. I understand you have been asked to make a warning statement. Thanks." Around 9, the story was breaking news on News 24 and the national media. Despite the rescheduled meeting, because I was not going to be able to attend that afternoon meeting of the 23rd, which was already scheduled, because they were already gathered at the IPID offices, the media. The media covered a story headlined, "Phahlane no-show at IPID." I should also mention that without obtaining my warning statement, the case docket was processed to the National Prosecuting Authority for a decision premised on the lack of evidence. The NPA declined to prosecute. Another case, Sinoville case 146 of 5/2017. Now, this is important because this case, you will know that it was opened in May 2017. That is precisely after my appearance in Parliament to that meeting where this presentation was made by Robert McBride and IPID. Now, why is this of significance? Somewhere we are being accused of counter-investigation. There was never a case before the case which now appears somewhere, Camille Drift case 12 of 1/2016 or 2017, the one that General Mabula and them was investigating. So even when you go back to page 150, that paragraph, page 66, paragraph 150, what defeating the ends of justice was being investigated? Because there was no case. O'Sullivan had deposed a newspaper to IPID. I'm on 167, just above 152. Both Robert McBride and Paul O'Sullivan continued to peddle lies and disinformation that the vehicles were purchased for my benefit and usage by family from a supplier of service to the subs, Mr. Duran Snyman and his dealership, who has never rendered any services to the police. So, amongst others, I was accused to have 7 cars. Now, what they were doing, they went to obtain the records from the institutions who financed my vehicles. If I buy, I will, for example, have had a C-Class Mercedes-Benz, and then I go and sell it and buy an E-Class. To them, on their list, I've got 2 cars, a C-Class and an E-Class. I had the Land Rover Discovery 3, I buy a Discovery 4, I've got 2 cars. I sell Navara Baki, I buy an Amarok, I've got six cars. Now the car that they were mainly looking for, today, maybe when they appear here, they will. That is the car that was used, that I used that weekend when I was attacked in Duncanveld. It is a car that belonged to BMW South Africa. BMW South Africa, because the police buy vehicles and so on, from time to time, they bring cars to test drive so that they are being given feedback. So first, I was called by supply chain management. They wanted me to test drive an i3, one of those electronic BMWs, and I just did not have time. So it went back without me seeing it. Then they called and said, now there is an i8. I said, I'm busy.
I think you have given them enough advert. You can just say they called and promised a new vehicle. Yeah.
Thank you, Chair. Reality. But anyway, the car came. I drove it.
No, Chair, I was not interrupting. I wanted the General to conclude. I wanted to do a follow-up on this system of sponsoring from VW. Is there an internal mechanism for declaration of such sponsors so that no one is easily accused of having been given handouts somewhere or nicodemously? Is there an internal system? Here in Parliament, we even declare a power bank that so-and-so gave me a power bank for this reason. So do you have those, or did they have at that particular time, those internal mechanisms for declarations of such sponsors? Thank you, Chair.
Thank you, Chair. While this particular car was not a sponsor, it was, what they do, they will bring occasionally a vehicle, and it's not only this particular brand that I'm talking of, for test driving and so on, and those vehicles are returned. So, for example, I only drove that car, I think it was the Saturday and the Sunday. Monday, when I went back to work, my driver took the car to them. So, while it is so that there is a mechanism for declaring even sponsorship and gifts, this one will not have fallen into that category. And the other cars that I'm referring to, your Amarok, VW, and so, those are my personal cars that were bought. But to create this narrative of corruption and so on, they will say he has got 6 cars. And of course, if I'm to have 6 cars at the go, such high-end vehicles, you need to ask, where did the money come from to buy those? Unfortunately, in this case, if you go, they retrieve even the finances from the bank. You know, what is it? And we are entitled to a vehicle finance scheme. They retrieve the statements. One of the vehicles, at least 2 or 3 of them, actually, the payment of those vehicles was being deducted on a monthly basis from my salary, because I had what we call stop order. So the bank will pay the dealership directly.
Honorable Malam.
No, General, you're talking about trading in. You trade in this car, and then you use that money of trade in to buy another one. So they will now say you've got 2 cars. Instead of saying you have traded in the other one, use that money to buy another one. Is that my understanding? Is it correct?
Your understanding is correct, Honorable Member. So on the other, even if they see that this car was sold or traded in, and I buy this one, on their records they say he has got two, for example, Mercedes-Benzes, 2 Land Rovers, and 2 Bakkies. I don't have capacity for such. So, Nkabinde, I spoke about Nkabinde and the case, Sinoville case 14605, which is the one relating to cars. Now, when they did not find any of those cars, inverted commas, corruptly obtained, the Mr. Duran's name that they are referring to is a dealer who has got no contract, no relationship with the police. Me and him were establishing a relationship. In actual fact, he wanted me to be doing business with him. I said, I can't. I can't be doing business now because I'm still employed. Now, at the same time, there were community projects that we were doing. Our sponsor, for example, food parcels. There's even a house I built for Emuruti somewhere there in Kwamhlanga. And him hearing what I'm doing, he said, how can I contribute? So there were two cars, a Toyota Hilux, a Legend, and a Polo. Basically, those cars were not even sponsorships to me. They were sponsorship to the social, what do you call, for that social. But because I am taking responsibility, I'm to be funding the maintenance and fuel and even insure the cars when they are used. The agreement was for 18 months. And after 18 months, those vehicles went back to him and he disposed them. So those were the cars that I was dragged to court, myself, him, as well as my wife. And after 2-3 appearances, that case was struck off the roll. Having considered the allegations of Mr. McBride, I can state without any fear of contradiction that he has been less candid. Robert McBride is grandstanding, abusing his powers, including taking advantage of his position by deliberately withholding information or evidence that ought to have been placed before the authorities and in the public domain. That's exactly what I'm referring to. This information, they already had in their possession. He is using platforms created for our people to cleanse corruption in state institutions to the benefit of his self-serving gains. On 153 of my affidavit, a letter by IP dated 18 March 2016, signed by Khamayani in his capacity as the acting director, was received by my office at the time I was the acting National Commissioner of Police. The letter stated, IPID received a complaint from Paul O'Sullivan regarding allegations of tender irregularities and irregular appointments. Paragraph 3 states, you are requested to arrange a suitable date for investigators to meet with you to discuss these allegations. For ease of reference, I annex that as JKP 25 and JKP 26 for copies of the letters referred to in that paragraph. This letter addressed to me in my capacity as the acting National Commissioner of SABC indeed informed me about the complaint in writing. However, it did not disclose who the subject of the investigation was. Upon receipt of the letter, 9 May, I instructed my personal assistant to schedule a date for the requested meeting with IPID. An impression was created by McBride that counter investigations were embarked upon and there was no threat conducted that necessitated the appointment of a team to investigate any alleged unlawful activities detected through a threat assessment. McBride continued to attack my integrity and character, amongst others with the distortion of facts well known to him that I did not appoint a team from the Northwest to conduct the investigation against his ally, Paul O'Sullivan and Sarah Jane Trent. Chair, in this affidavit, I think you'll find JKP 28. That's General Mabula's affidavit. This is the affidavit that served before Judge Zondo where he was testifying in this regard. And I'll refer to paragraph 8 of that annexure, if maybe you assist where in the bundle it is, but it's JKP 28. General Mabula in his affidavit say, during November 2016, as a result of suspicious conduct of Ms. Trent and Mr. O'Sullivan at a residential complex, Sable Hills, where Lieutenant General Phahlane, the then acting National Commissioner, resided, Division Crime Intelligence compiled a security threat assessment pertaining to the security threat against the security of Phahlane. As a result of the threat assessment, the then acting Divisional Commissioner Crime Intelligence, Major General Machele, communicated that, do we have a page? 509. This JKP 28 is on page 509. Communicated with Lieutenant General Motsunyane in a capacity as the Northwest Provincial Commissioner to provide intelligence, crime intelligence with the capacity to investigate the security threat against Phahlane. This is important. Crime intelligence are not doing investigations. Their task is to gather investigations. It is for this reason that General Machele approached the Provincial Commissioner of Northwest for a team of detectives to conduct an investigation. Mabula continues, I was nominated by Motswenyane to communicate with crime intelligence and was from then on the lead investigator. The investigation was conducted under the auspices of the acting Divisional Commissioner, Crime Intelligence. I therefore state that my appointment to the investigation was lawful and rational. It was brought about by the unlawful conduct of individuals such as O'Sullivan and Trent, and I refer to hereafter. Council read in that presentation of IPID about the Mabula team. One of the allegations is that I appointed the Mabula team. There is evidence to that effect, which served even before Judge Zondo, that Mabula was appointed by General Machele following designation by the Provincial Commissioner of the Northwest Province. There is a part in this affidavit that I wanted to refer to, because I was hearing in testimony here people who deliberately forgot, but I'll find it. What happened, General Mabula, after receiving the tasking, after his preliminary investigations, he approached the DPP, Advocate Muzinyati in Pretoria, to table what he has found from the preliminary investigations. I just want to go there. Yes. It is that which I want to talk to is on page 519, paragraph 8. 8 at the bottom in General Mabula's affidavit. It says, my first port of call after receiving the security threat assessment briefing was to convene a meeting with the National Prosecuting Authority, the Director of Public Prosecution's Office, for the sole purpose of discussing whether the investigation relating to the threats against General Phahlane may not be construed as interference in IPID investigation. The team met Advocate Nemoarani and Advocate Andrea Johnson, and after relaying the facts of the earlier briefing of crime intelligence, they were unanimous in their decision that the investigation was lawful and we were given the green light to proceed. Brigadier Ngube and the rest of the team then proceeded with the investigation. The team met with aforementioned advocates of the DPP on several occasions and kept them abreast of the investigations. After perusing the evidence, Advocate Nemoarani and Advocate Johnson advised that a criminal case docket be registered. A case docket was then registered under Kameeldrift Case 12 of 1/2017, impersonating an IPID official in contravention of the IPID Act and intimidation against Paul O'Sullivan and Sarah Jane Trent. Advocate Mashuga was then appointed by Advocate Nemoarani to oversee the investigation in the offices of the DPP. It is to be noted that the team only functioned on an ad hoc basis, not stationed in Pretoria, Gauteng, as claimed by McBride. Now, this is important. During this committee's honorable members' hearings, there is a point where, because I was following these proceedings, Advocate Andrea Johnson was asked about Kameeldrift Case 12 of 1/2017. She played ignorance, yet she is part of the team of prosecutors that were assigned by the DPP to investigate this. We do know that at some point she disappeared from this case. But I also do know that she emerged on the other side, in as far as this investigation is concerned. I know even the National Director of Public Prosecutions, Advocate Batoi, when asked, she did not know about this particular case. And this is the case that Cedric Nkabinde was saying it is gathering dust there in the NPA. And I think it was Honorable Malema who was asking, why, if O'Sullivan is doing all this, is there no case opened against him? I think at some point it's a crime against the state and so on. If you look at the docket, it's something too serious. There are over 80 emails that hopefully were shared with the members of the committee are part of that particular docket. These Section 70 recordings that I'm talking of, conversations with journalists and everyone, including where are you going, them formulating, O'Sullivan drafting statements for people or applications for J50 or 205s. It's contained in there. So why that docket is being made to gather dust, I don't know. I know Council wants to talk to...
General, the case that you are making reference to is the case where Mr. O'Sullivan is alleged to have impersonated as an IPID official.
That's the case.
You want to take us through those details?
Yeah. In that docket, Honorable Chair.
I want you to help us, and I don't know if Andile is here. Listen to these details, Andile, because remember last week in our meeting, okay, let me say to you, the committee has written to the respective authorities to request details of these cases. And they responded to us. You might have not seen the response that they sent to us, but if you can just give yourself time and give us the information that you have about those cases.
Thanks, Chair. In this case was informed by this security threat assessment which was conducted by crime intelligence. And indeed, they did find that there is a threat. So the Divisional Commissioner of Crime Intelligence, as I said, then requested detectives who could do the investigation. But she opted not to approach the Provincial Commissioner of Gauteng or the Divisional Commissioner detectives, but approached the Provincial Commissioner of the Northwest for reasons known by them, so that, amongst others, they did not want to be told that these people in Pretoria, Gauteng, are privy to what has been happening. Therefore, they wanted a team coming from the Northwest. That's how General Mabula and the team, comprised of about 5 members, was appointed. I think the team was Brigadier Ngube, Brigadier Khorane, Colonel Reddy, and Lieutenant Colonel Daywood. So they did their investigation, and as I said, as part of the process, they approached the DPP and presented what they have found, their initial findings. That's where Advocate Muzinyati designated Advocate Nemoarani and Andrea Johnson to now lead the team, in other words, from a prosecution side. And after they were presented with what they were presented, they had several meetings. I know one meeting, I was told it was at a courtyard hotel, where they were told, that is now the investigation team, that there is enough here that constitute a crime. Because amongst others, when O'Sullivan and them were at my place, they wanted the building plans, but at that time, there was no case opened against me. They wanted the building plans, and I know when they went to the security,
there is a terrible feedback. I don't know if our sound engineers are able to deal with it. Yeah. Or you can also try the next
one
microphone.
Maybe, is it better? Okay. So that's how that case was opened. But when they were at my place in the estate, strangely they went to the security. And O'Sullivan wanted to know the following: what cars and how many of them are my protectors and me driving? 2, they wanted to know how many are they, what caliber of weapons do they carry, and the times, movement. What time do we come? What time do we leave? What time do we return?
When you are still there, how does he find himself in the mix? What was his role?
He's an honorary IPID member. Kabinde told you here that he's the boss. McBride reports to you.
Who was he with when they came to you?
When they came to my house,
Yeah.
it was Paul O'Sullivan, Sarah Jane Trent, an IPID investigator who is currently...
So they were with a recognized IPID official?
Yes,
But without them being IPID officials?
Yes, they were in O'Sullivan's private car, O'Sullivan being the driver, the passenger being Sarah Jane Trent on the, we call him a crew in police. So the passenger on the front seat was her, and the 2 IPID guys the late Mandla Mashangu, and the one who is now at IDEC, the Manivina, were in that car. So those were the 4 people that were in that car that came to my estate.
So in that, the 5 occupants of the car, 3 of them were recognized government officials.
Only 2, the Manivina and the late Mandla Mashangu. Sarah Jane Trent works for O'Sullivan, or worked for O'Sullivan, what is it, Forensic for Justice or something like that. They are together, they are private people. He's actually, if I'm not wrong, an advocate who works there.
No, you, okay.
Sorry,
Can
an
I-
attorney.
Just a moment, can I check with honorable members if there is any who may want to take a bite? I see Honorable Ngola.
Just a quick one, Chair. To what in the statement is referred to the Paul O'Sullivan and Torach. So are you saying one of the then recognized IPID officials is currently in the employ of IDEC?
It's correct. That's why I support General Mkonazi when he's talking about the rogue unit within IDEC.
Chair,
Imani Binang is a member currently, as we speak, of
Chair,
IDEC.
can I move that the committee be furnished with the name of the said individual? Thank you.
The witness hears you. What is the name of that?
Imani Binang.
Temane.
Temane. And the surname is Binang. Binang.
Binang.
Binang. I think it's a Motswana.
Thank you, Chair. Mr. Ramano will also capture that for the work of the Justice Committee as well. Thank you.
Honorable Matthys.
Thank you, Chair. Mine is just that whether the builder and the security personnel that were approached by Paul O'Sullivan and Sarah Trent and the crew, will they be agreeable to provide us with affidavits to support what it is that you are saying? They don't necessarily have to appear before us, but to support what it is that you're saying. Thanks.
Honorable Chair, Honorable Matthys, they have already provided affidavits. If you go to, there's an affidavit here of Brigadier Ngube, JKP 27. Maybe I can just be assisted because it's easier. My annexes are marked 484.
But besides someone in SABS, we're talking about those that were in your property. Do you have any, because I didn't see any supporting affidavits from the security personnel at your complex and also when they were engaging about the building plans?
Yes, Chair, that's what I'm referring to when I'm referring you to JKP 27.
I thought you said it's Brigadier.
Because,
Okay.
no, if I want to go to a page where the affidavits that they have provided, which are part of the case docket, are there. They are quoted, I think, in the JKP 484, page 484. Ne? There is here witness 1, what the witness said, witness 2. So I'm simply saying while they are not named, their affidavits are already in place in that case docket 12 of 1/2017. There is witness 1, 2, ways, for example, 1 say here, he deposed an affidavit under oath that members who were all alleged to be from IPID by one of them produced a business card not an appointment certificate. Normally, when you are an officer and you are asked for your identification, you can't produce a business card. You must produce an appointment certificate, not your DOMPAS or ID, appointment certificate. 486, 496. Yeah, in page 496 of the affidavit, there it is. And then witness 2, he deposed an affidavit that he met with the persons driving the Ford Kuga at the main gate and escorted them to the offices of witness 1. He was then requested to take them to the house. This is now the security manager, Freki, that we are referring to. Witness 3, he deposed to an affidavit that he stopped at the Ford Kuga at the service delivery entrance and was informed by the driver, Mandla. This is referring to the IPID official, Mr. Mandla Kaisoma, that they were from SABS and demanded entry into the estate. They did not even say they are from IPID. This is the person who was the security guard who was manning the boom. 4, he deposed an affidavit confirming that the registration number belongs to O'Sullivan, and even the affidavit of my driver is in here. And by the way, these affidavits are of my driver when he was approached by O'Sullivan were drafted by O'Sullivan and Sarah Jane Trent for him as if they were IPID members and they were expected to just sign. Nkawinde testified here that O'Sullivan had access to letterheads and they will draft affidavits for them and so on. So just to conclude, Chair, that...
So these are the events of 2016?
These are the events of 2016.
And who was the IPID head at the time?
McBride. Okay. Because this team, as I said, he went back to office after his suspension, the 18th of October 2016. It was on the same day that he took off the people that were tasked with investigating the O'Sullivan, and then immediately the Phahlane task team was established.
Can you say it again?
Sorry, Chair?
Just repeat the statement that you made. You said when he got into office, remember there was this Camille Thrift case that has been registered.
Yes.
And then you say that the people who were investigating it were taken off.
The people who were investigating the allegations made by O'Sullivan in IPID were then removed by McBride. And then following that removal, that's when he appointed the famous Phahlane task team. Now, if we talk about the Camille Drift case that we were referring to earlier, it's the case docket that was registered by the team of SABS detectives led by General Mabula. Sorry, I just want to hear.
Now you clarified it. Let me check with Honorable Matthys if she's satisfied. Oh, okay. SC. General Phahlane, did you still have a part that you want to talk to?
Yes, Chair.
When you are done, you will indicate to,
I will indicate
to the SC so that he can then lead you on the next part.
Okay, we'll do so, Chair. There is a part on 497 which it's maybe worth bringing to the attention of the honorable members. It starts on 496. I'm going to read what the parts of what witness 2 said. He was then also requested to take them to the house and was questioned about the security personnel responsible for the protection of Phahlane. Mr. O'Sullivan questioned the witness about the following security details of the Phahlane, to wit, how many protectors are deployed at the house, whether the protectors are static or mobile, what firearms are they carrying, and how many vehicles are they utilizing. And then the other one. In respect of number 5, witness 5, he deposed to an affidavit that the said Mr. O'Sullivan had a registered firearm on his name, a CZ 9mm pistol with serial number so and so. Now, it may be a question, if it does interest, how will he be issued with a firearm while he has got a criminal record? Secondly, why was his criminal record never recorded on the systems of SABS? Because there is a criminal case where it's a gender-based violence assault of his wife or something like that, which he paid even, what is it, an admission of guilt or a fine. How will such a case not find itself on the records and the same person has got a licensed firearm?
Honorable Nomval.
No, apologies, General, for interrupting you. So, when to become aware about this, about the news that these guys are in your complex? At what stage? Were you there? Were you inside the complex?
I was, Honorable Chair, I was not at home. I was in office. And that's why this happens. Remember somewhere I speak about me being in attendance at the strategic session in Limpopo. So I think it was the 14th, it started the 14th of November, 2016.
So when do you become aware? While they were still there, or when you arrived, the security told you that there are guys who were here looking for you?
I only got to know after, because the estate, not the estate manager, the builder called me. And I remember we were doing the launch of a festive season. I was in Komhlanga that day on my way to the strategic session, which was taking place from the 15th. So then the builder calls me and say, there were these people. And he had also called my driver, Alvin Dupree, to say, but there were these people, this is what they were doing. That is, he called me in the morning and he called me late. And then the following day he called. That's when I called the estate manager. And the estate manager responded in the manner that is reflected in my affidavit, confirming that, yes, they were there. So I knew immediately on the day that they were there, and progressively, as they were there, for example, they would have went to the Sinoville, where the builder of my house, his wife was doing business. They had a crèche.
So the intention was to search your property?
Not at that stage.
Not at that stage?
No, they were not searching.
Because I wanted to establish if maybe the case, your response was the opposite, if they had a search warrant.
No, on that occasion, I don't know of any search warrant. My understanding was that it was the so-called investigation which they were busy with. That is why, even when I text McBride and when I engage him the day that I came back from the strategic session with this meeting that was arranged by by
So
CB.
they ended by the gate, they did not proceed to your house.
They went to the house.
They went to the house
They
and there
went to
was
the
no
house,
one inside the
and
house.
pictures of my house were taken.
So the
Interesting.
house was locked, there was no one inside.
No, there were people.
Did they get inside?
No, not on that occasion.
Okay.
Not on that occasion. In actual fact,
Thank you.
where is my book?
Honorable Ngola.
Thank you very much, Chair. I think I missed the general a little bit. Who is the person who assaulted the wife and paid a fine of guilt?
Paul O'Sullivan. the
Paul
Honorable.
O'Sullivan.
Yeah.
But in the records, the criminal record register, there is no criminal record against him.
I happen to be the Divisional Commissioner Forensic Services. Criminal records are housed in the Criminal Record Center,
Yes.
which I am a custodian at the time. And
Yes.
they never reflected that he had the criminal record.
So did you pick up if whether it was registered and removed or it was never registered at all? You remember the issue of KwaZulu-Natal of Jerome Corners and the other police official giving the nation details about criminal records being removed from the register?
Honorable Member, I only got to know about that criminal case much later. I was already not in the system.
Okay.
And then, like you know, I've stepped aside.
Okay.
And I do not interfere with police records.
They come to your house, they ask you about cars, they take photos of your houses, they ask about your security detail, they ask about the ammunitions they carry, the firearms they carry. Did you not consider that a security breach that needs a serious security assessment by SSA?
Chair, that's why crime intelligence arrived at that conclusion that there is a threat against my life and that of my family. And it is on that basis that the acting divisional commissioner requested investigation capacity. And it is that precisely which General Mabula and his team were investigating. And it is following that investigation that they were arrested. Paul O'Sullivan, Sergeant Trent, Temani Binang, and the late Mandla Mahlangu. Later, because as the investigation progressed, that's when it became evident that there is a Phahlane task team. And McBride was added on that case, as well as one of the IPID members, who also, by the way, is currently at, IDEC, Rapesu. He was added.
So this is the second official that is at IDEC?
Yes.
Okay.
So they were added onto that case. Strangely, that case was struck off the roll at a point where McBride was added. And the reasoning behind the adding, the struck off the roll was, don't add people now. Go and obtain what? A racketeering certificate. That's the impression that was created, that there is a racketeering certificate that was what was going to be obtained. And that's where on the council will talk later, I know, about Judge Tuchten's judgment. Because that judgment, McBride and them went to court and they were alleging that there is counter-investigation. And that's when General Mabula and his team were removed from the investigation against who? Paul O'Sullivan, McBride, and everyone. And that case stalled because somewhere it was given to a lieutenant general who left. It was given to a major general who is currently an acting divisional commissioner. But that case is never placed back on the roll. That's why I hear from the chairperson whatever they have communicated. But
That's
that is the case.
satisfactory, Chair. Thank you very much. That was elaborate.
James, I can see a question on your face.
Yes, because I'm just getting some. General, you mentioned someone from IDEC. What was his surname? I'm just thinking back. I think we questioned Advocate Andrea Johnson on this person, and this person had a matter that was currently being investigated by IDAC, and he was actually given a position despite also having a record. And I think you mentioned the surname now. If you,
Honorable member, the people who are, there is more at IDEC, but the people who are directly involved in this matter, Matthew Sissoko, who's currently, I think he's the head of investigations in IDEC. He used to be the head of investigations at IPID. And there is a Rapesu,
Yes.
R-A-P, I can't remember what it's, R-A-P-E-S-H-U or P-E-S-U something, Rapesu. And there is the Manibinam that I have
Yes.
spoken to. Those are some of the three. But in terms of those that who were involved here, in actual fact, I have, if I can be assisted, there is the affidavit of Cedric Nkabile. Council, have you seen that affidavit? Cedric Nkabile? Sorry? 723. I'm going there because some of the names of the people who are currently, who were at IPID, that and part of the Patlanitas team are 723. Yes. Chair, when Cedric was disclosing what he disclosed before the committee, I knew about it long ago because he had deposed this affidavit in one of my applications. I was going to interdict the conduct of McBride and O'Sullivan, whatever was happening. I just want somewhere there's a list of me. 727. Okay. Yeah. Okay. I think it goes to, first it starts on, it's 727, page 727, 4.7 and 4.11. In 4.7, Nkabinde say, during the end of 2016 or beginning of 2017, I cannot recall the exact date or month, there was a meeting that took place at Mr. Paul O'Sullivan's house, the former house of well-known Radovan Krecha, whereby Mr. Paul O'Sullivan was chairing this meeting, and amongst other people present were Robert McBride, Mr. Mandla Gaise Mahlangu, Cedric Nkabinde, Sarah Jane Trent, Candice from Crime Intelligence, Mr. Shadrach Sibia, two white males representative, one from AfriForum and one from the DA, while white lady journalist and one black male who was busy preparing fire for the bride. This white lady journalist is Marian Tem. And the one black male who was busy preparing fire for Braai is Jacob Nari. Now, Jacob Nari is supposed to be a 204 witness in the Krecha matter that was placed under witness protection in London, state cost, no proper approvals obtained. When he came back, and that's how I know about it, when he came back, the then head of, you call it slush fund, the Secret Services account, approaches me. I'm now the accounting officer. and only the accounting officer signs off on the expenditure if it is on a certain level of the account. So he's saying to me, there is a witness called Jacob Nari, who is now returned from London. So he was approached by detectives to fund his stay here so that he can be placed in a safe house. And I refused. Unfortunately, the person was already in the country. I refused because that's not what the Secret Services account is being used for. If that person was a state witness, he was supposed to be funded through the Justice Witness Protection. So I refused. And then I could only approve the stay for a week. The reason why I approved that stay for a week was to say, ask them to follow the process and go and get witness protection funds, which they failed to do. And somewhere we will traverse that area later. O'Sullivan then boasts and say now he has got Jacob Nari in his house. So he is the fireman that was part of this particular meeting. Yes. But then I'm trying to answer Honorable James' question, 411. Okay, 411, the exchange of official information between IPID and Mr. O'Sullivan continued, and several meetings took place at IPID offices where Mr. Paul O'Sullivan and his assistant, Ms. Sarah Jane Trent, who will come and do presentation to the entire task team of Lieutenant General Phahlane's bank records and cellular phone data. The same representative from AfriForum was always present in these meetings. I can, for instance, recall on my presence at the last meeting I attended was towards the end of 2017, where Mr. Paul O'Sullivan, Ms. Sarah Jane Trent, and Ms. Teresa Buota presented to us their comparisons of the bank statements and cellular phone data of Lieutenant General Phahlane. The following persons of IPID were all present during the meeting: Mr. McBride, Mr. Kuba, Ms. Gibson, myself, not me, Mr. Mandla Mahlangu, Mr. Mancha Rapesu. That's the person Mancha Rapesu, Mr. Binang, Mr. Subrimani, Mr. Sias, and Mr. Govender. The majority of these people.
Stop it there is Honorable. Just put your finger on the paragraph where you were.
Sir, General, you mentioned that in that affidavit, I don't know if you have the details, you said there was a person from AfriForum and somebody from the DA. Am I correct? That is the Democratic Alliance?
You are correct, Honorable Member. Okay. But remember, I'm reading from Nkabinde's affidavit.
Okay.
I don't know who those people are.
Okay.
The ones that I know, I will list, like the Marian Tem. I know she was the person in the
Jacob Nar. Okay, so you don't have the names for AfriForum and DA,
member
all right.
and AfriForum's member.
Just to remind you, the witness had also forgotten, they were described the way they were described, that there was one from AfriForum and one from the DA, but he was not certain about their names. I have it on my notebook record here. Yeah.
Honorable, am I allowed to proceed, Chair?
You know, I want to check if Honorable Sangweni is satisfied.
No, I'm clarified, Chair, and I wasn't being facetious. Unfortunately, I missed the full testimony of Mr. Ngabinde. I was not here. Thank you, Chair.
Okay. Chair, just...
you were still on that part of those
Yes.
Those
I had,
people who were at the meeting.
Yes. Now, I know for a fact, I know Honorable Nkola, Ngola, sorry, sir. You were asking me who is in what is it? IDEC. Mr. Govender?
It was
Mr. Sears?
Honorable James.
Yeah, but earlier he wanted clarity on Mr. Binang when I was talking to ascertain whether it is the person. Honorable James wanted me to clarify the name. I think it was Rapeso. But all I'm saying is that Governor, Sias, Binang, Rapesu, and Sissoko, who's not here. He's not listed in this paragraph, but he's very integral here, are all currently in IDEC. I don't know this Suprimani, whether he's there or not, I'm not sure.
Honorable Skosana.
I just wanted to find out the names which you mentioned, General. There's Sinal. You said what's the surname? Sinal or Sunel or
Binang.
Pinang.
Binang. B-I-N-A-N-G.
Okay.
Binang.
Thank you.
Temani is his name.
Thank you, Chair.
Yeah. Okay. Okay. All right.
Let's do like this. Let's break for 15 minutes. We'll come back at 19 hours. I can see that the details that you now present are overwhelming to my members. So let's break. We'll come back at 19 hours. This is what we could have done when we started, but you were a bit defensive, rattled, and no, the terms of reference, forget about the human being and focus on the terms of reference. Advocate Arendse, and General Phahlane, welcome. Can we resume? We want to give the advocate time to lead you in your presentation. He has been quiet for over an hour. That's why I say over an hour. Yeah. So it's your time. Good luck.
But Honourable Chair, to be fair to the witness, if he wants to round off, he has for the past 2 hours been responding to a presentation made by IPID before the Portfolio Committee on the, I think, 14th or 16th of May 2017. Has been reading extensively from his affidavit, and not only the presentation he made in Parliament. I don't know whether he has concluded his response to that, because I'm obviously going to move on to something new, something different, new topic, although it's related. I know General Phahlane had promised to be quick after the last break that we had. But yeah.
Chair, I certainly, is it my turn? I definitely would want, if the opportunity is still there, to present, and for the chairperson and the honourable members' purposes, I'm way beyond what I just want to check that which alphabet are we on? No. I first on this topic it's E, ne? We are on F, and obviously F, it's a big issue for me, and because of the significance of F, that's why I spent a lot of time to deal with those allegations that I have already comprehensively dealt with in Parliament, and unfortunately they were just growing. Now in the affidavit, as I was going through of Nkabinde, you look at page 7 to 8. 412. Nkabinde say, the extreme measures and means employed in bringing Lieutenant General Phahlane down was that IPID will be to obtain information unlawfully and formalize it later. Should there be any personal information required, it will be given to Paul O'Sullivan's assistant, Sarah Jane Trent, who will obtain the information unlawfully from her contact in TransUnion without following the processes. Now, I also, a lot has been said about me. There is a book by Paul O'Sullivan, Stop Me If You Can. Now, I'm just going to make reference to some parts of this book. In page 283, it will make it clear that when we talk about the capture of the criminal justice system, And the control that Paul O'Sullivan wielded is not only with the IPID, but in SABS, as well as within the NPA. He's got obviously a well-decorated group within IDEC. General Mkhwanazi termed them the rogue unit. And I've got no reason not to agree with General Mkhwanazi. And I, somewhere in my statement, when I was interviewed, I said that rogue unit is led by Matthew Sissoko within the environment. Now, in Paul O'Sullivan's book, it's page 283. Just to show, you will see there is a picture. I know it's very far. Now, in this picture, it's him, Paul O'Sullivan. In the middle is an officer, a police officer in the Czech Republic, Prague. Next to him is, he was a colonel then, Brigadier Gininda, who's currently in the office of the National Commissioner heading the so-called cold case, cold case unit, the lead investigator in the Senzo Meyiwa case. That's him. But why am I bringing this to your attention? And that's not me who's writing, it's Mr. Paul O'Sullivan. In a complaint, Kotsia laid out her evidence against Munu by describing the strange decisions Munu made on the Krecha case while still the head of detectives. She described an overseas trip planned by Major General Daiwe, Lieutenant Colonel Gininda, and Advocate Kaba of the NPA to meet with Jacob Nari. Remember I mentioned Jacob Nari, who was taken to London as a witness, allegedly. He's a 204 protection. So they are now going there to meet with Jacob Nari, the Section 204, who was then based in London. The team also made an application to visit Prague in the Czech Republic after the London meeting to meet with a witness I believe was important to the Krecha cases. Mono denied the application for Prague leg of the trip. Now, firstly, Mono happens to be a lieutenant general, the divisional commissioner responsible for detectives. So if you want to know, he doesn't have authority to approve trips. He will recommend that the team of detectives is going there. His actions were deliberately detrimental to the case against Krecha, whom I believe he was trying to protect, and a prime example of the length he will go to in allegedly defeating the ends of justice. Now, this is important. I paid for Gininda and Kaba's trip to Prague, where I met with them and introduced them to the police there. During this time, Kotsie was in contact with an informer who told her that I will be murdered in a subsequent trip to Prague. She relayed this information to Colonel Gininda, who told her to draft an official letter addressed to me to warn me of the threat. Now, it's been concocted there. Gininda must write an official letter. She was then to forward the email to him, to Gininda, and he will sign it and send it to me from his office email address. Remember, he's there in Prague. Obviously, he's got access to his email and so on. Kotsie alerted me to the threat in an SMS and then blind carbon copied the letter to me, assuming it to be the final signed letter. I sent it to Prague, requesting police protection while there. He was asking protection to come here, to this committee. The authorities there contacted Interpol and got through to Munu. Munu denied the existence of the threat and told Colonel Gininda not to send the final signed letter. So that's the extent. Remember, this person, Nari, is a 204 witness. Where is the declaration of him paying the trip from London to Prague and back to London? Here, management knows of Gininda and Taiwe and the advocate Gaba having went to London. They don't know about the Prague trip. And in here, it is clear also from his thing that they knew that the Prague leg of the trip was not sanctioned. It happened. So, in this book, the famous Phahlane house is here. This, I think, was it one of the members, I forget. What did he do when he came to my house? And I think General Mkonazi, during his testimony, I can't remember whether it was here, he said he was surprised that years after my house was built, he has my house pictures from foundation as it progressed. He has those pictures, but here it is. There is something which I wanted. It's on page 17. Now, unfortunately, it also goes to what we refer to the media, third estate or fourth estate? Fourth estate. Refers to the fourth estate. When my family was safe, that's now O'Sullivan, I decided to ramp up the heat on Selebi. I decided to rein Selebi's 2007 Christmas by setting up an elaborate hoax. I contacted one of Selebi's police colleagues who did not like Selebi and told them that the DSO will be arresting Selebi at his home early the following morning. I also tipped off a few journalists. It was the only time I ever planted false data in the media. I received calls from 2 separate journalists asking me if I knew anything about an arrest warrant for Jackie Selebi. Of course, I knew one had been issued, but after the unlawful suspension of then National Director of Public Prosecutions, Vusi Bikoli, steps had been taken to cancel it. I told the journalist that I had also heard that something would happen early the next day at his house in Pretoria and that he will appear in court soon. The results were far better than I could have hoped for. That morning, at least 20 journalists were gathered outside Selebi's house and the police headquarters, with their long lenses hoping for a shot of Selebi being taken away in handcuffs. It had a tremendous effect. The crooked chief of police must have felt so exposed while he was wrung his hands with worry, wondering whether or not his arrest was imminent. May Commissioner Selebi's soul rest in peace. This comes in O'Sullivan's book. You have got a dedicated chapter, Phahlane, there it is. So, Honorable Chair, I did not come here solely to respond to what the issues that Nkabinde was raising, because there is much more. We spoke earlier about the lady Sarah Jane Trent, an attorney of the High Court. This person happens to be the same complainant in the Ms. Duduzile Zuma is it Sambudla? Yeah. She is the one who is the complainant there. Now, is it ethical for attorneys to be behaving in this manner. In here, I've got an elaborate, I think it's, and by the way, Chair, I'm triggered by the presentation or by the leading of evidence by my evidence leader to raise these things or to respond to these things. JKP 30, what page is it? JKP 30? 30, yeah. 544. I'm still on the Phahlane task team, Chair. I did not go ahead of the evidence leader. 544, JKP 30. I think it goes until it's long. I'm not going to go through. Yeah, it goes up to 600. It's from 544 to 600. These are WhatsApp messages extracted from Sarah Jane Trent's phone when she was arrested by the team that did the investigation, that Camille Drift 12 of 1, 2017. Now, in this, I'm just on page 545. In the middle there, you will see coming from Mandla, the late Mandla. He say, Ndlemesa should be next to be fired. Dash or dash DA. And there is, on 546, again, Mandla, because they are reporting to the masters, we are seeing Phahlane tomorrow. You maybe have questions for him. So it's Mandla asking Sergeant Trent. We are seeing Phahlane tomorrow. You'll recall I spoke about a call that I received from Nkabinde on the 22nd of November 2016, and the morning of 23 November 2016, when I received an SMS or a WhatsApp message from Peter Louis Meyberg, and the meeting which I was to honor with IPID that afternoon, I had rescheduled because of other commitments. So this WhatsApp, when you look at it, it was from Mandla to Sarah Jane Trent on the 22nd, and it was around 2:38. And this is around the same time that I received a call from Gavinde asking for a meeting, which I said, please talk to my office. Now, Sarah Jane replies to him, check with Paul, I think it's Mandla, check with Paul, please. Amazing, we'll send to you an email. So they will now go and formulate questions that must be, that I must answer. I must answer to O'Sullivan. There is just a lot in this, in this WhatsApp messages. By the way, here we only make visible that extract of what comes from Sarah Jane Trent's phone, and not the rest that was sourced following the approval of the Section 70 that I've referred to, including the recorded conversations. One of the things that happened here, Chair, was that The same threat assessment report by crime intelligence, McBride handed it to O'Sullivan. When O'Sullivan got to the office, he was celebrating that they have got the threat assessment. That is why in there, I think even in the presentation that the council was going through, he said he pretended that there was a threat assessment. What he did not know is that we have that threat assessment. In actual fact, the copy of the threat assessment is in this affidavit. If you could look for me, Johan, the threat assessment. There was also something I wanted to speak to. Sorry? What was it? 539, thank you. Don't blame yourself. Oh yeah, here it is. There is a threat assessment which was done by crime intelligence. It was declassified here by General Mutiba. 542, comments and recommendations. 4.1, the intelligence gathered clearly indicated that this action is spearheaded by Mr. Paul O'Sullivan and is using IPID as background players. There is the recommendation which led to the appointment of the General Mabula team. Now, when they were celebrating, whoever at Crime Intelligence handed this threat assessment to them would have told them that it doesn't exist. This is the only copy. So this threat assessment, the original thereof, is with Paul O'Sullivan. You won't find it in the records at CI.
Honorable Skosana.
Thank you, Chair. Yeah, I've seen so many names in this WhatsApp, and I guess, as you said earlier, that it will take a little bit of time. I think it's up to 5. You said up to 600. I've seen names, but you mentioned earlier when you had the book that there was a rock unit. I didn't get it well. When you say rock unit, were you saying rock unit in the police or at IDEC or at SARS?
Well, the one I know of, it was the Phahlane task team, which happens not to be in the police, but at IPID. That Phahlane task team has now been relocated. They are in IDEC. So that's the rogue unit that at least I can refer to. I know about the SARS rogue unit, I read about it, but no, I don't want to go there. This one in the space where I find myself in.
So, General, in other words, the names will get it later, perhaps, because we'll need those names as well.
No, Chair.
Besides this one, because I saw some names, the journalists, unless you say including them as well.
Yeah.
Yes.
We can do so. Those that I know.
Thank you, General. Thank you, Chair.
Okay. Bangazita.
Honorable Chairperson. Now, just a small question to the General, whether he also is aware that Mr. Nkabinde, when he appeared here, he also confirmed and attest to the existence of the Phahlane task team. Did you follow his evidence here?
I did, Chair, and it accords with his affidavit and the letters that he had presented to the Portfolio Committee of Police then and to the former Minister of Police. No, I'm aware, and that's why it is in a sworn statement coming from him, which I have access to. So, Chair, having said all this, I think I was just responding to IPID. There's an area which we need to traverse because it has got, the emails. And part of the reason why I'm under attack stemmed from those emails. So I did not hear the council talking to them.
Let's go back to
Yeah.
the senior counsel and hear how he wants to lead you.
General Phahlane, is it my turn now? You're aware that because you reference it in your affidavit, at paragraph 159 on page 70, you say it is important to note that following the arrest of Paul O'Sullivan, Sarah Trent, Jane Trent, and at a later date, the two IPID investigators, Tamani Binang and Mandla Mashlangu, the late Mandla Mashlangu. Mandla was murdered, wasn't he? You know that?
Yes, Mandla was killed.
And another case of defeating the ends of justice was registered by Nkabinde at Pretoria Central SAPS. This case was registered following the Portfolio Committee session held on 16 May, which is where I last spoke. I spoke about that meeting. That was the joint meeting between you and McBride.
Yes, sir.
And you were responding all along to that meeting.
Up to date.
So you reference that now in his, so the complainant was Nkabinde, and this is what he says in his affidavit, which was not placed before this committee, and he wasn't questioned about it when he gave his evidence. He says, and I'm paraphrasing, he's employed at IPID as the principal investigator attached to the National Investigative Task Team Head Office. I'm the complainant on behalf of the state in the case of defeating the ends of justice against the acting National Commissioner and others. I wish to state that during the approximate period between the 9th of November 2016 to the 10th of May 2017, our suspect in the corruption case, the acting National Commissioner, Lieutenant General Phahlane, he allegedly abused his powers by establishing a team from Northwest under the false pretenses of his security breach to counter our investigation and to interfere with our several witnesses in order for them to submit contradictory statements, which amounts to defeating the ends of justice. It is alleged that suspects are operating from Pretoria, where they summon all our witnesses and approach them to submit second statements which contradicts with their original statements submitted to the IPID investigators, which amounts to defeating the ends of justice. No one has the right to interfere with our witnesses to defeat the ends of justice. So that is what Mr. Nkabinde said. And he continued working at IPID until 2018, when there was an agreement to terminate his employment. And he then also subsequently submitted a report to then Minister Kele, which was placed before the Portfolio Committee, and where Nkabinde now had also made another affidavit, the one that you referred to and that you rely on. So those are the facts. It's not going to help us or me to debate this, but this is the person that we're dealing with, Nkabinde. as lead investigator for IPID. Almost 2 years later, in 2018, he changes his tune and he makes an affidavit in support of you, and he says that now McBride is the one who's abusing his authority. So that is also context, and I can leave it, and I want to leave it there. The fact of the matter, though,
No,
is...
but Chair, too many things must not be put to me. I must be allowed to
Phahlane, you
respond.
gave your evidence for more than almost 3 hours.
No, but you're introducing a new thing, and I must be allowed to talk to
No,
it.
I'm reading to you from your affidavit.
Let's do like this. Let's do like this. Advocate Arends and General Phahlane. I reminded you that this is a meeting of the Ad Hoc Committee. And this Ad Hoc Committee is made up of 11 members of Parliament. And the two of you are not members of Parliament. You can proceed.
Now, despite this visit, where it is alleged that, or you allege, you weren't there yourself when O'Sullivan and Ms. Trent was there with the IPID investigators. Is that right?
You're allowed to ask questions. I'll answer at a time where I've got an opportunity to do so. Because it looks like you were at my place. It looks like you know my place. And I really take offense, Chair. I have already traversed this issue, putting facts there. When I was asked about O'Sullivan and Mandla and Sarah Jane Trent being at my house, I think the honorable members ask here, I say, on that day, I was in Komhlanga. I said it here. I was in Komhlanga. I was launching the festive season campaign of the South African Police Service. I left Komhlanga and went to Limpopo. When I was in Limpopo, I got further calls. I don't know why must I be asked whether I was there. I was not there, and I placed it on
I
record.
don't know why you go on. You weren't there. I'm trying to establish a fact. Okay? I'm trying to establish a fact. The fact is that Trent was there, O'Sullivan was there, but other IPID officials, officers were also there. You don't know as a fact that O'Sullivan or Trent presented themselves to the security people at the gate or to people at your house that they are there as IPID members. They were accompanying IPID members. Now, another fact, a case was opened against them for impersonating IPID officers. Nothing has come, is it also a fact? Nothing has come of that case. They weren't prosecuted, certainly not successfully, and those allegations still hang in the air. So as a fact, it hasn't been established that they impersonated IPID officers. Or don't you accept that either?
Am I to respond? I'm asking, am I to respond now?
Yes, I'm putting it to you.
If you allow me, let me then
being
respond.
charged-
Thank you, sir. Thank you, Honorable Chair. I'm going to respond. I do not rely on hearsay. And I do not rely on narratives that are being peddled in the public domain that are uninformed. First, there is never a dispute that Nkabinde opened the cases. Under oath here, Nkabinde told you that this is what they were told to do. And having been told to do later, it's not before he opened the case, later his conscience troubled him. And it is on that basis that he deposed not this affidavit. There is an affidavit in the docket which you say never saw its day as a 204 witness. This is a different affidavit. He deposed the affidavit when he was opening case 123 of 11/2016. That's the defeating the ends of justice. I don't know whether you have it on your records. 2, he deposed an affidavit in this 534. Maybe this thing is giving feedback again, Chair. Can I move to this one?
The problem, the microphone may be part of the problem, not entirely. Both you and the microphone may be the problem. So, look, I want to request you not to be agitated.
No.
Just compose yourself, and then respond to the questions to the best of your ability.
Okay.
Remember when we started here, it was you who said we have gone through a marathon of consultations. And Chairperson, this time may not be adequate. I don't want to leave here. I don't want the committee to run through if I have to regurgitate the words that you used to run through my affidavit. I want to be given sufficient time and satisfy myself that justice has been due diligence. That is what you said. So we want to do that due diligence and just stay calm. Let me take Honorable Shonga. His hand is up.
Thank you, Chair. I just want to get a clarity on this narrative. The SC is trying to bring a narrative that says, or a question that says, what changed in Kabinde 2 years later? But at the same time, I'm taken back. When Kabinde was sitting there, he says, he deposited an affidavit, opened a case again, and at one stage when he was going for a hearing, McBride comes in that hearing. Then the status of the hearing changes, and then comes a settlement going forward. I would like to ask the General Phahlane here that in his thinking or in his own knowledge, what changed Kabinde's attitude, according to him? I just want to understand that, because from the essay I'm getting a different narrative, which makes sense. But I also want to understand because according to my understanding, Kabinde says somehow it didn't work for 5 years, and that was because of the power that those guys had, and he never got any help from either anybody. So that's why maybe it didn't continue with this thing. So I just want to understand that from the general's thinking. Thank you.
Thanks, Chair. The only thing I know why Nkabinde first this road to Parliament and to the ministers, I still remember his report is titled "The Unethical Conduct of the Executive Director, Robert McBride." I don't know what went into his head when he decided to go that route. Simply put, he was making a disclosure of the things that he said, I, Nkabinde, cannot be associated with. We were doing this for ulterior motives. He said it here before the committee. Now, I don't know why that question comes to me in a way from council.
No, General, don't question the question.
No, I'm answering, Chair.
Yeah.
Okay. let
If
me-
if the advocate asks you a question, you just respond to the question and don't attack the question.
So, am I allowed, Chair? His conscience is the only thing that I know bothered him. That's why he went and made the disclosures that he made. That's why even during the investigation by General Mabula, when he was approached, he, confessed and made a 204 statement that he had made to disclose whatever happened. It was later on that he deposed this affidavit that I have in here. Another affidavit that he deposed, that's why I say there are several affidavits that he did. First was the Camille Drift case 123 of 11/2017, the defeating the ends of justice. If you go and look at that docket, he is the one who deposed the affidavit to open that particular case. The second one is this 534 that I must now talk to because it's even in my affidavit. And I hear counsel talks about this 534. Me, I was never charged with case 534. The acting head, the acting divisional commissioner of crime intelligence was then charged on this case 534. The reason why they charged her, allegedly, they say when they were in the building, in the crime intelligence building, coming to obtain statements or interview witnesses, there was a lady, a white lady, I think either was a staff officer or a PA, I'm not sure. It is said, and I don't like hearsay, but that's what it is. It is said, General Machele, in closing the door, he kind of used a sign language which shows that that lady must not cooperate. She was arrested. The case went to court. She only appeared once. That case was struck off the roll because there was absolutely no basis for that particular case. Another thing in this 534 was the allegation that I appointed the Northwest people. And I say it in my affidavit, and it is there in General Mabula's affidavit, which is an annexure. It is there in Brigadier Nguve's affidavit, which shows who made those appointments. And I have testified to the effect that the appointment of General Mabula's team of detectives was by the acting divisional commissioner of crime intelligence after liaising with the provincial commissioner of the Northwest. But because there must always be Phahlane, I was targeted with this particular case. But that case, just like the one I'm told has never seen its day, this one has never seen its day in court, in as far as Phahlane is concerned, because he is not involved at all in this particular case.
Honorable Ngola and Honorable Matthys.
Thank you very much, Chair. I just want to appeal for fairness and consistency. We'll recall that the nature of the matters we are inquiring here are allegations that were taken to the public discourse. And Parliament is undergoing an inquisitorial process to get to the bottom of the matters. And we call witnesses here, Chair, on the basis of them assisting the work that we are doing as Parliament. And how we've been trying to extract information from the witnesses has never been that Gerald Mkwana, you say so and so went to this house. Give us the video of that visit. That General Spear, you met with Brown Mohodzi in Clifton. Give us the footage of that. We have always been acceptive of what the witnesses are said to us as they are willing to assist the process we're undergoing. And General Phahlane is on record here, almost the whole day, that I was not there. The security said this, this information and that. I think to a certain extent, Chair, although it is important to put a fact of law, but I think let's exercise restraint on aggression to that effect so that we're able to smoothly run the proceedings without having these altercations. Already now the proceedings of this day, Chair, are trending on the basis of an altercation between General Phahlane and Advocate Arendse. So I want to amplify your intervention, Chair, that they must
Both
tone
of
down.
them are not members of the National Assembly.
Exactly, Chair. That's exactly what I'm saying. That they must also assist their proceedings. And also, I think, let us be consistent and be fair to all the witnesses that appear before the committee. Thank you very much, Chair.
Honorable Matthys.
Thank you, Chair. Mine is just a follow-up question. Our senior counsel asked a question about whether we know for a fact that they were impersonating IPID members. So my question is, in your experience, General, is it common practice for non-IPID or non-SABS members to be accompanied by just citizens when they go in to do investigations? Is it something that is practiced both within the police, from what you understand? Because the line of questioning, even if they were not impersonating, the fact that they showed up, and we also have affidavits from various people confirming that they were there and they've sent SMSs. So I'd just like you to speak to that.
Even before you do that, through your chair, the complainant, is it a practice that the complainant can accompany IPID to go and investigate a person they are complaining about?
May I
Yes.
respond,
General Phahlane.
Honorable members, it is not allowed anyway. Investigations are done by investigating officers. You can't even take an informer to go to a place and say, I'm busy with investigation. It is not allowed. And in my affidavit, Chair, I have made reference to the IPID Act. Oh, sorry. I know. Sorry for being a problem to the mic, Chair. Now, it is not allowed. Not in the police, not in IPID, and I have specifically quoted the IPID Act. Imagine you are having a complainant who was assault GBH, it's assault with grievous bodily harm. This person is bleeding and so on. Now you still want to take that person to the crime scene, further traumatizing that particular person. Now, unfortunately, in this case, O'Sullivan, it was not read by me, it was read by counsel. Somewhere they say he was a complainant because they say they got a complaint from Pop Crew members and from Paul O'Sullivan. So that makes him a complainant if indeed there is a sworn statement of him in any of the dockets which I'm yet to find. Maybe at some point the NPA will disclose that. And then he now also is an investigating officer. In some cases he goes and writes, 205s or warrants for IPID. At some point, he's doing the analysis of cell phones and bank accounts and so on. It's found nowhere in the legal system.
We are reverting back to the senior counsel.
General Phahlane, I've also been in practice for a number of years, and I've also done my fair share of criminal matters. You've heard of pointing out in criminal matters.
Chair, I'm not going to respond to that one because it's an obvious thing in the police environment, in investigations.
And who does the pointing out? Witnesses. And how do they do it? They do it in the presence of the police. They do it in the presence of an investigating officer, especially a murder scene or where an offense was committed. In rape cases.
May you please get closer to the microphone? Yes.
So witnesses, no, not only witnesses, but complainants. It depends obviously on the nature. I think we can agree it depends on the nature of the complaint, the nature of the charge that's been laid. That complainants and witnesses routinely accompany the police or a detective investigating a matter to a particular crime scene or pointing out.
SC, Chair, I will unfortunately not respond to that question.
Okay, then we
because
can move on
I'm
if you don't want to
dealing
respond.
with the specific case here. Paul O'Sullivan at my place, Paul O'Sullivan being involved with IPID, Paul O'Sullivan being a complainant, an investigating officer, and everything else that is there. The justification of that conduct, the attack on me, which I must sit through and be told it sounds okay, I will never respond to it.
So here's a complainant. He is Paul O'Sullivan. He's not the investigator because the matter is being investigated by IPID. He goes and he goes with the IPID investigators to your place to show them this is your place. And they take photographs of your place. What is irregular about that? I submit to you that there's nothing irregular about it. It is quite normal. I don't hold the brief. Let me be very clear. I don't hold the brief for O'Sullivan.
No, I have suspicions. I truly have suspicions.
Yes, that is the
I
trend of
want
your evidence.
that
It's based
SC
on speculation
to show
and
me
suspicion.
one son affidavit in any of the dockets where Paul O'Sullivan is a complainant. One. I'm not asking for two. Show me one. Which case number?
Now, that is exactly the point, General Phahlane. You face a number of cases involving corruption, and I'm going to deal with it. And Mr. O'Sullivan is not the complainant. He's not a witness in those cases. This is a complete distraction in relation to those corruption charges that you are facing. It's not about O'Sullivan. It's about you.
Chair, I need protection, and I'm not going to respond to that, no matter how loud you ask that question.
I want us to do this.
If I may move on from there. I
No,
think I've made my
before you
point.
move on.
Yeah.
What we want in these proceedings, honorable members, what we want in these proceedings, we want an evidence leader and a witness. in these proceedings. That is what we want. An evidence leader and a witness. We don't want personalities. And I have said it many times, I thought you understood. When we say the honorable members of this National Assembly are sitting here very patiently so that you can help us for these meetings to proceed. And we don't make judgments in these proceedings, Senior Counsel. We don't make judgments. If we bring a witness here to come and accuse him or her, I don't think it's a fair statement to make, to say to the witness that this is not about Paul O'Sullivan, it's about you. That statement is misplaced. If there are questions that we want to put on General Phahlane for him to respond, or there are allegations of corruption against him, let's state the questions. You say, there is this allegation that you took 10 rand of the SAPS. What is your response? But to say to him that you are now trying to deflect attention from yourself to somebody is unfortunate. And I don't think the committee can agree to that. If there is any, and for sure, consciously you also understand that that statement does not belong here, because you even said it yourself that you don't hold a brief from O'Sullivan. Consciously or subconsciously, you understood that you said something that you were not supposed to have said. So I humbly request that if there are any allegations that we want to probe, allegations of corruption, let's state those matters and allow the general to respond as a belief. Honorable Skosan.
Thank you, Chair. Chair, I just wanted to make a follow-up question to the General. That when the IDEC and Paul O'Sullivan went to your house, because you got a call, as you articulated to us that you were in Wamhlanga and you went to Polokwane. Paul O'Sullivan, when he came to your house, he came as a complainant, or he came as we know now that he's in control of the IDEC and other state institutions in the security, like SAPS, IPID, and I think it's not disputable now. Now, you said it very clear that it's unusual that a complainant, I guess the police as well, if they get the address, they don't need Paul O'Sullivan to accompany them anyway. Now, in your experience, because as you said, you started many years ago as a police constable, up to the rank where you are before you set home. You still insist that it is not common for, in particular in your case, I don't want to deviate from your case, or Paul O'Sullivan went into your house for a particular reason. It was not about only taking pictures. It was about you, as he was boasted to say he has removed police commissioners in this country. What's your take on that?
Chair, I want to respond to that question by making reference to the IPID Act. And I'll answer it to the end. IPID Act, which is sitting on page 51 of my affidavit. paragraph 1172, but I'm going to go straight to 2, which is there on page 51. A person appointed as an investigator must have at least a grade 12 certificate or a relevant diploma or degree. B, say must have knowledge and relevant experience of criminal investigation or any other relevant experience. 3, say any person may not be appointed as an investigator unless information with respect to that person has been gathered in an appropriate security screening investigation as prescribed by the minister. The security screening investigation contemplated in subsection 3 must be done in conjunction with the National Intelligence Agency as referred to in section 3 of the Intelligence Services Act of 2002. 5, say the executive director or official so delegated by him or her must issue a security screening certificate in respect of such person, wherein it is satisfied that such a person has successfully undergone a security clearance and is appointed as an investigator in terms of this act. If Mr. Paul O'Sullivan has got a security clearance, that makes him an investigating officer. For a moment, forget that he's a complainant. But now you know that he has been investigating me, or he is the boss of IPID and IDEC when they do investigations. I have testified, and there are affidavits to that effect. I went through Brigadier Ngube's affidavit, who was the investigating officer in the matter. I went through extracts of what the witnesses are saying. And these witnesses are saying, Paul O'Sullivan and Sarah Jane Trent were taking statements from them. That's what the statements are saying. If we forget for a moment that he's not an investigating officer, if there is justification that when you do pointing out, blah, 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 you bring people, what kind of a pointing out is being done by somebody who purports to be a complainant and that person takes statements? I have testified to that effect. Now, of course, Chair, people have the right to accuse me, but let's go to court, whoever has got anything that they're accusing me of. And when I'm being told about the so-called corruption, I'm speaking to those issues in here.
Yeah, no,
we are still going there.
It's fine. Let's come back to the game. Advocate Arendse, you can proceed.
Yes, I want to be very specific. The two issues I want to speak to, the one is Kabinde, because he also gave evidence here. And the other one is this so-called security threat. I'm reading to you. It's clear that we're not going to finish, by the way. So this affidavit will be made available to you. This is an affidavit from a Lieutenant Colonel FHC Kruger, or Krier. I don't know if you know this person. Franz Hendrik Christian Kruger states under oath, I'm a Lieutenant Colonel in the African Police Service, stationed at Crime Intelligence Head Office. Additional to my previous statement that he made on the 2nd of November, the following. Regarding paragraph 5 of my previous statement, I was informed that Paul O'Sullivan was with the members of IPID who visited the Sable Hill complex, that's your place, regarding an investigation against Lieutenant General Phahlane. I never recommended any further investigation into the quote-unquote security breach tasking we received. I was informed by a source that SAPS members from Northwest Province visited Sable Hill Complex just after we left and before we even submitted the report. This is an affidavit which is dated and signed on the 24th of November 2017. This is shortly after this visit to your place. So that's the first issue. The other issue relates to Nkabinde. Again, a document you would be familiar with because it's your case that you brought. This is in the matter of, in the Gauteng High Court, Johannes Khomotso Phahlane, case number 8258/17, 2017. Phahlane versus Executive Director, Independent Police Investigative Directorate. First respondent, Paul O'Sullivan. Second respondent, Sarah Jane Trent. Third respondent, the Magistrate J.R. Nsatsi, nomine officio. Fourth respondent. I'm reading to you from a supplementary affidavit of Robert John McBride, where he says at paragraph 3, I've read Phahlane's supplementary affidavit, which was deposed to on 21 August 2018, and the supporting affidavit of a former IPID investigator, Mr. Cedric Nkabinde, deposed to on the 24th of July 2018. I respond to both here under. The heading is the alleged quote-unquote new information about IPID's investigation of Phahlane. Phahlane contends in paragraphs 8.7 to 8.13 of his supplementary affidavit that quote-unquote new information has emerged that quote-unquote corroborates his case, that IPID's investigation against him is, and then he puts it in quotation mark, an orchestrated effort from the side of the Executive Director, Mr. Robert McBride, to undermine me and to destroy my career in full collaboration with the second and third respondents in this matter. The quote-unquote new information that Phahlane has produced is in Nkabinde's affidavit, which contains extravagant and utterly false allegations about me and IPID's National Task Team for Special Investigation, hereinafter referred to as a task team, which is charged with investigating Phahlane amongst others. Nkabinde purports to detail the quote-unquote ongoing unethical conduct in IPID's investigation of Phahlane, including, for instance, that it is quote-unquote spearheaded by Mr. O'Sullivan, that I personally instructed the task team to, quote, damage the image of General Phahlane in order for him not to be confirmed as the permanent National Commissioner, close quotes, that IPID's investigation against Phahlane is part of an elaborate plot, quote, to usurp the power of the entire security cluster, unquote. These allegations and most others in Nkabinde's affidavits are pure fabrications. No evidentiary weight or credibility can, I submit, be attached to the affidavit. My denial of Nkabinde's allegations is substantiated below and is supported by statements made under oath from members of the IPID task team who have personal knowledge of the facts. The context in which Nkabinde's affidavit was produced is also crucial in appreciating its lack of veracity and credibility. Nkabinde produced the affidavit shortly after disciplinary measures were taken against him at IPID. Those disciplinary measures were taken after I learned that Nkabinde was approached by SAPS members seeking to obstruct IPID's investigation against Phahlane, but had failed to disclose this fact when called upon to do so. From what has transpired, it is evident that Nkabinde was indeed persuaded to assist Phahlane to obstruct and undermine IPID's investigation against him. If there has been any calculated, quote, orchestration, unquote, in this matter, it is between Phahlane and Nkabinde. Phahlane attests that on or about 24 July 2018, his attorneys were contacted by Nkabinde's attorneys and furnished with Mr. Nkabinde's affidavit, quote, for possible use in the pending litigation, unquote. It is clear from its heading and contents that Nkabinde's affidavit was drafted specifically to serve as a supporting affidavit for Phahlane in this application. Nkabinde is no longer employed by IPID. He was placed on precautionary suspension on 4 June 2018, whereupon IPID commenced disciplinary proceedings against him. Kabinde's disciplinary hearing was scheduled to commence on 19 September 2018, but the parties reached a settlement on that day. Under the settlement, Nkabinde agreed to resign from IPID. Nkabinde also formally withdrew his complaints against IPID. I attach a copy of the settlement agreement and refer to paragraph 4, which reads, the employee forthwith withdraws all of his complaints and any statements related to those complaints, and the protected under the Labour Relations Act and the Protected Disclosures Act. Without limiting the generality of the foregoing, the employee hereby withdraws his complaints to the public protector, any complaints to any ministers, parliament, or any of his referrals against the employer whilst in the employ of the employer to any forum, including any bargaining council, and undertakes to inform the said forums no later than 21 September 2018 to furnish proof to the employer thereof by 21 September 2018. If he fails to do so, the employer shall have the right to inform the said forums of this agreement. Nkabinde has therefore retracted his complaints against IPID and has agreed that this should be conveyed to the relevant authorities. Against this background, I proceed to detail the facts of Nkabinde's departure from IPID. I then address the main allegation in Nkabinde's affidavit on which Phahlane relies. In support of what is stated here, I attach sworn statements from members of IPID's task team, which were obtained in response to Nkabinde's letter to the Minister of Police. That's the one to Minister Phahlane of 28 April 2018. The allegations made in that letter are now repeated in Nkabinde's affidavit. The sworn statements are from the following IPID members: Matthew Sissoko, the National Head of Investigations at IPID and Head of the task team; Ambulani Innocent Kuba, Chief Director and Provincial Head of IPID, Limpopo, and Project Manager of the task team; Mandlakayisi Mashlangu, Principal Investigator of the task team; Mansha Rapetsu, a Principal Investigator on the task team; Abram Tamani Binang, a Principal Investigator of the task team; Ms. Teresa Botha, Deputy Director and Member of the task team. Then he says that I also attach sworn statements from members of SAPS and other persons named in Nkabinde who all deny his allegations. Brigadier Bamuza Petty, P-H-E-T-H-E, a member of the SAPS technical team; Ms. Candice Kutsi, a member of the SAPS Crime Intelligence Division; Gladwin Mafuna, an intelligence officer employed by the State Security Agency, who is seconded to IPID as a VIP protection officer to the Executive Director; Petro Heineke, Forensic Liaison Manager at Vodacom; Brigadier Shlungwani, a member of the SAPS Crime Intelligence; Brigadier Dumusani Chili, member of South African Crime Intelligence Division. Then he deals with Nkabinde's departure from IPID. In 2016, Nkabinde, who was then a principal investigator, was appointed as a member of the task team that I established to investigate the then acting National Commissioner Phahlane. During or about mid-March 2018, I learned that certain members of SAPS, including Brigadier Khomo and General Mkwanazi from SAPS Crime Intelligence, had approached members of IPID's task team, including Mr. Nkabinde, promising them a promotion in SAPS Crime Intelligence if they agreed to give false statements implicating me and other senior IPID members involved in investigating Phahlane. On 16 April 2018, I convened a meeting with the members of the task team to deal with the unlawful approaches that had been made by SAPS. At this meeting, I asked members of the task team to disclose whether any member of SAPS had made unlawful offers that would compromise IPID's members. Mr. Mashlangu raised his hand and confirmed that he had been so approached. Mr. Nkabinde did not disclose that he had been approached. In a separate meeting, Mr. Mashlangu advised me and Mr. Sissoko that he had also spoken to Nkabinde about the approach from SAP's crime intelligence. Mr. Mashlangu advised us that Nkabinde had told him that he had also been approached by SAP's crime intelligence and had said that he would prefer to work for SAPS because he did not feel appreciated at IPID. He refers to the sworn statement of Mr. Mashlangu, and he also then refers to the sworn statement of Brigadier Pamuza Pete of the SAPS Technical Unit. She says, quote, Mr. Nkabinde had also informed me that General Ngobo promised him a brigadier post in return to bring Mr. McBride down. Mr. Nkabinde would always be giving contradictory information. Now I know it was because he made up stories. On 23 April 2018, Mr. Sissoko sent a letter to Nkabinde advising him that information at IPID's disposal indicated he had been approached by members of SAPS with a view to giving information about IPID's investigations and management. Then he attaches a copy of the letter. Mr. Sissoko stated he had decided to release Nkabinde from the task team until the Phahlane investigation was concluded. 4 days later, Nkabinde addressed a letter to the Minister of Police dated 28 April. In this letter, Nkabinde leveled the same allegations of unethical conduct against me and other persons that appear in his affidavit. Then he attaches Nkabinde's letter. On 25 May, Mrs. Pabaiki Maharaj notified Nkabinde of IPID's intention to suspend him on 4 June 2018. He was placed under precautionary suspension. Upon being suspended, Nkabinde claimed that I had committed an occupational detriment in contravention of the Protected Disclosures Act by placing him on precautionary suspension in response to his letter to the Minister. The claim was disputed and it was denied that Nkabinde made any disclosures to the Minister in good faith. Nkabinde's hearing was scheduled to convene on 19 to 21 September 2018. At the commencement of the hearing, Nkabinde approached me and proposed to settle the dispute by resigning, in return for which IPID would withdraw the disciplinary inquiry and all related charges against him. In addition, Nkabinde instructed his legal representatives to confirm his proposal in writing. And then he deals at length, he says Nkabinde's allegations are false. He deals with it paragraph by paragraph, and he explains that all the material allegations are false and are clearly contrived to undermine me and IPID's investigation against Phahlane. We will make this affidavit available to you and your legal team, and you can deal with it. So what I do want to ask General Phahlane is, this case of yours, what was the outcome?
Which case?
Sorry, maybe I can give you the answer. It's in your affidavit. Thank you, Maria. At paragraph 219 on page 89, another issue that excited both Messrs. McBride and O'Sullivan was my alleged acquisition of a music system through corrupt means, as referenced by Mr. Poe in his book. In the matter pending before court under case number 8258, it's the same case, 2017, I have a next compelling evidence to prove that I paid for the music system from my personal Nedbank bank account.
Is it my turn to respond?
Yes, please. I asked what was the outcome? Was this case ever concluded? Was there a judgment, or did you withdraw the case or abandon the case?
Honorable Chair, honorable members, firstly, that which was read now was never disclosed here to me. Earlier, I was showing there is what was referred to as an evidence file, which was disclosed just before we commenced this session. I had not went through it. Just as I said, the documents in there are not necessarily foreign. I know them. That is my case. But let me now respond to that issues. I'm not narrowly going to respond to what is the outcome of the case, because allegations are being made here. I go back to my affidavit, page 73. One of the things that was mentioned, it's a Kruger. I don't know who Kruger is, but Chair, just for the benefit of the members, when you talk about the kennel, you talk about the deputy director. So up there, the director general, who happens to be the national commissioner, is a general. That's a level 16. Then you come down, lieutenant general. That's all these deputy national commissioners, provincial commissioners, and divisional commissioners. Deputy director generals, lieutenant general. So from national commissioner, that's the first level. You move there, you come to major general. That's a chief director, level 14. From there, you move to brigadier, which is director in the public service, level 13. That's where SMS, members of senior management services, start, not only in the police, but in the public sector. A colonel, I was just hearing a colonel Kruger. I'm not sure whether it's a lieutenant colonel or a colonel. If it is a full colonel, that's a salary level 12, deputy director in the public service. If it is an assistant director, who will also be a colonel because it's a lieutenant colonel, that's an assistant director level 10. So now I hear there is a Kruger. At the time, I happened to be the acting national commissioner. I am not the divisional commissioner, crime intelligence. The divisional commissioner, crime intelligence, at the time, was an acting divisional commissioner. It's Major General Mahele. Under her command would have been other major generals and a brigadier. There is here, JKP 30, a threat assessment. Actually, JKP 29, sorry. If you look at that, sorry? 539. But there is reference also.
What's it? J?
No, 29. It is also on 74. It's on page 74. And here it is as JKP 29. This threat assessment is signed by the section commander counterintelligence, which means that person is responsible for threat assessment, Colonel S.H. Heine. The next person, Brigadier T. Moyane. Moyane writes in this, his comment is, this is a serious breach of the security of the acting national commissioner and need a criminal case to be investigated on the matter. This must be conducted as soon as possible. So, I don't know where Kruger fits. And why must I be responding to a Kruger that I've not even seen? That's the first thing. Now, I'm going back to the affidavit. Honorable Chair, for the sake of me explaining to the committee. Council referred to Nkabinde's affidavit. I've went through that particular affidavit. What is it, JKP? Affidavit of Nkabinde. Now, Nkabinde happened to have been here before this committee. He happened to have spoken about, what made him to leave, what were the circumstances, and all that. I'm definitely the wrong person to speak on behalf of Nkabinde. I can only talk to what is under oath from him, which is contained in the affidavit that I dealt with earlier. "173 of my affidavit, that's paragraph on page 74. Upon the conclusion of the threat assessment, the acting divisional commissioner, crime intelligence, requested the provincial commissioner Northwest to avail an investigation team to investigate the security threat on me. I had no role in the appointment. I don't know how Kruger looks like, what his responsibilities are. I am not the manager who micromanages. And if Kruger had a view, which he expressed in the affidavit that I haven't seen, that is now being tabled here before the committee, I really have little to do with that affidavit. I think Mr. Kruger is better positioned. Which threat assessment did he conduct? Because here is the threat assessment based on which a criminal investigation was conducted, following which a case was opened and people appeared in court. Now, I did hear, it seems as if there is a story around that case. Mr. McBride never assured me that any investigation into my alleged misconduct or corruption will be legally and ethically conducted. Instead, a desperate Robert McBride directed that a case of defeating the ends of justice against me be registered on the 21st of November 2016 under Camille Drift case 123-11-2016. The actions of Robert McBride in this defied logic, and thus the NPA declined to prosecute. That's the first case that Nkabinde opened. I have testified to this effect, but it's been repeated. Mr. O'Sullivan, that's paragraph 175. Mr. O'Sullivan is purportedly a private investigator, not employed by IPID in terms of Section 22 of the IPID Act. It boggles my mind why a complainant registered a complaint against me. At the same time, the very same complainant becomes a key person in leading and assisting the investigations, in leading the investigators in performing their statutory investigative duties against me. Worse, he has the nerve to impersonate an IPID investigator together with an admitted attorney of the High Court of South Africa, Sergeant Trent, in terms of which provision of the IPID Act or policy was Mr. O'Sullivan and Ms. Trent allowed to play the role he played or is playing in my investigation by IPID. I annexed here too instant messages, WhatsApp, between Mandla and Sarah Jane Trent, extracted from the latter's cell phone, seized during her arrest. For ease of reference, I annexed here too, marked JKP 30. If attaching them and maybe just referencing to one or two things is not enough, let me go through all of them. It is inconceivable why Mr. McBride, as the accounting officer of IPID at the time, dismally failed to ensure that any investigation against me was carried out in terms of the provisions of the IPID Act and regulations. There is nothing special about me. If there are any allegations against me, just as there will be allegations against any ordinary South African, they need to be investigated. But I do think there's something wrong if the conduct of McBride and O'Sullivan and the Phahlane task team is to be condoned. I wonder why the minister did not terminate this task team. Maybe he forgot because they never told me about it. It should have been immediately terminated. Someone must ask how much money was used by these people. They continue to refer to the to the team that led the investigation of 4 or 5 people from the Northwest, General Mabula, as the Northwest team. The Phahlane task team was comprised of people from Limpopo, Eastern Cape, KwaZulu-Natal, Gauteng, Free State, and wherever else, including the Honorable Mr. Paul O'Sullivan. I have never, in the past 9 years since January 2016, endured vicious attack and an onslaught on my character, integrity, and family from Paul O'Sullivan at the behest of Robert McBride. This included senior managers in the South African Police Service who are in cahoots and are beneficiaries of this well-orchestrated destructive program of action. In memory of the late Commissioner Selebi and my colleague and friend Lieutenant General Sean Chabalala, I'm resolute and continue to walk tall in the face of the storm unleashed against me. I refuse to sell my soul. There is no way I would have sold the South African Police Service and handed it to a foreigner, Paul O'Sullivan, for his own interest. If that is a crime, I will go to jail for it. Chair, in dealing with this, what was put to me, on 179, paragraph 179, on the 31st of January 2016 at 12:16 p.m., I received the first of over 80 emails from Paul O'Sullivan. I wish those emails are not withheld from the members of this honorable house. They must be shared. A foreigner in my life who I cannot be associated with. The email with subject, criminals under your command, in brief read, Dear Sir, Pierre was clearly a criminal in that she unlawfully and intentionally tipped Munu off that he was under the spotlight for corruption and more serious crime of defeating the ends of justice by protecting crime syndicates and kingpins. He's saying so because Mono was not supporting his agenda in the Krecha matter. She flatly refused to suspend him or take any action against him whatsoever, despite mountains of evidence that he is corrupt. This email is attached as JKP 31, being a message from Paul O'Sullivan. 180, the first email received from Paul O'Sullivan on 31 January was followed by 6 others, with the last one at 9:18 p.m. That is on the same date. I mean, that first one came 12:16 p.m. The last one on that date came 0918. The email with the subject Munu received at 0313 p.m. had lines that reads, we also attach a copy of our letter addressed to her predecessor and know that she did not even give us a courtesy of a reply. In the absence of any response from you, our client will take unilateral action in the public interest aimed at preventing criminalization of the South African Police Service. That email is attached as JKP2. On 3 February 2016 at 11:49 p.m., I received an email with the subject Mono damage control needed now from O'Sullivan, which amongst others read, if you did not take action against Munu now, I will shift my focus like I did to Pierre last year. I have started a process already which will leave you all reeling from what I have uncovered. I mean reeling. I will prove beyond reasonable doubt that Monu is a gangster protected by the hierarchy of the police. Take action before the weekend or see the application launched next week and the systematic corruption exposed. That email is JKP 33. On 5th February 2016 at 11 p.m., an email received, amongst others, read.
Let's do it like this, and I think those 3 emails that you have alerted to, we can take them as a sample and say,
okay,
the rest of the emails are up to page so and so in my, because you can imagine if we are going to sit here, you take us through every email.
Well, Chair, in actual fact, I'm not taking you through the 80 emails, but those emails, I have made them available. One reason why I made the 80 plus emails there is because some of the members of this house are in those particular emails. So I hope that they are being made accessible.
It's fine. Let me take Honorable Nwala and Honorable Sabu. You know, you must not frighten my members.
Thank you very much, Chair.
There is none of you honorable members who are in those emails.
Thank you very much, Chair. Chair, I think I'm getting a different angle from what I initially believed was happening. One would have initially thought that the alleged visit by Mr. O'Sullivan and IPID officials was a clandestine operation, a plot, and all those things. Now, I want to check with General Phahlane. Are you saying, is it your evidence that when this visit happened to the estate where you lived, the IPID officials were conducting an official investigation on behalf of the state?
Allegedly so, because remember I say there was a so-called affidavit, and I see council has got access to some of this. I don't think I included it here, but I know it is in those 80 emails because at some point he sent it to me, which mentions all other people, and then I'm one of the people that are being thrown in there because somewhere he will call me a Zupta person. So I'll be linked to the former president and everyone, people like the former minister Gigaba and so on will be in there. We are a whole list in that particular affidavit. And there is a wide range of issues that are being raised, including SAA issues with the late Medudu Muyeni and so on. So that's the kind, that affidavit is, if it is an affidavit, it's long. So it is based on that the former acting executive director of IPID, Isaac Khamanyani, once he received that email, which, by the way, the email did not point to me, it did not come as a complaint about me. He then appointed the investigators. One of them was Brigadier Khomo. There was, I think there were 2 or 3 people that he appointed. They then went to O'Sullivan to obtain a statement because now he was starting to zooming on me. He never deposed that affidavit, which made that investigation not possible. It is that which McBride took from the IPID members, Brigadier Khomo and so on. And after removing them, he now establishes the IPID, the Phahlane task team. So these people that are now coming with O'Sullivan to the estate are now the members of the Phahlane task team, accompanied by O'Sullivan and Sarah Jane Trent. At that point, there is no case opened against me. The only case that surfaces, remember I say McBride came to office 18 October 2016. The only case that was opened, the very first case, is the 21st of November 2016 by Nkabinde. That is that defeating the ends of justice case. So those guys, I take it that they would have taken over now from Brigadier Khomo, and now they are coming with the so-called complainant slash whatever to come and do investigation. So I won't say they were not busy with an official investigation because it is within their mandate to investigate any such.
Okay, let's assume the worst and say it was not a boys' trip. It was an official investigation.
Yeah.
As an experienced police official, is it legally permissible for private individuals to actively partake in an official investigation and the work of IPID when there is a complaint? And also, to what extent do complainants get involved in the investigation of IPID? Let's say I'm a complainant. To what extent do I get involved in the investigation against the person that which has been complained against? Thank you.
Chair, while I was never in my life an IPID investigator, and I don't wish to be one, I have at least visited the IPID Act, which tells me that that which was happening was illegal. It is for that reason I even, in responding to earlier, I said, anyone who has got a security clearance of Paul O'Sullivan must show me, because then it will only be after he passed his security clearance that maybe he could have been appointed. I'm not sure how old it is, at least how old he is. At least in the police, there is a cutoff age of recruits. So, based on my experience and based on the law, it is not permissible. It is not permissible.
Honorable Sangon.
Thank you very much, Chair. General Phahlane, I'm a bit confused. Maybe just help us with the chronological order. I mean, I've gone through this, the statement, the affidavit, and I'm still confused. These emails that Paul O'Sullivan sends to you, is it before or after these concoctions of complaints? When did your problems with Paul O'Sullivan start? Which comes first? So is the visit to your house, the investigation, as a result of the fact that you did not do what he said you would do, remove Munu and all of that? Can you just take us through how that plays out? Thanks. I'm sorry, I just missed it. Thanks.
Thanks, Chair. Thanks, honorable members. What started first were the emails. January 2016. I was returning from leave. That festive season, we had one of the greatest policing operations where zero crime was committed because of the deployment and the approach that we have adopted. So I took few days in January as a break. When I returned to office, I think it would have been in the second week. I first received a WhatsApp message on my phone. I say, I'm Paul O'Sullivan. May you please provide me with your email address? So I know I've been in the service even when Commissioner Selebi went through what he went through. And I said, this is not the character that I'm going to be associating with. I never responded to that SMS. 2 weeks down the line, as you would have noted, I say the first emails, I received them 31st of January 2016. That's when I started receiving emails. Somebody, or he was able to get my email from wherever. And the crux of it, he's saying to me, I must suspend General Munu. I must have General Munu dismissed. I must have him sent to prison. So somewhere, something tells me, but no one can direct me to do so. If you have got a complaint, register a complaint, go to the police station, register, let it be investigated. If there is criminality by General Munu, he will be dealt with. Even if you go to IPID, he will be dealt with. But simply to come to me and say, arrest him, dismiss him. And by the way, I just hope my team assist me here. There are 2 affidavits, one by McBride, the other one by Paul O'Sullivan himself, where he is withdrawing a case that he had opened against General Munu. So the strange thing to me is, when I only see this later, that you are saying to me, I must arrest this person, but the case that you opened against him, you have withdrawn it. In that withdrawal, there is a lack of a better word, a testimonial by McBride.
Sorry, General, I'm going to stop you because we're running out of time. Okay. But everything that then happened subsequently, it happened when you did not. So this was him fulfilling his threats. Is that your testimony?
This, starting January, remember I said the cases started coming after October, after McBride returned to office. And then it escalated from there onwards.
Thank you so much. SC.
Thank you. But General Phahlane, you don't tell the committee, because I'm going to take you to it, perhaps not this evening, but when we reschedule your next hearing, that these cases involving corruption have been brought against you and that they are in court.
Which cases?
I'll deal with it because I don't want to be distracted. Let me refer to, you can flag it, I'm not going to duck it. Let me refer you to the annexure you referred the committee to on what's it, 29, JKF, on page 539 to 540. This is the information report on which you rely. The report, 539.
539.
Annexure, your annexure 29. This is a report of possible security breach. Acting National Commissioner Lieutenant General Phahlane. Purposes to inform the head counterintelligence, security intelligence head office with regard to the outcome of the intelligence gathered action conducted at Stable Hill Estate. Introduction and background, and then if I can just take you to page 543, these are the comments and recommendations. Comments and recommendations, the intelligence gathered clearly indicated that this action...
Oh, okay. 4.4,
yes,
okay. I was looking for it. Yeah.
The intelligence gathered indicated clearly that this action is spearheaded by Mr. Paul O'Sullivan, and he is using IPID as background players. Your further instruction in this regard is awaited. There's no comment or recommendation that this constitutes a security threat. In fact, if you go to the comments of what is it called, the report right on page 541, they interviewed a Mr. Jooste. Jooste is the estate manager. They interviewed Mr. Jooste, the estate manager, and the security manager, Fruk van der Walt. This is on the 9th of November 2016. Fruk van der Walt was contacted by security personnel at the service gate entrance of Savory Hill Estate and informed that there are police officials who want to enter the premises. Van der Walt referred them to the main gate, where one official identified himself as a member of IPID and informed him that they are busy with an investigation against Lieutenant General Phahlane. They were driving a white Ford Kuga with registration number so-and-so. It's registered in the name of O'Sullivan. Mr. Van der Walt escorted them to the estate manager. They introduced themselves as Paul, Sarah, and Mr. Mashlangu, who handed Mr. Jooste a business card. Mr. O'Sullivan informed Mr. Jooste that they are investigating allegations regarding defeating the ends of justice against Lieutenant General Phahlane and need the file regarding the plans of Stand 53 Sable Hills, where Lieutenant General Phahlane is residing. Mr. Jooste refused, and Mr. Sullivan explained to him that he could be arrested for refusing to assist a police investigation, and they will serve a notice to produce evidence. Mr. Jooste let them take cellular phone pictures of the plans of the house. Sullivan requested the name of the building contractor. Then on the 13th of November, Jooste received an email from O'Sullivan, whereby O'Sullivan requested him not to disclose any information regarding the investigation to anybody. On the 13th of November, he received another email from O'Sullivan, whereby Jooste was requested to send another picture of the first floor plan of General Phahlane's house, as the picture they took was fuzzy. He also requested full-size drawings. On the 16th of November, Mr. Jooste received a call from Lieutenant General Phahlane, who requested him not to give any documentation pertaining him or his residence to any investigators. Lieutenant General Phahlane also instructed the security manager to block any person who wants to go to his house without consulting with him first. On the 18th of November, Paul O'Sullivan and Mr. Mashlangu met with Mr. Jooste and handed him a notice to produce evidence. Mr. Jooste also gave Mr. Mashlangu a sworn statement in this regard. Now, comments from the writer. Mr. Jooste indicated that Paul O'Sullivan never indicated to him that he is not a police official. Due to Paul O'Sullivan's body language and attitude, he believed that O'Sullivan was a police official. He also mentioned that O'Sullivan made sure that he saw the firearm that he was carrying. Jooste only realized that O'Sullivan was not a police official when Lieutenant General Phahlane informed him. Mr. Jooste also mentioned an incident that took place at the estate on the 15th of October, when a resident of the estate, Mr. Johan Olivier, and driver was refused access to the estate because he didn't have the necessary documentation. Mr. Olivier lost his temper and ran down the boom at the estate. Brigadier Phahlane, wife of Lieutenant General Phahlane, had him arrested by the bodyguards of Lieutenant General Phahlane, but the charges against Olivier was withdrawn. He was fined 20,000 rand by the homeowners. After the media coverage of the allegations against Lieutenant General Phahlane, Mr. Jooste alleged that Mr. Olivier boasted, and made remarks that he is the one who gave information to Paul O'Sullivan. According to Mr. Olivier, he is receiving all the information from Lieutenant General Phahlane's daughter, who is sending the photos and information to his son. They are attending the same school. Mr. Jooste also indicated a picture of Lieutenant General Phahlane's house, which he saw in the media, was taken from the front of Lieutenant General's house. Photos of the back of the house can be taken from the main road outside the security. And then those comments and the recommendation which I read to you. There's nothing in this official report which indicates that this constitutes a security threat.
Chair, I know I'm not an honorable member, but
No, Chair, just before the General.
Honorable Malema, Honorable Skosana.
General, where they were making you to read comments and recommendations, down there, there is a comment that is handwritten. Can you please read it aloud for me?
thanks, Honorable Malema. I actually read this earlier because this is my
No,
evidence.
in this context, can you read it again?
So, this is a serious breach of the security of the acting national commissioner and need a criminal case to be investigated on the matter. This must be conducted as soon as possible.
So how is that not a security threat on a senior police officer? How is that not read to be a security threat on a police officer? Is that not a way of saying there is a threat on the life of the acting national police commissioner? Is that your understanding? Because that's my understanding.
That's exactly my understanding, and I'm being told I'm relying on it. I did not have to rely on this document because in the first place, it's not addressed to me. And the investigation that was done, the criminal investigation, is informed by this report. That's why I earlier said, I don't know. It was for that reason that I said there's Lieutenant General, blah, 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 you get to a kennel. I was told about a kennel Kruger here that I don't even know. But here is the report, which council selectively reads and exclude the comments which are in there to the person that it was addressed to, because this thing is addressed to the acting head, counter and security intelligence, crime intelligence, and to the section commander, counter intelligence investigations, crime intelligence. So it is there.
No, Chair, I raised this issue because it was deliberately left out, but there's a comment which I wanted to bring to your attention, which the SC made to the General, that there are cases, and the General asked the question, which cases, and he said, I'm going to come back later on those issues, maybe on another day, leaving that dark cloud hanging. Because if he had a case to raise, that there's a case opened against the General, you can't make a sweeping statement like that and leave it. The second point I want to register is that his attitude against the General is so bad. It's not of a person who's leading evidence. It's of a person who's interrogating the witness. And I don't know how he gets to be addressed about that, because as a chair, I think at some point you have to intervene. Because we have never seen this. Repeatedly, we have had to remind them that they are not members of parliament. We are members of parliament. And then General responds to the attitude of our leader of evidence. I've never seen him do anything like that to any witness that came before us here. We might have issues with General. If we have issues, let's raise them in a professional manner and not in a manner that we invite a person to come and help us here and get to humiliate him in a manner he's being humiliated. He's just being very kind. If it was me on the other side, this thing would have stopped long time ago.
Honorable Skosana.
Thank you, Chair. I guess I don't have to ask our evidence leader. I'll ask the General Phahlane. Though it would be unfair for me to ask that, because I was waiting for the evidence leader. Because when he opened, he said, General Phahlane did not disclose that there's cases against him. Now, after I think we started on page, I'm still waiting. I think the evidence leader read 3 pages. I'm still lost. I'm still waiting for those cases which he said is going to read to the general. Maybe I didn't hear him well, but I think that's what he said. The general, I'm not sure whether you concur with me on that.
Well, Chair, if I'm to respond, I don't know which other cases he's referring to, but in my affidavit, I traversed the issue of the blue lights.
General, are you undergoing any criminal trial currently?
Yeah, that's what I'm responding to. And I want for...
That is the simple question that these honorable members are asking. Are you before any court?
Chair, I'm not going to just go that yes or no. I'm explaining. I'm saying yes, but I don't know which other cases is he talking of, because if you go to P in my affidavit, procurement of blue lights, Gauteng Province, Hillbrow Crest, 789. I'm referring to it there. Somewhere, I think, towards the end of the affidavit, I'm dealing with a matter that relates to the crime intelligence case, which is on the procurement of the, software. It's here. I'm dealing with it. So I can't answer on behalf of council, and I can't be. Maybe let me use a polite word. I'm talking here it is as part of from where I'm talking about crime intelligence, the Secret Services account. If you go into that matter somewhere, I'm talking about it. I think paragraph 331.4, which is on page 151 of my affidavit. I'm speaking to that. So I don't know which other cases that are known by council, and if they are there, bring them on. Let's go to court. Bring witnesses, whether it's O'Sullivan or who. Let's go to court. This is not the platform to ventilate those. Thank you, Chair.
Yeah, there is one of your colleagues who came here. We asked him about the phrase "bring it on." It's like it's like bring it on is very common in the police service.
It's close to immediate. Bring it on.
No. Honorable Shonga.
Yes, Chair, just a quick one. I don't know whether, Chair, I'm new in Parliament, you know, so I might be making a mistake. Am I allowed to ask the senior advocate, or should I ask you a question?
You can't question the advocate.
Did General and SC meet? Seems like this
they
statement.
they did consult.
They did. Okay. No, thank you.
But in this report where Honorable Malema made you to read the last part, which is the recommendation, is it a two or 3 page report? Because my concern is
4-page, Chair.
in that report, there is one person whose name is mentioned many times more than any other names. And I had thought that the names that will appear often in that report will be the names of the SAPS officials. But very strangely, it is the name of Mr. Paul O'Sullivan that dominates the paragraphs. Who wrote that report?
Honorable Chair, this report is written by Division Crime Intelligence. In
The person
particular-
who was writing the report or that unit is an SAPS unit.
It's an SAPS unit.
And it is not reporting about itself, it is reporting about an individual outside the SAPS.
It is what it is. Colonel Haine and Brigadier Tom Moyani, or Brigadier Moyani, are the ones who drafted this report.
And the report confirms that this citizen was part of those operations.
The foreigner.
Whether it's a foreign citizen or what, but this report confirms that he was part of these police operations.
It does, Chair, because
That he was even there at your house and everything.
4.1, which
Yes.
Council read, say the intelligence gathered clearly indicate that the action is spearheaded by Mr. Paul O'Sullivan and is using IPID as background players.
No, I just wanted to confirm that. Remember, part of our terms of reference is to investigate interference by members of the public in the affairs of the SAPS. And when you have your own officers writing a report, but mentioning Lekhanyane many times in their report, then they would mention themselves as SAPS officers. It's very, very concerning. Honorable members, it is 5 minutes past 21 hours. And I'm at a point where I think we should proceed. No? No. Let's do this. Like we said when we started, that the committee is going to have a meeting on Monday. We haven't scheduled appearances on Monday. We will have a committee meeting to discuss our matters, and we will reallocate a day or whatever number of days we decide on for your reappearance, General Phahlane. But in the period between now and the date of your reappearance, yourself and the evidence leader, you need to get closer to each other. The observation of the honorable members is correct that we were very rusty today. We were very rusty. Our rhythm might have been affected by the Christmas break. So when we come back for your reappearance, you must have dealt with these issues with the legal team, so that we have a smooth cruise in our work. SC, can I check if you have any comments that you want to make before we close?
Thank you, Honourable Chair. Just in relation to the issue raised by Honourable Malema, What I was referencing was that the officers, the intelligence or counter-intelligence officers, who were tasked by the head, Motiba, to conduct the investigation and whether or not there was a threat. They did not find. You're right, and perhaps I was not fair to read the handwritten, but because General Motiba then records that this is a serious threat. He is not the one who conducted. I was referring to the officers who conducted the investigation and reported to him. And the head of intelligence then concluded, yes, it does constitute a threat. So I don't have an issue, and there was no intention to mislead. And if there was, then I apologize. Otherwise, yes, Chair, we agreed that we'll hold over, I think you said, will it be on Monday? And we will make further attempts with General Phahlane and his legal team to try and streamline the proceedings as best we can.
The next date of appearance is not Monday.
Oh.
Monday is the date for a committee meeting, which will decide, will look at the schedule and make a decision when the next appearance will be. General Phahlane.
Chair, we must make it very clear that it's going to be virtual if we want it to work on Monday. It has to be virtual.
You mean the committee meeting?
Our committee meeting. Yeah.
No, the committee meeting will be virtual. This is a very hectic year. We need to afford you the time that you need. Yeah, your hand was up.
Sorry, Chair, I just want to correct. It's not General Motiba wrote no report.
Yeah.
General Motiba wrote no report.
No, General. Look, we said that you and the evidence leader.
No, but Chair, how do I live here creating the impression that there is something that General Motiba did, which is not correct? All I'm correcting is that General Motiba never wrote any report. General Motiba never worked in crime intelligence, only in his capacity as an acting national commissioner. He declassified
when you say
the document.
never wrote any report, what do you mean?
I'm
Because
referring to-
you must be specific.
All
Because
right.
if you say never wrote any report,
All right, Chair.
he can also call us and say, but I once wrote a report about the same.
No, he's more competent.
Yeah.
No, General Motiba never wrote a security threat
Thank you.
assessment report. His signature there is only for declassification purposes as an accounting officer. Thank you, Chair.
Okay. You want to say something, Advocate Arensa?
Talking about his handwritten comments. Those are his comments, but he never wrote the report.
Do you agree with the last statement, General Phahlane?
No, Chair, it's too late. At least I'm not yet a senior citizen.
Do you agree with
Thank
that
you,
last?
I don't agree with it because the handwritten comments are Brigadier Moyane. General Motiba only signed at the bottom in declassifying the document.
Okay. Advocate Arense? Okay. No, thank you so much, honorable members. When tomorrow? Yeah. What time? Okay. The honorable members are, there is acclamation for 11 o'clock tomorrow. Let's start at 11 o'clock tomorrow. And Bonani is announcing that as we leave, honorable members may use this exit. Thank you so much. Let's leave tomorrow. Let's meet tomorrow at 11.